Good morning, ladies and gentlemen. At this time, I'd like to call to order the December meeting of the Tennessee Real Estate Commission. And I think we'll start, I'll have to look at the agenda. Do you want to give your announcement before we get started, call the roll, and then get going? Okay.
This year's date, time, and location have been noticed on the Tennessee Real Estate Commission's website, included as a part of this year's meeting calendar since August the 9th of 2013. Additionally, the agenda for this month's meeting has been posted on the Tenn Real Estate Commission's website since Wednesday, November 26, 2014. This meeting has been noticed on the tenn.gov website since Wednesday, November 26 of 2014. Now I'll call the roll. Grease.
Here.
DeChara.
Here.
Alexander.
Here.
Bloom.
Here.
Collins.
Here.
Franks.
Here.
Hills.
Here.
McMullen, absent.
All right, we have a quorum. We can proceed. At this time, I'd ask for everyone in the room to stand. Commissioner Bloom will lead us in a prayer and then the pledge to the flag.
Let's pray. For the blessing of life and for the freedoms that we enjoy in this country, for our health, for the business that you allow us to conduct in this industry, and for the opportunities we have for discussion about that industry today. We give you thanks. We pray for wisdom in our deliberations, and at this particular time of year, we're thankful for friends and family and for your love for us. In Jesus' name we pray. Amen. I pledge allegiance
to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
This time, I'd like to remind everyone to turn their cell phone off.
What's a fine for that?
Do as I say, not as I do.
No, I'm turning mine off. I was thinking about that just as the prayer was going on, how thankful I was my phone wasn't going off. And lo and behold. All right, for participants in the meeting today and tomorrow, just a couple of notes on the schedule. We're going to break for lunch at about 11:30 this morning and reconvene about 1:30 this afternoon. So we have a Christmas party for the employees, or Christmas luncheon, so we'll have a 2-hour break at lunch. We have a whole slew of hearings, not formal. What are we calling these things?
Informal applicant appearance.
No, not those. This afternoon. What do we do?
Yeah, the legal report.
We have a long legal report this afternoon. We'll stay in this place until we get that done, which could take some time. Okay, so if you guys are trying to plan your schedule for today, don't book anything at 4 or 4:30 at this point. We just don't know when we'll be done. Depends on the amount of discussion we have. Tomorrow morning at 9 o'clock, we have a formal hearing. There will be a court reporter. There will be an administrative law judge, attorneys hearing a case. We'd like for you all to be here on time for that. And again, there's no telling how long that will take. It could be fairly short. It could be fairly lengthy. We don't know the nature of the case at this point. We just know we've got a formal hearing tomorrow. So I think those are my announcements right now. Let's move on with the agenda and see if there's a motion to adopt today's agenda.
So moved.
Is there a second? A second by Commissioner Collins. Ms. Franks.
I'd like to make a amendment to the agenda that we add Robin Ryan after the informal appearances, please.
Is there a second to that amendment? Seconded by Commissioner Collins. So the motion on the floor at this point is to adopt the agenda with the addition of Robin Ryan appearing following informal appearances this morning. Any discussion on the motion? Let's vote. Those in favor of the motion vote aye.
Aye.
Those opposed, no. The agenda is adopted.
Oh, Mr. Chairman,
Mr.
I'd
Bloom.
also like to add, if possible, if we have time, for comments or thoughts from the commission on the rulemaking hearing.
All right, or an update at the very least.
Right.
Could you include that in your report, Eve? Or I mean, we're looking for the transcripts from the hearing. Are those in?
No, we don't have those back yet, I believe she told us it would be by the end of this week, correct? End of today.
We could have them tomorrow, perhaps?
It's possible.
Don't want to overcommit or anything, I understand.
Oh,
Yeah, but let's, at the appropriate time, we'll bring it back up again.
Could they email them to us?
say that we would have them by the end of the week. I don't know if we should say tomorrow because it's kind of, yeah.
My sense was that you guys were going to review them and compile the comments so that they're a little easier for us to
Right,
focus
match
on.
everything up, so it'll be easier for you guys.
Right.
Yes.
Yes.
All right, the next item on the agenda is to approve the November minutes. Thank you, Commissioner. Is there a motion?
Motion to approve the minutes.
Second.
All right, there's a motion on the floor to approve the November minutes. It's properly seconded by Commissioner Franks after being made by Commissioner DeChara. Is there discussion on the motion? Any additions or corrections? Let's vote. All in favor of the motion, vote aye.
Aye.
Those opposed, no. That motion passes unanimously. All right, education reports next. Ms. Maxwell?
The next, do you have the timed agenda up there?
I've got this lunch afternoon
Oh, you don't
take.
have the
I don't have the morning. Are
We
we
only
going to
have the
informal
second sheet.
applicants next?
Yeah,
I have one.
here's
I
one.
may have one. I haven't looked.
You have the first page.
Okay, thank you.
Yeah, I have the first page, not the second page. John has the second page and not the first.
All right, thank you. Let's check and see if Jamie Baker and Lydia Pennington are present. Ladies, if you would come up and sit in these,
Or they can sit in front if they want, that's,
uh,
they can sit.
okay, take those two front seats right there. I just want to make sure we can hear you, so if you'll split a microphone some way or get close to a microphone. Don't have to sit that close together. If you both
You
want a
can
microphone.
use that one's fine. We just want to be able to hear you.
Great.
All right. What is it, ladies?
I was just telling Keeling that she'd need to swear them in, and so we were just reviewing what she was gonna say.
I've never actually sworn anyone in before, so.
Well, now's your opportunity.
We'll put this on your resume, December.
Exactly.
Yeah, go ahead.
It's, do you promise to tell the truth, the whole truth, and nothing but the truth?
I'm going to just go over a little bit of the information that Ms. Baker had sent in that's been sent to the commissioners previously, and then you'll get an opportunity to say, whatever additional information you would like to say. The applicant for licensure as an affiliate broker is Jamie Marie Baker, and her principal broker today is Linda Jordan Pennington, who is the principal broker of the Dream Team Green Hills LLC, doing business as Keller Williams Realty. Ms. Pennington is the principal broker of this firm located in Nashville, Tennessee. Ms. Pennington was first licensed as an affiliate 4/7 of 2000 and was first licensed as a broker on 10/12/2004. Prior to becoming the principal broker for the Dream Team Green Hills LLC, DBA Keller Williams Realty on 6/10 of 2013, Ms. Pennington was a principal broker or a broker at several firms in the Nashville area. The track records indicate that the firm was first licensed 1/7 of 2005 and currently has 166 affiliate brokers and 13 brokers. The track records reflect that Ms. Pennington has had no disciplinary action taken against her by the commission. The applicant, Jamie Marie Baker, has completed the 60-hour pre-license course and completed the 30-hour course for new affiliates. She has taken and passed the affiliate broker exams and submitted all the required paperwork pursuant to TCA 6213-303. Ms. Baker's application for affiliate broker licensure is ready to complete if the commission approves her to move forward with the licensure process. Along with her application, Ms. Baker submitted an application for decision regarding prior criminal convictions, and she stated that she pled guilty to one count of theft under $500, which is a misdemeanor, in the General Sessions Criminal Court of Davidson County, and that was on 1/26 of 1999. She received a 6-month suspended sentence, which she served on probation. She also disclosed that she pled guilty to one count of theft under $500, a misdemeanor, in the General Sessions Court of Rutherford County on 2/11 of 2002. 2011. 2/11/2011. Ms. Baker received a suspended sentence of 11/29, which she served on probation. Ms. Baker also disclosed that she had a count assault on an officer, which is a misdemeanor, in the General Sessions Court of Wilson County, and that occurred on 1/7/2010. She received a sentence of 11/29 at 50%, all of which was suspended, but 30 days. On 11/14/2005, Ms. Baker had one count simple assault, which was a misdemeanor in the General Sessions Court of Davidson County. She received a suspended sentence of 11/29. And on 1/31/2007, she had one count casual exchange and misdemeanor in the Court of General Sessions of Davidson County. She had two counts DUI, both misdemeanors, in the Court of General Sessions of Davidson County, one on 4/25/2012 and one on 7/5/2012. She received a sentence of 11 months, 29 days for each of these convictions. On one, she served 45 days in jail and 48 hours on the other. Ms. Baker has had other traffic convictions for driving on a revoked license and for violation of probation enumerated above in the enumerated above convictions, but those involve the payment of costs and fines. One of Ms. Baker's convictions for theft under $500 involved a compressor which Ms. Baker had rented for use on a residential roofing job for which she was acting as a subcontractor. Ms. Baker stated that the check of the general contractor bounced, so the checks to her crew bounced. Ms. Baker's crew then took the compressor and said they would return it when they got paid. Because Ms. Baker did not return the compressor to the rental company, criminal theft charges were filed, and she pled guilty to theft under $500. Ultimately, the compressor was returned. The other theft under $500 involved a shoplifting incident. In regard to the assault on an officer, Ms. Baker stated that she was inebriated when arrested, but bit the police officer when she perceived that he touched her in an offensive manner. The police officer stated in his report that he was attempting to buckle Ms. Baker's seatbelt. Ms. Baker said the casual exchange conviction occurred during the time she was smoking marijuana to ease the side effects of cancer treatments. Ms. Baker stated that the two DUI convictions and arrests, two of which happened within 1 week, convinced her that she needed to turn her life around. While serving time in jail for one of the DUI convictions, Ms. Baker enrolled in and completed NAAA class and found the Lord. After her release from jail, Ms. Baker completed the Davidson County Sheriff's Office Intensive Outpatient A&D program on 8/13/2013. Ms. Baker states that she has been clean and sober for over 2 years and has been able to move forward from the abuse which she suffered as a child and young adult, which she discussed in detail in the statement which was sent to the commissioners earlier. Ms. Baker states that all of her encounters with law enforcement were related to her earlier abuse of alcohol. And I'll let her add whatever other information she would like to add.
So, which is Miss Baker? Okay, didn't want to make any assumptions here at all. All right, well, you heard the summary of what Miss Maxwell read. What would you like to add to or correct in that statement? Now, I need you for you talking to the microphone. Just pull that around.
Ma'am.
There you go.
Everything she said is basically what I've written in on my statements. I had an abusive relationship growing up with my father and my grandfather, and I had an abusive relationship with my ex-husband. I know that's not something to blame it on, but it was very mental to me and emotional. I did find the Lord. I have a wonderful man in my life now. I have turned around. I live in Green Hills. I'm doing amazing now, and I'd just like a second chance. My kids, my daughter, the baby is 17. My boyfriend really don't even want me to work, but I'm just doing this because I would like to do it, because I want to be able to prove to myself that I can do and be who I want to be. And I have a wonderful broker that's standing behind me. Wonderful family now. My mother just recently passed away, and we just buried her last week. I know how strong I am now. I have fought the cancer, I beat the cancer, and I fought the alcoholism, and I beat the alcoholism, and I just would like a second chance.
Any questions for Ms. Baker, members of the commission? We may.
Is there anything that you're doing that's involved in the community or at your church, or how has your life changed in the last 2 years?
I go to church 3 times a week. Thursdays, Wednesdays, and Sundays. I've actually got my father involved in going to church with me now. He's just a total wreck, and the Lord's helping him as well. I really haven't done too much in the community because I've been taking care of my mother for the past 2 years. She was really sick. So I really hadn't been able to add too much to the community, but I have been going to church, going to NA and AA meetings as well. I was going about 3 times a week, but I hadn't been this week because, like I said, I just got back from Texas.
You go to rehab?
Yes, ma'am.
I'm sorry about your mother, too.
Thank you.
That's all I have.
Other questions? Ms. Hills?
Ms. Baker, and what, I noticed that the broker said when she completed the form that she had to complete, that she had known you about a week. What drove you to choose that company, that broker?
Actually, when I was in class, I did the class twice because I didn't feel like I had got enough out of the class the first time to be able to pass it. So even before taking the test, I went and did the class a second time. And when I was there, one of the young ladies that worked for her came in and she was handing out some stuff to the people, just introducing them to real estate and to Keller Williams. And prior to her coming, there was another lady that came saying that she was from Keller Williams. And the lady, she told a lot of people she was going to bring them lunch. And there was a lot of older people there and that drove 2 to 3 hours just to get to the class. And they were farmers, real sweet people. And she promised them lunch. They didn't bring their lunch one day because she promised it, and I bought them lunch. And I was discussing to this lady what the other lady had done. And she was like, you know what, that's wrong. And she actually stayed in contact with me and let me know, that she contacted her broker and things like that. That let me know that they do care, that they're not just out there just trying to get people in their office to get them money, that they actually support their agents.
Bloom?
Yes, I'm not familiar with casual exchange, and then your identification of that is while you were smoking marijuana. What does casual exchange mean?
I was rolling a joint.
Pardon me?
I was rolling a joint.
Oh, okay.
You know what that is, Mr. Bloom?
I do know what
Okay.
that is. I just have one other comment. I love to give people a second chance. There's not a person up here who hadn't been a beneficiary of a second chance, including me. My problem is 2005, 2007, 2010, 2011, 2012. For me, there's just not enough time from 2012 to where we are today, 2014. I believe everything you're telling me. I don't have any denial that you've turned things around, but I think my responsibility is to look out for people who are entering this industry, and for me, there's just not enough time there, and I'm sorry.
Ms. Baker, do you have your driver's license now?
Yes, sir.
Okay. When did you get that?
Actually, I got it 7 months ago, 8 months ago. It was $25,000 total to get it back, and my boyfriend actually helped me pay it.
Who did you have to pay $25,000 to?
To the state for all the tickets and the court costs and everything. They weren't allowing me to get my driver's license until I had everything paid off. Court fines, probation fines, anything and everything that had to do with the court I had to pay off.
Thank you. Other questions? We may reserve the right to come back and ask you additional questions. Okay. All right, Ms. Pennington, what's attracted you to this potential applicant?
Well, again, we're talking about second chances, and I was hesitant, to be honest with you, and especially listening to what Ms. Maxwell read, and it's a scary thing to think that we could be in that position, and any of us, by the grace of God, we're sitting where we are, and I grew up in a wonderful background, didn't have the issues that Jamie has, and if she's awarded a license, and I say that awarded a license because I think that we all have a responsibility we're protecting the public, and I tell my agents over and over and over again that it's not about me, it's about the client, and what can I do to help them reach their home goals, their life goals, as in buying property. And Jamie stuck out in that she is intent on bettering her life. She's got a long list of mistakes, a long list, and you know, it's a gut feeling. And when the young lady that met Jamie first, she was so excited that she was going to be able to help a young woman turn her life around. And I know that Jamie's on the path. I don't know that she's, only time will tell if she's really there or not. And if she's awarded a license, I'll work very closely with her to make sure she stays on that path. But again, that's her call to make. And it's just the determination that she showed me.
Commissioner Alexander.
Pennington, you're the principal broker. How many teams does you have in your company?
Teams?
Yeah.
Our office, I believe we have 6.
6 teams.
Mm-hmm.
Which team is Ms. Baker going to be on?
We have a lot of individual agents. She won't be on a team.
Won't be on a team.
Our teams run on an individual basis, and then we have a lot of single traditional agents.
Gonna pay her money to? Who y'all gonna pay her money to? How's she gonna get her cut?
Well, she's going to go out and sell real estate like the average individual agent. Mm-hmm.
Thought it was a pyramid.
Questions for Ms. Pennington? Yeah. Mr. Collins.
With your other teams, how do you disperse commission on that? To the individual agent or to the team?
Individual agent.
The team doesn't get remunerated for anything.
No, as a real estate agent, we can only pay the individual agent, and the commission is, we have on a team, and we have teams that have several agents on it. We have a team that only has 2, and it's basically the individual agents that work on a team. They, for lack of a better term, they get a referral, and that's all it is. Everybody works on an individual basis. That's the way it's set up, but they work within a team and have a little more structure and focus on an area of their expertise, as in a buyer's agent or a selling agent, and have more communication with a team individual that oversees that team within our office. But there really is no difference than a traditional agent. They're all required to do exactly the same thing, and they function underneath the general rules of real estate, and we pay them individually as the instructions that we're given.
Maxwell, how is this company registered with the?
How's it registered?
Ma'am.
Its license is issued in Dream Team Green Hills LLC, DBA Keller Williams Realty.
If I could clarify a little bit, the way Keller Williams works, we're a traditional real estate company. There's nothing unusual about us. There's groups of agents who share information, and they still are under the same regulations as everybody else in a traditional company. It sounds a little different, but it's really not. They all are required to do exactly the same thing that I've worked with any other company. They associate with different groups. That's the only difference.
And Ms. Pennington, do you write the checks out of your escrow account? Or do you have somebody else to write it?
I have an administrator who does that.
Do you review those things before they go out? Every one of them?
We have, as you can well tell, we have a large, we can close anywhere from 150 to 200 deals a month. And so do I look at those physically no, I do not.
How do you take care of your escrow account without looking at each of those, if you're responsible for it?
I oversee the compliance of a file, and they don't get paid unless the file is complete and is compliant.
With 179 agents, how will you be able to give Ms. Baker the time and training that she will need?
I conduct contract classes once a week, and I teach other classes during the week as needed. I have a team, and I use that word loosely, but we have several people in our office that share information and mentor, and so I have access to people that I respect and are in close contact with, that I know their strengths that would be able to mentor her.
You look at every contract and listing that comes through your office? Who takes care of those?
I have an assistant who looks at, I pick and choose and make sure he's on track.
And is that person licensed?
No.
All I have.
Ms. Hills?
And when teams form or develop in your location, how do they, would Ms. Baker be invited by a team to join a team, or she could decide to have her own team? How does that work?
She can form her own team. There's a chance that she would be invited when a team has a position that they feel they're lacking in their availability to serve their clients. They interview, just like any other company, that they're needing a specific type of person on that team. And she has the opportunity to, if her business gets going, she has the opportunity to ask someone to join her team. I'm lacking in this area. Would you like to partner, if you will, with me, and so we can better service my database in my area of clients?
I did, Diane. Okay, we'll get. So, Ms. Pennington and any other brokers we get up here, we like to ask questions because we've found different levels of knowledge of what goes on inside their own firm on occasion, and so I hope you don't take this personally. For instance, on signage, do your people advertise as the Dream Team Green Hills, or do they advertise as Keller Williams Realty?
Keller Williams.
So they don't go KW, they go Keller Williams, right?
The criteria, what we look at is that Keller Williams allows us to use the KW logo as well as the name Keller Williams and Keller Williams Realty, and that's the criteria.
Well, from the state's criteria, we don't allow you to use the KW logo as your only identification. I'm not preaching, but
sure.
It's one or the other. How you're registered or the DBA. So, if for instance you had signs or agents who advertise and just put KW up there, you'd agree that's in violation. Okay, I just want to make sure we're clear on that. And Ms. Baker, I'm sorry we got a little sidetracked on this. This really is about you, but we don't get a chance very often to talk to principal brokers. When we do, we appreciate that opportunity. Diane, did you have one more question?
Ms. Baker, please. The outpatient A&D program.
Drug and alcohol. It's outpatient. It's an intensive 90-day program. It consists of you getting a book. You stay there for 8 hours a day. You learn what you have to learn. I actually completed my book ahead of time. I was really interested in it. So you just go there and you sit and you listen and you learn about what happens to you. And I learned what everything was doing to me.
Alexander?
I am inclined to be like Commissioner Bloom. I've looked at this, I've looked, moving around in different counties and rested. I don't believe she's ready.
Oh.
I've listened to the principal broker. She tells us she doesn't have time to see after all of this. She tells us that she's not going to be on the team. She's going to be working by herself, and my motion will be against the vote.
All right, we may have other discussion, but there's a motion that's been introduced to deny this application. Is there a second to that motion?
What's the motion? I didn't hear it.
I thought you made it.
No,
I thought you said you're gonna,
I'm gonna vote against it, but I'm not even gonna make the motion.
oh, okay. Well, I'm sorry, I misunderstood.
Well, I did too.
Are there other questions for either party before the chair entertains the motion? All right, if not, is there a motion?
I'd move to deny the application.
Is there a second to that motion?
I second that motion.
All right, the motion on the floor is to deny the application. Is there discussion on the motion? Would anyone care for a roll call vote? All right, let's roll call it. If you vote yes, your vote is to deny the application. If you vote no, it's not to approve it, it's just to vote against the motion that's on the floor.
Start out with the A's.
I said, if you vote.
Start out with the A's, is that what you said? Then can I go in the order I have it
Top
here?
of the alphabet.
Alexander,
Yes.
Bloom,
Yes.
Collins, DeChara,
No.
Hill, Franks,
Yes.
Hills. Yes. Grease.
Oh,
4 yes, 3 no.
all right,
call
the
it?
motion passes, and I with no malice, but at this point, this commission is not ready to let you move forward with your license. We
Can I
do
ask a
wish you the best.
question? When would be the next time that would be appropriate for her to try to, 6 months, okay.
And I'd like to make a comment. I think,
Let me make sure we get that answer.
Okay.
6 months, I think is the answer we got from staff. Okay.
I think, Ms. Baker, that I would have felt more leniency if you were with a smaller company and with a broker that would have lots of time to spend with you. So, and nothing against Ms. Pennington, they have a wonderful, but as a principal broker, with that many agents, I know she has such a big job, and you might consider if there were a smaller company where someone could give you more help and guidance.
If I did that, would I be able to come back before the 6 months if I found another broker?
Say what, before 6 months?
The rule is 6
I'd
months.
say with the attitude of this commission, it wouldn't move you much good.
Well, if we've got a rule, we've got to go by. And these ladies are legal counsel over here. I'm sorry I didn't introduce them, but Ms. Baird, do you want to speak into that microphone for the record?
Yes, it says in our rules that an applicant who appears before the commission requesting licensure and who is denied will not be eligible for reconsideration for 6 months from the date of denial.
Oh,
You really need a mentor or somebody that can work closely with you in helping you achieve this
agree.
goal.
but we applaud how far you've come. We feel sorry for you and your family over your mother's loss, and hopefully you'll have a good holiday season. Thank you both for coming down. All right, next on our agenda is an informal application or applicant, Robert Hudson and Kurt Steckel. Gentlemen, are you here? Gentlemen, if you come forward, take the same 2 seats that were just vacated. They seem to work out good. Thank you for being here. Just for the record, who's Robert Hudson?
I am.
Okay, Mr. Hudson and Mr. Steckel, is that how you say your name?
Steckel, yes, sir.
Thank you. Okay.
Which one's the preacher? Which one? Did it say reverend?
No.
Oh, no.
They may be. If you want somebody to preach, maybe we can break somebody out.
That finds the Lord somewhere.
Ms. Maxwell, would you give us an overview?
She's got
Wait,
swear in.
first.
Oh, Ms. Baird, please
Can you
swear in.
raise your right hand, please?
Gentlemen, both of you, please.
Do you swear to tell the truth, the whole truth, and nothing but the truth?
The applicant is Robert Edward Hudson, who is seeking to move forward in the process to obtain an affiliate broker license. His principal broker with him today is Kurt Steckel, and he is the principal broker of the Dream Team Franklin LLC, DBA Keller Williams Realty. Mr. Steckel His firm is located in Franklin, Tennessee, and he was first licensed as an affiliate broker in 1984 and was licensed as a broker on 8/10 of 1987 and has been the principal broker at the Dream Team Franklin since 6/8 of 2009. The track records indicate that the firm was first licensed, as I say, 6/5 of 2003 and currently has 171 affiliate brokers and 16 brokers. The records reflect that Mr. Steckel has had no disciplinary action taken against him by the Commission. The applicant, Robert Edward Hudson, has completed the 60-hour pre-license course and has completed the 30-hour course for new affiliates. He has also taken and passed the affiliate broker exams and submitted all of the required paperwork under TCA 62-13-303. His licensure is ready to complete once he is approved or if he is approved by the Commission. Mr. Hudson submitted an application for decision regarding prior criminal convictions at the time of his application and stated that he pled guilty to one count of aggravated robbery, which is a Class B felony, in the Criminal Court of Davidson County, Tennessee, Judicial District 20, Division 1, on 9/29 of 1990. Mr. Hudson received a 10-year sentence at 30% with a notation by the judge instructing Mr. Hudson to file a petition for a reduction in his sentence. Mr. Hudson served 19 months and received early release due to good behavior. He then successfully completed 8.5 years of parole and was released from parole on 10/1 of 2000. Mr. Hudson also disclosed that he pled guilty to one count simple possession, a misdemeanor, in the Court of General Sessions of Davidson County, and one count of anhydrogenous ammonia violation, a misdemeanor, in the Criminal Circuit Court of Davidson County on 7/11 of 1991. He received a suspended sentence of 11 months, 29 days for the 1989 incident and a time served sentence in the 1991 incident. As to the felony, Mr. Hudson stated that he was 18 years old in 1989 when the robbery was committed. Mr. Hudson and his cousin conspired to rob a Pargo's restaurant. According to Mr. Hudson, he and his cousin approached an employee after closing, escorted the employee back inside the building, and took money from the cash register and employees. Mr. Hudson stated that one employee left the building, notified the police, and the police arrived before Mr. Hudson and his cousin could leave the building. No one was physically harmed during the robbery, and Mr. Hudson and his cousin never were able to leave with the money that they had taken. In regard to the misdemeanor convictions, Mr. Hudson stated that in 1989 he was a passenger in his cousin's car, which was pulled over for a tail light violation. The policeman smelled marijuana, searched the car, and found a small amount of marijuana. The 1991 misdemeanor incident, Mr. Hudson stated that he had run in to get some ice cream while his friend waited in the car, which was headed in the wrong way on a one-way alley. The police noticed the car, searched it, and found a small amount of marijuana and cocaine. And the friend was convicted of a felony, Mr. Hudson stated, and Mr. Hudson received just a misdemeanor violation for the anhydrogenous ammonia. Since 1991, Mr. Hudson has had no other convictions. Mr. Hudson stated that from 1994 to 2002, he owned and operated Giroux's Fashions, located near the TSU campus. From 2002 to 2007, he worked as a loan facilitator for Atlantic Mortgage and did small remodeling jobs. In 2007 to 2013, he owned and developed At the Table Restaurant on 12th Avenue South in the Gulch area. Mr. Hudson sold the business in 2013 and has been buying, developing, and selling property since that time.
All right, Mr. Hudson, again, thanks for coming here this morning. You've heard the summary. Would you like to add or give more detail about any of those events?
It's pretty much complete. So far as the robbery incident, it was a time in my life I was just kind of in between, I guess, becoming an adult and being a kid. I was hanging around with my older cousin, which a couple of those incidents we were together, and just found myself getting into a lot of trouble. So looking back at it now, it was something that needed to happen to bring me on to where I am now. I wish it didn't happen. I knew what I was doing was wrong, but not so much as the lifelong consequence that came along with that, you know, that here I am 20-some odd years later still dealing with something from my past, and I deeply regret it. Wish it never happened, and but I've changed a whole lot since then. That was the end of that part of my life at that point. Yes, sir.
Are there questions by commissioners? Ms. Franks?
I'd like to ask, how have you made amends to those employees at Pargos? And first of all, did it involve a gun?
It did. It was unloaded, but it was a gun involved.
Okay, so how many employees were there that you were there when you robbed them?
Maybe 5.
So have you done anything that would to make amends for what happened?
Not to them personally. Ironically, as I got older, I became a restaurant owner myself, and it wasn't a day that went by that I didn't think that somebody may come in and pull a
Right.
gun or doing those type of things, to me myself. So, and even once I was released from prison, I worked at fast food restaurants just to get back on my feet and get started. And it always played in my head, hey, what if somebody came in here and, did the exact same thing? How would I feel? How would, I react? Or even if somebody had gotten hurt in the incident that we did, So I am deeply sorry about the situation. And like I say, I ran my own restaurant with my uncle for 5 years, and it wasn't a day that went by. I was in a small section between Edge Hill and the Gulch, and so this side had condos, this side had housing projects, and I was right there in the middle. So my mind constantly thought about security and things of that nature. So, but no, not to those individuals directly, but I felt within myself, what they could have been going through.
As a restaurant owner, I know we all worry about that very scenario happening to us. So I think probably the biggest punishment you had was having those feelings yourself.
Yeah, and I had them daily. So
that's all.
Other commissioners? Mr. Hudson, according to this report I have, it says that you're currently buying, developing, and selling property?
Yes, I'm mostly in the Elizabeth Park area over here off of Monroe and Arthur Avenue. I'm in the process of doing development of 4 units on the corner of Garfield and Arthur. We broke ground about a week and a half ago. We're starting to do the first duplexes, and once we finish those, we'll do the second set of duplexes. Also have a house that I'm closing on the same street. Hopefully Friday, we're supposed to close. And I have a couple of rentals in the area also that or do Section 8, and I'm going to a meeting on the 12th about veteran housing for veterans.
So why do you want a real estate license? If you're sound to me that you're being successful without one?
Well, I figure this development that I'm doing, all units together be 1.3 million. I get a little extra commission on that, help also.
Will you be paying yourself the commission?
I'll be paying Kurt.
Well, I don't mean it that way. I mean, sometimes Mr. Alexander says, if you're just dealing in your own properties, you may not need a real estate license. Is that your intent, or you expand?
Yeah, I just
service?
want to expand my realm and just add another tool to my toolbox. I've done things in the past for income that I thought were great ideas to generate money, but I really enjoy doing real estate. It's something that I enjoy doing, opposed to the restaurant business or the clothing business. It was things that I got into more of a venture that I thought would generate income, but I really enjoy doing the real estate part.
But any other questions? There may be others for you. If it's all right, we'll go to Mr. Steckel, and if you will, tell us why you're attracted to this applicant and what you can do to make sure he's successful.
Robert through one of our agents in the office.
Please step up to that microphone just a little bit.
I met Robert through one of our agents in the office they've been friends since childhood, and he pretty much explained the same thing that Robert went through. It's just wrong place at the wrong time, about almost 20, 25 years ago. So Robert and I have talked a couple of times about it. Based on what he's telling me now, I feel right track. I feel there's a very good prospect to be a realtor that's out there, a real estate agent. So I feel with him coming on board with us, with part of our training that we have in Keller Williams, and also too, he will actually be in the mentor program with this same agent. And this agent has been in the business between 3 and 4 years, and he's very, very knowledgeable, very thorough, very professional. So I feel it'll be a good combination between the two. that they can work well together, and I feel comfortable with that.
Alexander, do you have any questions?
Pass for right now.
Okay.
I'll come back to me.
Okay. Other commissioners for the broker?
I'd like to make a motion.
Please do so. I do have a question myself, but go ahead and let's get a motion on the floor.
I make a motion that we approve this applicant.
I second it.
Okay, we have a motion made by Commissioner Franks and seconded by Commissioner Collins that this applicant or his effort to proceed to get a real estate license be approved. We'll hold the motion just for a second. So you heard our discussion with the last Keller Williams broker. Is it the same company? Do you guys have the same name? It looked like both of you are what's the story between the two companies since we've got you up here?
We're under the same Keller Williams model, and just two different offices, but we're pretty much the same question that you were asking Linda, pretty much would be the same questions you asked me, and I would pretty much have the same answers, yes.
So is there different ownership between Linda's Pennington's and your Keller Williams franchise?
We have a principal, we have a majority owner in each office.
Same owner?
Same owner, 51%. Then the other 49% are owned by investors of each office. Some could be in both of them, some could be just in my office, some could be in the Green Hills office. And that's how the ownership is set up.
Go ahead.
Are those investors some of the agents? So they're all.
Are some that are not, some that might have been agents in the beginning when they came into town, but they may not still be in the business.
Well, this agent that brought this gentleman to you, is he going to be on his team?
Mentor program.
That wasn't my question.
Right.
Is this man that brought him to you on a team? The teams you have?
I'd probably say maybe around anywhere from 5 to 7.
5 to 7.
5 to 7, I think.
You don't know?
Some of them are teams are just a husband and wife. So I
You
probably
either got 5 or you got 7.
I'm gonna say 7.
Okay. Question: do you look at the escrow account? Do you write the checks? Do you observe those checks and monitor them when they go out?
Yes, I spot check.
And none of them are made to the team captain and then issued. I see the words got passed.
Oh, sir.
Got a pretty good pat answer now.
Hills.
And how long have you known the applicant? 2 months. And Mr. Hudson, I'll ask you the same question. The attraction was through your friend to this company?
Not only that, I did research with other companies before, and they pride themselves on their teaching and informing their agents. They're very big on that. They're one of the largest companies, if not the largest company in North America. And I just thought it'd be a great place to start. I went to Village. I went to some smaller companies and talked with their brokers, and I just felt better with the support team that they had in place over there. And yes, my friend also spoke very highly of the company.
One more clarification. You said between the Dream Team Franklin and the Green Team Green Hills, the same owner of 51% is those two companies.
Did you hear my question to Ms. Pennington about the KW? Do you understand that by itself it can't represent your company?
We understand that, and Keller Williams has said the same thing when they first came out with that about maybe 2 years ago with just a KW. It's just a logo, but you still have to have Keller Williams Realty because that is what we are registered as. That is supposed to be on all signage and advertising, yes.
So do you have Dream Team Keller Williams? Because is that the name that you have when you turned in for your license?
A Dream Team, is that correct?
The Dream Team Franklin LLC DBA Keller Williams Realty.
You have a second office in at the same address? That's maybe Keller Williams Commercial or anything like that? Okay. All right, are there other questions for either the
I
applicant?
want to tell Mr. Hudson one thing. All you doing, if you gonna build and sell your own stuff, you just asking for problems.
No,
And you're gonna start giving away part of your money. If you're that $1,000,003 would've been $78,000 on 6%, I can figure that right quick.
That's,
Call for the question.
all right, there's a motion on the floor. There's been a question to vote. Is there an objection to the call for the question? I hear none. Let's vote. All in favor of the motion to approve this applicant to move forward, please say aye.
Aye.
Those opposed, no. Motion passes unanimously. Congratulations. Good luck, Mr. Hudson, Mr. Steckel. Thanks for
Thank you
coming
very
in.
much.
Have a good holiday season.
How about a break? Wouldn't that be appropriate?
What time is it?
I don't know.
Well, our guys from Memphis just got here. We're going to take about a 5 to 7 minute break. Then we'll get Mr. Mitchell up here with his potential licensee.
Well, he's not supposed to be here till 10, so we got 10.
And we have one more informal applicant to consider this morning. At this time, I'd like for Major Smith and William Mitchell to please come to the front table there and find a microphone you can sit in front of, and we'll hear your story. Before we get started, our legal counsel will need to swear both of you two in. So, Ms. Baird, if you would do the honors.
Raise your right hand, please. Do you swear to tell the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Ms. Maxwell?
Yes. The applicant for affiliate broker's license is Major Clarence Smith. His principal broker is William M. Mitchell from Crylike Inc. in Memphis, Tennessee. Mr. Mitchell was first licensed as an affiliate broker on 8/8 of 1979 and was first licensed as a broker on 8/12 of 1999 and has been the principal broker at Crylike Inc. Since that time. The track records indicate that the firm was first licensed on 1/19 of 1983 and currently has 42 affiliate brokers and 4 brokers. Our records reflect that Mr. Mitchell has had no disciplinary action taken against him by the Commission. The applicant, Major Clarence Smith, has sent in certificates indicating that he has completed the 60-hour pre-license course and completed the 30-hour course for new affiliates. He had not tested when he submitted his paperwork, and he may have tested by now, I'm not sure, but he had not tested when he submitted his paperwork. He is ready to proceed with the completion of his requirements if the Commission approves him to move forward. Mr. Smith did previously submit an application for decision regarding prior criminal convictions and stated that he had been convicted of 1 count of involuntary manslaughter by the State of Michigan, County of Wayne, City of Detroit, 3rd Judicial Circuit Court on 6/17 of 1983, and this was a felony. Mr. Smith was sentenced to the State Prison of Southern Michigan for an indeterminate sentence ranging from 5 to 15 years. Mr. Smith was initially paroled on 4/7 of 1986, but missed his curfew one night, and that violation of the terms of his parole resulted in a return to prison. He was paroled again on 1/4 of 1988 and was discharged from parole on 7/4 of 1989, which was approximately 6 years after his original conviction. Mr. Smith was 31 years old at the time of the traffic accident which led to his felony conviction. Mr. Smith states that on November the 4th of 1982, after working a 10-hour shift at Chrysler Automotive, he stopped by a bar and grill for a beer. On his way home from the bar and grill, Mr. Smith fell asleep at the wheel and crashed into another vehicle. A man in the other vehicle died as a result of the accident, and Mr. Smith was charged with and convicted of involuntary manslaughter. Mr. Smith stated that after he was initially paroled from prison, he returned to his job at Chrysler Automotive, where he had been employed since 1967. One night while working overtime, Mr. Smith missed his parole curfew and was told by his parole officer if he missed again, his parole would be revoked. His parole was revoked the next time he missed curfew, and that was on 10/29 of 86, and he returned to prison. As I mentioned earlier, he was paroled again on 1/4 of 1988 and discharged from parole on 7/4 of 1989. While in prison, Mr. Smith earned his associate's degree from Jackson Community College in Jackson, Michigan. During this time, he also became a certified apprentice substance abuse counselor in Michigan and studied psychology at Spring Arbor College. Since his discharge from parole, Mr. Smith has attended Lemoyne-Owen College in Memphis, University of Memphis, and UT School of Social Work. Since 2011, Mr. Smith has been a resident monitor for the CAPS program, which is the Cocaine Alcohol Awareness Program in Memphis. He's worked at several companies involved in the delivery of counseling and behavioral therapy services for the last 20 years.
Thank you, Ms. Maxwell. Mr. Smith, you've heard that summary. Is there anything you'd like to add?
Nothing is a part of my life that.
Mr. Smith, I'm going to interrupt you just for a second. If you wouldn't mind speaking closer to the microphone, we record these and we need all your comments. Thank you.
A part of my life I deeply regret, that lack in judgment.
Well, let's not focus on that for a minute. Tell us what you've been doing the last 4 or 5 years.
I've been working as a monitor and a counselor at the VA Transitional Housing, counseling veterans with dual behavior problems and alcohol and drugs. I've been doing that the last 4 years. Several different places, mostly contract work, and still continue to do so on a PRN part-time basis.
But what, in your opinion, is totally unrelated to why you're here. What's the state of our veterans at this point?
I didn't hear you, sir.
What is the state of our veterans at this point? Are they getting better, worse? They got problems we need to work on?
Well, they're being addressed. Most of it is being transitional, being left, like a better term, left behind. And with a little help, we have a 2-year program there at CAPS. We help them. We sort of connect the dots to the resources that a lot of them don't know they are available for them. And even with the assistance of getting a roof over their head, a permanent roof. And the program has been quite successful for what I see. The recidivism, the veterans returning are far less than the other treatment centers and facilities I've worked throughout Memphis and Michigan. So that program there is well needed and very useful.
Other questions for the applicant, Ms. Franks?
I'd like to know what has led you to the path of wanting to be a realtor.
Well, I purchased a home, to be honest, and I had quite a bit of difficulty finding what I needed. And I sort of enjoyed looking at the houses, and I've always been a people person. I always enjoyed helping people. And I know that this job would help me financially, and it would give me a little more time with my grandchildren.
Thank you.
How many grandchildren do you have?
5.
They all in Memphis?
All in Memphis.
Well, you hadn't got time to sell real estate, do you?
That's what I was thinking.
All right, any other questions at the moment for Mr. Smith? If not, let's turn to William Minchell, his potential principal broker. William, what can you tell us about your relationship with this guy? Why do you want him?
Well, I first met, and first of all, good morning. I first met Mr. Smith probably 20 years ago. I sold him a house.
That's the house he was talking about?
No. And we kind of got lost from one another, actually. And so he called me, and even while I was working with him, I never knew the story. I guess he had recently come here from Michigan. And, of course, he's always been just a friendly guy. And he and his wife, who, by the way, have been married for 44 years. And they were just an exceptional couple, and then really enjoyed working with them. And he called me a few months ago and said he wanted to get in the real estate business, and he told me about his incident. And I said, sure, I'll go up and support you if you're going to come to work. I said, you seem pretty eager, and you're retired, and you know, with the right training and pathway, I'm pretty sure you'll do pretty well. He's got a concern of people more so than anything else. And when you're concerned about people, that leads you to do a better job. When you're not concerned about people, you'll probably be down here.
Questions for Mr. Mitchell?
Mr. Chairman, can I make one correction, I think, on my license? They say I was licensed in '79, but that's my records show that my license were obtained in November of 1974. And I know the '79
Year you were born?
Well, 10 years prior. But
so noted, William. You've got this thing in the bag, I think, if you're careful.
Well, I don't want to screw up nothing. I don't want to get an infraction for practicing in 1974 and 5 and 6 without a license. So I wanted to
we've got a new investigator.
Yeah, that's all right. I'm clean.
Okay.
I'd like to make a motion that we approve Mr. Smith for his license.
I have a motion by Commissioner DeChara, seconded by Commissioner Collins, that this applicant be allowed to go forward, get his license, and be successful. I think that was the motion, wasn't it?
It was.
All right.
I like the successful part.
Well, is there discussion?
Knowing William Mitchell, there is no question but what he won't be monitored and checked. William Mitchell, I've known him since he's been licensed, I guess, long time.
Long time.
I'm a little older than him, but he is a quality gentleman.
So is that a call for the question, Mr.?
That's a call for the question.
All right, is there discussion?
Like
One thing I'd like to pass along to Mr. Smith. I had several Saturdays, about 17 or 18, I was dealing with a couple, and I went to this seminar, and they said, always talk to them about what they like and find out what their hobbies are. And I did, and they said their hobbies was looking at houses.
Oh,
I just want to pass that on to you.
I remember that.
Please do.
All right, thank you, Mr. Collins. Let's vote on the motion. The motion is to approve this applicant to move forward. All in favor of that motion, vote aye.
Aye.
Those opposed, no. The motion passes unanimously. Mr. Mitchell, now that that's out of the way, can you tell us exactly what Crylike is doing illegal in Memphis? I mean, what practice is there?
I refuse to answer that question.
Gentlemen,
You're still as smart as you ever were, William.
Thank you both for coming to see us today. Good luck in the future and have
Enjoyable
a happy
day.
holiday
Thank you.
season.
I would like to thank you, and especially Ms. Maxwell and her staff for encouraging me to get the information that they direly need.
But take care
I
of
know
those.
I might have been a pain, but thank you so much.
Good luck and God bless.
God bless you all.
Yes, sir.
There's a person in the building. that
You go,
may be-
gentlemen, or you can stay all day and tomorrow if you want to, but you're dismissed.
That may be questionable, and I
all.
would like for you to check him out.
I will. I'm going to do that in just 1 second.
I think he still belongs up here.
So before we get to this introduction, to the audience, we on a regular basis have people who have had some event in their history who come before us to try to get permission to get a real estate license. And you've heard 3 different cases today, and it's tough on this commission. Many times, sometimes it's easy. Mr. Smith was, in my opinion, pretty easy. But it's tough on those people, and you got to give those people who show up and tell their sins to come up here in front of you. It's on YouTube forever and a day now. This whole proceeding is recorded. And so I hope you appreciate their effort as well. Finally, Ms. Maxwell, if somebody's got something in their background like a felony and they don't mark that box on the applicant and we find out about it later, what happens at that point?
Well, at that point, we would open a complaint against them. Fortunately, now that fingerprints are required, a lot of that's coming out on the front end, but they would have a complaint opening against them, which would ultimately be presented to the commission to make a determination for misrepresenting something on their application.
Which doesn't generally sit well with the commission, I might add.
I also had a question for Ms. Maxwell. I noticed that Mr. Smith had not taken his test yet. So, I mean, at what point can someone come before us? I mean, could they come before they took the class, or?
Right. Some people prefer to, especially if they have something they think might be more serious and could possibly result in their not being able to move forward, they'll come just before they start any process, before they've expended any money, any time, and they'll fill out that application for pre-decision. And their difficulty there is getting a principal broker who will come with you because it is sort of in the future. And so we see now more and more that people at least have taken the courses, and then they'll come with a principal broker when they're a little bit closer to the process. And then you have, like, 2 of these 3 applicants had already taken the test, had done everything that was necessary to get licensed except have the approval of the commission to move forward. In Mr. Smith's case, he had had taken all the courses. He's got the 90 hours, and I assume that he'll be sitting for the exam.
So what is the law? I mean, is there a certain point, or could you come before you took the class?
Yes, you can come before you take the class,
at
but
any
because
time
the
then?
commission requires that your principal broker accompany you, it's a little more of a challenge for people that have taken nothing, and they've not taken any of the classes, they've not taken the exam, to find someone to come with you when it could be 6-8 months. It could be a period of time before you get licensed. But there's no set time in the statute, because the individuals are coming before you all pursuant to 6213-303, so that you can determine as a commission whether or not they meet those requirements of trustworthy and able to complete the job of a broker or an affiliate broker. So that's why they're appearing before you all, to make that determination. And the commission has decided that a felony or misdemeanor that involves the theft of money, services, or property are those items which would need someone would need to come in if they had a conviction for one of those, not just charges, but a conviction. Because as I've mentioned before, lots of people have many run-ins with legal enforcement, but they don't end up with a conviction for it. So that's what brings the individuals in.
Thank you, Ms. Maxwell. So this commission is made up of 9 members. 7 are here today. Actually, the 8th member is here. These 7 are all licensees. There are 2 members appointed by the governor who are not licensees. One, our friend Austin McMullen, had his grandfather pass away day before yesterday and had to go to Jackson, Mississippi. He's an attorney here in Nashville, and the other public member is sitting in the back row back there. He's been out on a cruise ship or somewhere. I don't know where in the heck he's been, but Commissioner David Flitcroft, come up here with us because David Flitcroft has a parting line for every one of those applicants, proposed principal broker. On the way out, Commissioner Flitcroft, who's going to tell me what that line is right here, will say to that principal broker, David?
He comes back, you come back.
Okay. Well, we're glad to see you, my friend. Welcome.
Bear says he'll be here at 10:30.
Then there's another nefarious kind of fellow coming. The fellow who just went off the real estate commission is a guy named Bear Stevenson. Ladies, if you, I'd recommend you find somebody to sit next to you right now, because he will try to if you're not careful. He could care less what we do in this business. He just wanted to see who he can sit and chat with.
He ain't gotten here yet.
But we'll introduce him when he shows up as well. At this time, Ms. Robin Ryan is on the agenda. We added her. She's got an item to discuss.
I do.
Okay. And so would you give your title as well so people know who you are?
My name is Robin Ryan. I am one of the litigation attorneys, and I litigate issues.
And she's on the docket tomorrow morning. She's the attorney representing the state tomorrow.
That's correct.
Okay, Robin.
The issue is for tomorrow that the respondent has an attorney, and the attorney has requested for the respondent that the respondent be allowed to testify or talk to you via telephone alone and not appear in person. And I will tell you that this is a party to a case, so it would be, if it were a witness alone, it would be an issue for the ALJ to determine if the other side and I could not agree. But this is not a witness alone. This is a party to the case, and it's up to this commission to decide whether or not they want him to talk via telephone or want him to appear in person. I told his attorney that I would, it's very unusual, I've never had this happen before, but that I would bring it to you all for a vote. It is up to you to make that determination. I asked for some reasoning to why he would not want to appear. And I will read you his attorney's statement. He is seeking a telephonic appearance as a cost-saving measure. His business has been extremely slow and the cost is somewhat of a hardship. He recognizes his wrongdoing and doesn't want to make excuses for it. He simply feels he could express the reasons for leniency without making the personal appearance. Yes. There is no law on that. And you know, if he weren't to show up at all, if he doesn't appear at all, then it would be up to you to determine whether or not he'd been properly served and whether or not it would be a default judgment you would go forward without his testimony. If he were in prison, then his appearance probably would be allowed by telephone if he asked for a motion for that, because he would be totally unavailable. As far as your laws, you don't have anything in place, and the laws of the Administrative Procedures Division don't provide for this either. It only provides for witnesses via telephone. And witnesses, he is technically a witness, but he's a party witness as opposed to a witness that would normally be testifying on behalf of either the state or the respondent.
Didn't we do this like a month or so ago? We had someone testify by phone?
Not a party. This is a party. He's the respondent. Yes, you've had witnesses testify by telephone, but not the person against whom we're seeking.
He was a plaintiff, I think, wasn't he?
No, he was not. He was a party. He was a witness. That means that either he had a complaint going or he was the victim of something, but we don't represent those parties. Right. This person is represented by an attorney, and we represent the state, and it's up to you all to determine if you want to do that.
I thought that we had to agree, if they didn't like the ruling, they could appear before the commission, and by phone is not appearing.
Well, it is, but it's not appearing in person. I mean, it's still an appearance, but you're right. There is a difference, and that's why I'm bringing it to you all to determine what you would like to do.
Is his attorney coming?
I asked that question. I've not heard back from his attorney, but my guess would be no.
How far away is this person?
Memphis.
Well, what's the difference in a phone call and a deposition sent to us that we could look over?
Well, a deposition, it would be limited in what you could do with the deposition because it's in writing and you'd have to look at it. With the telephone call, you would still be entitled to ask questions or have him respond to anything, and he would be answering questions live.
Chairman, just for the audience's sake, we are the jury tomorrow. We deliberate in public. I think Ms. Ryan is going to make her case, and sometimes we agree with her and sometimes we don't. So I'm not sure how much you can tell us about this. Did I hear an indication that the guy said he knew what he'd done was wrong? Is that the attorney's statement that you read?
That's the attorney's statement that I read. I don't really want to give away the facts of the case. It's not fair to the respondent to do that.
I understand.
Okay. But I did ask for a statement from his attorney, and I told him I would relay this to the commission.
Hey, Mr. Alexander.
And Mr. Chairman, to get it taken care of one way or other, I move that he be denied the telephone conversation and he appear in person.
Seconded.
And I think that Mr. Alexander, I think that's appropriate in that we have a commissioner who drives here from Memphis for these meetings every month. If you told me he was in California, but if he's in Memphis, he can drive here.
I think you misunderstood my motion. My motion is that he be here.
That's what I'm saying. That's what I'm saying.
Are you speaking for the motion?
The motion, yes. Let me just make sure everyone understands the motion made by Mr. Alexander and seconded by Ms. Hills. And that motion is that is it our desire, Robin, or what is our instruction that he...
That you're denying the motion for his request to appear via telephone and that he would have to appear in person.
Okay, so the motion is to deny the request.
Yes.
And I would ask, before you take the vote, that when you do take the vote, if Ms. Maxwell will do it by roll call vote for the record.
Let's start alphabetically.
Ready?
A's first.
Well, let's see, is there other discussion on the motion before we get to that point?
In a second.
Yeah, we've got a second. Ms. Hills?
Just to add that then if he makes a decision, whatever our vote is, then that's up to him.
That's correct. And may I ask too, since I will be reporting this back to the attorney, if you could at some point give me a statement or the reason for the denial so that it's a part of the record and I can relay that reason.
Leave that to the chair.
Well, let's talk, so, if neither the attorney or his client showed up tomorrow, we'd have to decide whether we want to hear it because you'd properly noticed him.
You would, the first thing you would decide is I would present proof on whether or not he was properly served, and that would be the decision of the administrative law judge. Then the administrative law judge would then ask you as the commission if you wish to go forward or continue it.
I think one of my biggest issues with them not being here when they're the respondent is the fact that if something else comes out and we have additional questions, we don't have that opportunity because they've already appeared by phone and we have to go back and get him on the phone
Well,
again.
no, he'd be on the, if the commission were to approve his being on the phone, then I would surmise that he would be on the telephone listening throughout the entire hearing, so that if you would be able to question him when he's giving testimony, and just like you would if he were here.
Okay. And his reason that you stated for not being present was it was a cost hardship. That's the reason, right? And
is,
so I think for that reason we need to deny it, because that's what it's all based on, is that we deny it because of that reason.
Mr. Ryan, there's no incapacitation. He's not ill or sick or...
Yeah, and that's a good question. I did not get that. I will tell this commission that I believe he's like 74 years old, but...
That's not old.
I know. I don't think so either.
Wendell can tell you that's not old.
But other than that, I have had no indication. In fact, I was asking to see if there was something there. And there may be something, and he's not comfortable telling. I don't know.
All right.
Call for the question.
Any objection to the call?
And you're going to deny it because it's not a cost hardship, or what?
Well, let's get a vote, and then we'll see if we can give you unless you want justification before the vote.
What do you think, E? Should I get justification? Yes, justification before the vote.
We see no hardship, a cost hardship, if that's what the vote is.
I think also it changes precedent because we've never done this before. The 9 years I've been on this commission,
I would
precedent's
put
the
both
number
of
one
those.
reason.
Okay.
And we're opening the door for everybody. Hey, I'll be on.
I'm not coming.
I'm not
Yeah.
coming.
All right, everybody's
been
comfortable with those reasons? Assuming the vote passes, we're going to roll call this. Ms. Maxwell?
So the motion is to deny the request by respondent to appear by telephone. Gary Bloom?
If I vote yes, that means I'm voting for the...
For the motion.
Yes.
Alexander?
Yes.
Franks?
Yes.
Grease?
Yes.
Hills?
Yes.
DeChara?
Yes.
Collins?
Yes.
And McMullen is absent, so it's all in favor, yes. Motion passes.
Motion passes unanimously.
Thank you.
Thank you for coming down and
We'll see you tomorrow.
9 o'clock, right?
Be there, be square. Want to hear a bad joke before I go?
No.
Oh,
No.
you save it for lunchtime, Robin. You have to entertain us at lunchtime.
Can we just take your picture?
Thank you, Robin. We're on to the education report. And we're
Which
back to
one?
Ms. Maxwell.
So we have several items under the education report. I don't know how much, we have plenty of time. I don't know which ones the commission's interested in doing first. Probably the course instructor approval is the one that's listed number one. And everyone had received a copy, I hope, of the education report. And on it, it listed all the core courses. And when I finished reviewing all the core courses for the core for 2015, 2016, some seemed as if maybe they were lacking some substantial information. And so I took off a number of the core courses, as you'll see from the education report. And there are several core courses that are on the list for approval, so that we would have some core courses available as of 1/1 of 15, which is when the current core course will no longer be a valid course to take for CE credit. I don't really know what the expectation of the commissioners is or was as it related to the core course. And, you know, there are a lot of topics this year, and some of them are covered in not much detail in some of the core courses. I don't know whether some of the commissioners would be interested in looking at one or two of the core courses to sort of get a feel for what's actually contained in those, to make sure that it does have the material that the commissioners want it to have and envision that it have in there. The ones that are on here are primarily the internet ones that have been approved by Arello, and they have the Arello certified instructors who are teaching them. So those, and I've gone in and looked at those, and they ask a lot of questions, so they're more interactive. They'll give some scenarios. Some of the core courses that came through really and truly had a copy of the statutes and had some rules as well. And then maybe some, as far as it related to the leases, the commercial leases, it had definitions of net, triple net, double net leases, but there wasn't a lot of other information, so you couldn't really tell what was going to transpire with those. Some of those were paper and pencil, and some were classroom. And so, as I say, I think it might be beneficial if one or more of the commissioners wanted to just look at some of those courses and get a feel for what's contained in those courses and see if that's the way you anticipated the courses would be structured.
Can I ask you something else?
I thought you were volunteering to take a course, Gary.
Oh,
Chair's
well,
gonna
I'll do that.
appoint him.
I'll
Chair
do
will
that.
appoint him if he doesn't volunteer.
But when you showed Trek Core 2015, 2016, I thought that was the number. You're saying that's for the years.
Right, so that's for the ones that start
Okay.
1/1. These are the ones that start 1/1 of 2015. They'll run until 12/31 of 2016.
Yeah.
And so
Okay,
that's
well, I
why
got
some of them are on here, so that we didn't end up a situation where someone wanted on 1/1 to take a Trek core course and there was not
Okay.
one that had been approved. So that's what those are the Trek cores. And these are not all Trek cores. There's some other courses mixed in here. And so these are courses, there were none that I wanted that I put on here for discussion, because we reviewed all these courses and they all looked like courses that contained information that would be beneficial to the licensees. The core courses I took off were, so, as I say, I think it would be beneficial for one or more commissioners to look at some of those and make sure that they are what you all had envisioned them to be.
Did you say you'd already taken those off?
I've already taken those off, as I say, but the first list that I sent to you all had all of those on there. And then as I went through them all in more detail, I guess like when you're grading papers and you go through the papers and you compare, you know, what one looked like in regard to the other, there were some that I took off so that, as I say, I thought it might be beneficial to have you all, someone's review them to get make sure that they did have the information that the commission envisioned.
Also, you said that some of the courses didn't have all the information that you.
Well, right,
Did you arbitrarily just take those off?
I took those core courses off. So some of them just didn't seem. Some are paper and pencil. So if it's not there, it's just pretty much not there, because there's no interaction with these particular courses that's required by the statute or the rules. So these courses would just be what you see on the paper and pencil is just what you're going to see. The classroom, obviously, there could be some more interaction just that comes with being in a classroom and people asking questions. But some of those courses didn't contain information that would indicate that was going to be the case. It was mainly, as I say, copies of the statutes, copy of the rules, and then copy of information that related to commercial leases that was part of the core course as well.
Just out of curiosity, you keep using the word some courses, half the courses. Would you like to be a little bit more specific?
Oh, yeah, it's about half the courses, quite frankly.
Are these people who are currently, or providers that are currently teaching that course this year?
Well, they are currently providers that are teaching. Yes, they are currently providers. I didn't review the core courses the last time, so part of it is, and I did look at a core course that was submitted last time. Some of the core courses weren't approved until like April and, I don't know, March and April of last time. Anyway, just looking through them, I felt like they probably just needed more interaction. I mean, it just looked like that was all someone had done, was take the information and just copied it, and that was
The minimal.
Right, and so I felt like it was important for one or more of the commissioners to look at some of these just to make sure that it does have, and it is presented the way, particularly with Commissioner Frank's concern and Commissioner DeCharo's concern last month about the instructors and about the way the course materials are presented. I just thought it might be an important thing to make sure, because the core course is required of every licensee who's not grandfathered. So it is a course that everyone's going to be exposed to that has to take continuing education for renewal.
Do we have criteria for people who want to be instructors, that they have some sort of teaching background, or?
Well, they don't have to have a teaching background. In the memorandum that I wrote about the instructor and course criteria, we do have, there's some statutory criteria, and then there's criteria that's on the application. And so, you have to meet those two criterias, and we look, you have to turn in your resume and all your experience and the courses you've taken and things of that nature, which doesn't guarantee you're a good or a bad teacher. You could have 1 year of experience and be an awesome teacher. But that's what, those are kind of the things that we require as far as just looking at a piece of paper and evaluating someone. And so that's kind of the starting point for the instructors. And then the course material is the other component of that. And we look at the course material, but it's really looking at it and trying to make a determination while you're sitting there whether or not the material contains what it should contain for that particular course, or what you at least, it looks like it fulfills the number of hours it says it's going to fulfill, and whether it covers all the areas that it says it's going to cover. In some of the CE courses that are submitted, obviously if you're teaching a course, say, on antitrust, well, that could cover a number of things, and we wouldn't specify what those things would be. In the core course, the commission has said these are the things we want you to cover. So there are certain things that have to be covered, just like in the pre-license course, certain things have to be covered. And so those, so it's kind of some of it is sort of a subjective determination when you're looking at the courses, but the paper and pencil courses are what they are. I mean,
right,
because they just, you're going to get what you're going to get. And so unless it's a pre-licensed course, and under the statute, you have to have those interactions every 5 hours, some live interaction. So those are just, that's the way the process works. And it's been discussed a number of times, and I don't know really how to make the process work better or more efficiently. As I say in the memo that I wrote, the commission itself under the rule has very limited ability to take action against an instructor or a course, because the commission doesn't approve sponsors. They only approve the course and the instructor. So there's very little action that can be taken unless it's just so egregious that the approval is withdrawn. And we've had a couple of instances that some of you all may recall where we did have approval withdrawn, but the schools had pretty much quit operation by that point anyway. But the statute, the rule lists about 5 situations where you could take the approval away. It does not really provide for taking just an instructor approval away, because the instructors came along in 2009. The separate approval of an instructor came along in 2009, and the rule that allows for approval to be withdrawn preceded that and wasn't, it was not amended at the time to include the instructors. So it pretty much is aimed at the courses.
So if they have a RELO, what is the word, not approval, but
They do have a certification.
certification, that is a higher standard then?
That is, well, it's gone through a process where, first of all, they had to pay some money, so at least they had a more vested interest, I guess, as it were. And then they've submitted it to Arello, who's made sure that it has the safeguards in it for an internet course, and that it takes the time that it says it's going to take. They have, Arello has independent individuals who do a time study. You turn in a time study as well, and then they go through and make sure that I can tell you're the person taking the course all throughout the course. They don't look at the materials per se and say, these are great materials, but they are evaluating the course as a whole. The instructors then have to be certified with the distance education instructor, which is sponsored by Arello, and you can't teach an Arello course unless you have that. So that you had to take a course for that to get that initially, that certification as an instructor, and then you have to renew it and take another, renewal course as well. So that instructor is, I don't know, maybe they've had more training at least, and they are internet instructors, and those are they're distance courses, and they're internet courses at this point.
So would it help at all if we were somehow, I know a lot of the classes do like a survey at the end of the class. Would there be any way that we could have some access to that to really know? The reason I brought this up was that my daughter just recently was licensed, and some of the things that, and I wanted her to go to this certain school. She did, and some of the things she told me, I was just, flabbergasted about. So I don't know how we control it any better. I would love and go on record every month that's saying that we still are in desperate need of an education director. Because I now see how that is a full-time job for someone looking at, all these classes and all these people. I think it could really get away from us on some of these. So that's my concern.
Right, and I think at different points in time, the commission has talked about doing, surprise visits to the schools and to the instructors in a classroom situation, which is fine, except that you almost have to get someone that no one knew. And you could have one class where maybe the interaction with the class was not good. It just wasn't good for whatever reasons. So that's a little hard to practically apply that kind of a secret shopper arrangement. The internet courses, one can go online, like for the core courses, I went online and could see what they had to offer with a password, and we've done that before with a couple of courses where we go online and we actually take it or listen to it or whatever we're going to do, and that's okay. That's not giving you a whole lot of information about the instructor. And then the statute requires interaction with an instructor in certain instances if the courses are certain hours long. Those are interactions that you won't be able to monitor because doesn't have to be at a set time. I can just, unless I guess the instructor says, okay, I'm going to be available like a college person would. These are the hours, my office hours. Otherwise, there's no given time for that interaction to take place, except that it has to take place if, in a pre-licensed course, it's done by correspondence or distance. It has to be, you have to have, per every 5 hours, you have to have a live interaction but it doesn't say what kind of live interaction you have to have. So those are difficult to monitor just across the board. The surveys, the instructors are to get surveys at the end of class. The
Where
internet.
do those go to, though?
They go just to the
instructor.
instructors, and they're in their records. And the internet courses, you have to answer the survey to get, and at least in some of them, to actually get the certificate. So that that's required. Those surveys, we could request those, but we don't.
We don't have the authority.
Well, we do have the authority, and because it is part of the record keeping of the school, and we've talked about in the past actually requesting the surveys. I guess you'd have to request enough to see enough to know something about a teacher, because from time to time we do get complaints about instructors or about courses or about sponsors who, as I say, are not approved one way or the other. But if you only get one, it's like anything. It's like anything else. You look into it, and if you don't get several that say the same thing about the person, because frequently the complaints that we get, and we don't get very many, but they're really personal complaints. It's like, well, I just didn't like that person, or I thought he was rude to me, or it's just a personal kind of complaint, and it's not about the quality of the teacher. And so so those are really ones that I don't know that the commission would really have any authority to jump into something that would be a personal conflict between a person and an instructor. And we've always said we're welcome to whatever suggestions anyone has as to how that process can become a more effective process with the tools that we currently have in the statute and the rules. And I attached those to the memo that I wrote so that you could sort of see those all gathered together and see, if there were any ideas that anyone would have. The last major change we made to education was in 2009, early 2009, when the instructor, as I say, got a standalone approval, and we came up with the instructor application, and that is the last time there was any significant. That was the last time I think we made any changes to the education rules or statute at that time. Happy to answer any other questions.
All right, let's get to where I'm focused.
Okay.
You went from some to about half of the track course, of the core
Of the
course.
core courses.
And how many in numbers would that be? 4?
No, there were.
Because I want a couple of commissioners to take a couple of those and come back and recommend whether we ought to approve them or not. I just need to know how many we've got.
Yeah, let me. There were. I want to make sure I tell you correctly here.
Mr. Chairman, I have a question.
Oh, Ms. Hills, I'm sorry.
And I understand, this is something in the public schools, the same thing with teachers. I think that's a hard thing, and I echo Commissioner Franks on it would be nice that we would have an education director. My question is, do we still, or do we, or is it through ARELA that we look at how just the licensing testing questions test out? Are those reviewed? Or does that company, do we rely on them? This is not the classroom, but just people taking licensing. Do we rely on them to, the company that does the testing, to look at those and rewrite, or
You feel like the affiliate broker in the broker exam.
Mm-hmm.
So PSI is our current test administrator and writer. They have what's called subject matter expert meetings every year, probably every couple of years, and we get several individuals to participate in those with PSI, and questions that either are grayed out as too easy, too hard, or just people seem to miss because maybe they're confusing. Those are all presented, and we make an attempt to rewrite those. Some of them are just too easy because they're just going to be too easy because you got to know it, and so it's just going to be asked. So that happens about every couple of years. PSI has a pretty large bank of questions they always update the questions when our laws or statutes, or, I mean, our rules or statutes change. They do that on a regular basis. The schools certify the individual to test. So, you know, wherever you take your pre-license courses, that sponsor, as it were, certifies you to PSI to test. And so then PSI does have a record of the schools and the pass-fail rate of the individual and what school they got their, you know, what school certified them at least. And so they have, that's a piece of information that they do keep in their statistical database.
That's where I was going with
Yeah.
that.
Sorry, it took a long way to answer
No,
that, but.
You answered it.
And I also wanted to ask too about the, I had two people that sat in a classroom and that were coming to my company, and then, and I like for them to sit in a class, but for the new affiliates class, I let them take it online. And so they did it, you know, separately. But when I asked them, could they bring their books to me and let me see their books? The books were exactly the same. The questions were exactly the same. The test questions were exactly the same. I mean, it wouldn't take somebody too smart to get 2 or 3 people together and do it together, do the ethics course together. I know that's happening. So I just wish there was some way that that could be remedied.
Was that a paper and pencil course, or was it an internet course?
No, it was paper and
Paper and
pencil.
pencil. If you read the little memo that we have, 300, no, we have about a third of our courses are paper and pencil, I think, if that's right. And those, you know, it's difficult to, I mean, that can happen. You have a year to complete that course, and that can happen. I don't know that you sign any affidavit that says, I didn't get any help on this. I mean, I don't remember. Commissioner Char may know, or Commissioner Bloom. I mean, I don't know whether they do or not.
No,
I don't think they do. So I don't, I mean, I can't say I don't doubt that probably does happen. And I don't know how to prevent that of it. I mean, you can have an affidavit, but people can sign that all day long, and that doesn't mean that it's so. So that, I mean, I think that's a danger in any of the paper and pencil courses.
Yeah.
And they're paper and pencil, as you saw, pre-license courses as well, like the 60-hour.
Answer to your question. There are other questions. I'm waiting patiently.
So there were about 6 core courses that I took off. So.
All right. Can I then ask Mr. Bloom, would you take one of those and look at it? Well, my goal would be for you, anybody that takes one of these, to come back at our next meeting and say, well, I recommend it be approved or recommend it be denied because of the following reasons. Thank you, Grover, Diane, Janet, Diane. Did I say Diane down here? So does that take care of the 6 people right there?
I think that'll be fine. I mean,
okay.
Chairman, I recommend that you give one to former Commissioner Stevenson, where he'll have a reason to come back.
Trying to keep him from coming back. Okay.
That'll be great. I mean,
okay.
Thank you. That'll be great. I think it'll just. I think that'll be a good way to.
All right. With that said, then we do have courses to be approved. Is there a motion to approve those courses that are listed?
I would just like to make a point of order that Oliver Francoso is on here for approval, and he is deceased now, so.
I guess he's still listed on.
Not teaching, is he?
Do what?
And if one of these people gets sick, can they call somebody else in to, if they're approved?
If they're approved.
For that course?
Yeah.
Well, yes, but if you, as I pointed out in that memo, the instructors, when the instructor application and the approval of instructors came about, the commission determined that if an instructor on their initial application checked a number of boxes that he or she was qualified to teach in those areas, and in fact their supporting information showed that they were, then they could then just submit courses that they wanted to teach, and they wouldn't have to be approved separately for those courses. So it was sort of a blanket approval for the boxes that one checked on the instructor application, so that those would be easy to substitute because they would, say if it was ethics and you taught contracts, then if you'd already been approved for the whole realm of subjects, then you could teach that.
Okay, let's see. I don't have a motion yet on approving courses
Mr. Frank
and
on-
instructor
On the
approvals.
new one? There's only 17 on the new one.
Oh, no, it's on the,
Is it so 405
it's on
or
the one that
06?
says education final course renewal list.
Oh, the course renewal list. Oh, okay.
We're coming up.
I
to
was
that.
talking about I think you're talking, Commissioner Grease, I think is just talking about the courses, like the,
There's-
But
okay.
I
Wasn't the course
I
renewal.
want to
He
get
must have
you
been-
focused on the agenda item that I'm on, whether you like it or not.
So that's the 6,
So
right?
which one
Which
are
is
you
number
on?
3, December 2014
Okay.
education report.
Gotcha.
Let's get this one handled. There are 4 pages to that. I hope you've looked through to see if there are any particular courses or instructors you'd like to pull out before the chair entertains a motion. If not, is there a motion?
There is one.
And that motion is to approve these courses and these instructors. Is there a second to that motion?
I'll second it. And can I ask a question?
Absolutely. Let me get the motion on the floor, and then you got the floor. The motion made by Commissioner Alexander and seconded by Commissioner Bloom is that the courses listed on our agenda be approved. Mr. Bloom.
Ms. Maxwell, does this include the removal of the core courses that we've just been talking about?
If you're, the
They're not
list
in
that's-
here is what I'm asking.
Yeah, the list, if it's D1 through D17, those are, is that the list?
Yes.
Okay,
That's what's in
so
front of us.
this has taken out those core
Okay, that's
courses
what I
that
was
you all would review.
Okay.
All right, motion's approved, courses D1 through D17. Any discussion? I hear none. Let's vote. All in favor of the motion, vote aye.
Aye.
Those opposed, no. That motion passes unanimously. Now, on the renewals, which, let me get back to my library
So this is,
is
these,
item 4, just for
Okay,
our,
right.
we're on item 4 at this point, which has got Oliver's name apparently on it.
and so these are the courses that, and instructors that were submitted by the sponsors for renewal. So they're courses that were currently approved or instructors that were currently approved, and their sponsors submitted them for renewal for the year 1/1/15 till 12/31 of 16. And so I'm just presenting this to the commission for their approval of these courses. As I say, they have been approved individually by the commission throughout the last 2 years as they've been presented to the commission at various times during that time.
So it's your recommendation that we approve this list?
Yes.
All right, is there a motion?
I'll move.
Motion by Commissioner Alexander to approve this list of vendors and courses. Is there a second?
Second.
Seconded by Ms. Hills. Is there discussion on the motion? Hearing none, let's vote. Oh, sorry, Mr. Bloom.
But I do have a question.
Yeah.
Like, in Negotiation Expertise LLC, which we're approving, it appears that Oliver's the only one that's approved to teach several of those courses, and as we've discussed, Oliver's passed. So how does that work if those people, do they just present another
They'll have to,
approved instructor?
yeah, they won't be able to teach that course. I think
Okay.
when they submitted it
We're
was
not
before.
approving anybody for these. It has to be an approved instructor that
Right,
would
so
have to
Thomas
substitute
Heyman was
for-
the other, I guess, approved.
But it was only on one course.
Right, right, that is correct. And they must have submitted their renewal before his death, and so they just wouldn't be able to teach the course until they submitted somebody else and they were
Actually, will
approved.
you put them on notice that they need to submit us?
I think Betsy's already told them, but we'll make sure that we tell them again.
Call for the question.
All right, there's a call for the question. Any objection to the call? I don't hear any. Let's vote. Those in favor of the motion, vote aye.
Aye.
Those opposed, no. The motion passes unanimously.
Abstained.
Ms. DeChara, who apparently is listed here somewhere on this list,
Several times.
recuses herself from the vote.
Oh, I'm sorry. I am listed too, so I better back off of that.
And Mr. Bloom also recuses himself from the vote. So the motion passes 5. David, did you
Four
vote?
of us. We need,
All right, 6.
Okay.
We have 6 ayes and 2 recusals. All right, course content delivery. Have we already had that discussion? your memo in there, you call a memo, which is 14 pages long, is it's more like
a
History
book, a
lesson.
small book.
reading between, say, Atlanta and San Francisco.
But I just wanted to make sure that, the questions were covered that
Excellent
anyone
job. Excellent
had.
job.
I don't think you need to explain yourself.
So,
I think at the last meeting you said that my concern is that we're not requiring enough hours. Is that something that you said that would have to go through the legislature?
you would like you'd like additional continuing education hours, and that's set by statute, and so that would have to go through the legislature if you wanted to bump that up.
Voted for you, Grover.
All right, let's, if you're prepared to do this, Eve, let's go to your director's report and see what we can knock out of there between now and 11:30.
Number is that?
Well, it depends on which one she starts with.
I guess I'll start with the complaints. That might be, I guess I'll just go down the.
Complaint status report.
Right.
Okay.
And that, I don't know where it is on the iPad since I'm not looking at the iPad, but the first page of that shows the total open complaints, which is 248, and we have 19 complaints cases in which formal charges have been authorized. The total closed complaints we have for the year is 122. That's for the fiscal year 7/1 of 2014, beginning 7/1 2014 through 11/30 of 2014. We've had 72 closed with no action, 5 with a letter of warning or instruction, 44 with a consent order, and there was 1 revocation pursuant to a formal hearing. The next.
I follow up on something.
Uh-huh.
So, is it your sense we're getting more complaints recently than we're used to getting?
Yes, I do think we're getting more complaints than we used to get, and I don't know if it's because business has picked up and there's more interaction amongst the people.
So, we have a standard, or I guess maybe all commissions have a standard to try to handle a complaint within a certain period of time?
Yes, we have a standard operating procedure for our complaints that set forth a number of time parameters that have to be followed at each step of the way. We have to open all the complaints unless there's a statute of limitations issue or a completely no jurisdiction issue. The entire complaint process, from the time that the complaint is opened in our office to the time it's presented to the commission by the legal department, has to occur within 180 days. And we each week get a sheet, a book, 20 pages, that show where each complaint is in the process and how many days it ticks by. So the clock stopping action, as we call it, is the point at which it's presented to the commission and the commission makes a decision. Whether that's a consent order or a letter of warning, whatever the decision is, except to defer it so that another commissioner could look at it, which is fine, except that doesn't stop the clock. The clock continues to run in those situations. So our goal, the legal department's goal, which is why I guess Keeling has been so very busy over the last 30 days, is to get all of those cases presented to the commission and have the commission act upon those within that 180-day time frame so that we meet that standard that basically was set when the comptroller's office came in and audited. And back, if some of the commissioners certainly remember, we had complaints that were 4 years old, 5 years old. People didn't even remember what had happened at that point. So it is an effort to move it along.
Oh, I have one final question about that. So if somebody files a complaint, then calls you a week later and says, I want to withdraw it, can they do that?
No, you cannot. Once you file a complaint, it becomes the department's complaint, as it were. And so you no longer are the person who filed it, the complainant. It's really no longer their complaint. It becomes our complaint. The complainant can't withdraw it. The only really the only say the complainant would ever have in it is they might be called to testify as a witness. They're not consulted about anything that transpires in the course of the complaint. They're notified at the very end of the complaint what the decision was, whether it was a dismissal or a consent order, whatever it was. They're notified of that. But they have no further role in the process.
What percent are anonymous?
Of our complaints? I don't know how many you've seen. The advertising complaints seem to be anonymous. We don't get too many other complaints that are anonymous. I mean, most of the ones that we get that are just advertising complaints.
All right, your statistics.
Yes, so the complaints, the money's collected. This month in November, we received $22,570, and you can see $21,420 of that was from reinstatement fees, and only $1,000 from consent orders. The next two graphs are the breakdown of the consent orders issued, authorized by the commission. So they don't represent ones that have been signed or monies that have been taken in based on those consent orders. These are just what the commission has authorized after hearing the cases presented in the legal report. As you know, the individual can decide not to sign the consent order, in which event it would be set for a formal hearing, or they can sign the consent order and abide by the terms thereof. And if they sign it and fail to abide by the terms, their license will be suspended pursuant to language that the legal department puts in every consent order. We have 3 people in suspension right now, I think, for failure to follow through with all the terms of the consent order in the time frame provided. But so as I say, the 2 charts set forth the monies that the commission authorized for consent orders, and then the specific areas that the commission found had been violated, and it just sort of breaks it down into a graph of the complaints that have been presented to the commission thus far, which is 156 since July the 1st. 21 involved property management, so that's about 13.5% of the complaints presented during the time from 7/1 to 11/30 involved property management issues. And are there any questions about any of that? Okay. So, statistics. I'll have to find the December statistics, which hopefully are on your iPads.
November or?
December. Okay. It says November, but it's actually, they were done November 26th, and that's why it says November on it. They were done that Wednesday before we left. And this shows that we have currently 25,346 active licensees, 798 inactive licensees, 7,336 retired licensees, 460 broker release, 46 that are suspended licensees, for a total of 37,359. And this is just licensees who are brokers, affiliate brokers, or timeshare salespersons. So this doesn't count the individuals who might work for Vacation Lodging Services as designated agents. We have 3,863 firms that are active, 186 retired firms, for a total of 4,049 firms. Are there any questions about that? If you flip through the statistics and go to the applications approved and exams taken, in November the number of exams taken were 341. Year to date, we've had 4,999 people take the exams, which is up from last year, which was 4,256 at the same time last year. So the number of individuals taking the exams overall has increased. It did decrease a slight amount this past month. Our November applications approved was 173, and our year-to-date applications approved was 3,387, for an average of 307 a month, which is up substantially over the 280 a month last year. And we do have a lot of applications coming in, so there are a number of people that are interested in getting into the business. The next page shows the exams taken by license type. So you can see that obviously the affiliate broker, they represent the largest number of individuals who have taken the exam since the first of the calendar year. And then timeshare salespeople are the next. And acquisition agents, we have a very small number of those. And brokers, we only have 415 brokers who've taken the exam since the first of the year, and compared to 3,965 affiliate brokers who have taken the exam since the first of the year. And I don't know if there are any questions about any of the numbers. Our percentage of license not renewed is 11%, which is it's been going down from the high of 24%. So our number of licenses. It's kind of like several pages back, but this is licenses not renewed. So that percentage, as I say, has gone down considerably since the high we had in April of this year.
I just quickly, exams taken by type, by license type, there's a total of 9,200, say 9,300 in 2013 at this time, and half that this year.
That's, my guess is that's probably not right, because it shows on the year to date that on 2013, that there were 4,256 at this time. So that number must be I don't think that number's correct, because we don't have that much difference. That might have been correct in 2006, Bear's favorite year, I'm thinking, because we're up a little bit this year over what we have been in the past year.
Would the broker number be correct, though? Because that's half of last year also.
Right, no, and I think that's, I need to get on PSI and check these. I think that number is not right either, because that would, those are, like, we don't have that, that's too high.
I also think that that's probably indicative of there being more teams. I think people, a lot of times, instead of starting their own real estate company, they start their own team, and they get around a lot of responsibility that way.
I mean, we have fewer and fewer people taking the broker exam. I mean, it's some months
Every
it's
month
just a handful of people, and I think that is it. I mean, some people, they're affiliates for 40 years. They're good with it. And I do think some people feel like if you become a broker, you have to become a principal broker, which is not the case. But you kind of get that impression sometimes when you talk to licensees, that they feel like if you are going to be a broker, there's no reason to be one if you're not going to be a principal broker. There's no benefit to it, which may be true. Not really. That might be the case. Are there any other questions about the statistics? If not, we can move on to
good job on all of that too.
The E&O update. The first page on the E&O update just shows what these are totals of the feeds that we have gotten, that we've received into TREC for the year 1/1/15. So these are people who are getting a jump, which we wish everyone would, on getting their E&O renewed. And you can see that from Rice, we've had 3,058, and from Williams, we've had 213. Those are just our biggest, those are the two biggest online feeds that we get, so that's why they're listed. And actually, Ken this morning gave me a new total through 12/2, and it shows Rice has jumped up to 3,804 as of, I guess, yesterday afternoon. So theirs has gone up. I mean, that's good. I wish it was 5 times that much.
Do we get any portion of that from Rice or Williams?
No.
Okay.
It goes straight to them. There was back in the day the time when the payments came into the commission and then they were sent to the insurer, but that was stopped, and so we don't get any of it. It goes straight to them. Most people pay online. It goes straight to them, and they feed directly into us. So hopefully this picks up, because the end of December is coming quickly, and we'll have to suspend the individuals who don't have E&O, who don't have proof of E&O in our office as of 1/1, who expire on 12/31, which
So-
is all the state insurance.
So if they're automatically suspended, how are they reinstated? Just by buying the E&O, or do they have to come before us?
No, if you are suspended, you'll be suspended if you do not have proof of E&O in our office at the time your E&O expires. Once suspended, in the first 30 days, you can give us proof of E&O, and you'll be taken out of suspension, and there's no further penalty involved. As of the 31st day, if you haven't shown proof, then penalty fees start to accrue pursuant to the statute. And those penalty fees continue to accrue until you show proof of E&O. And so those penalty fees don't go away. They don't disappear. They stay with you forever and ever and ever. If you continue to not show us proof of E&O, then after 12 months, your license will be revoked. And at that time, you still have to pay the penalty fee, and you have to retest and reapply. You can request a formal hearing before the commission. So it's a formal hearing with an ALJ. You can make a request to do that, but the commission has no authority under the statute nor the rule to actually waive the penalty fee, which is what most people's concern is. So that if a person comes in with a formal hearing, the cost of the formal hearing will more than likely be attributed to the individual who appears. The penalty fee cannot be waived. The only thing that could be adjusted would be the retest reapply. And so that would be the only benefit you might gain from a formal hearing. Otherwise, you have to pay the entire penalty amount and retest reapply.
So what about latitude this commission has related to the principal brokers?
So the principal brokers, under the rule and under the statute, but the rule specifically says that failure by the principal broker to make sure that all of his or her affiliated licensees have current E&O is deemed to be not being responsible for the licensees. And so they can be fined $1,000. There's a penalty fee set forth of $1,000 per affiliated licensee who has not shown proof of current E&O. So if you had a large firm, say like Mr. Steckel, and you had 177 they had 177 affiliates and 16 brokers, so almost 200 people, that could mount up if half of them weren't insured. The principal broker can, if the broker releases the person or the person shows proof of insurance within that first 30-day window, then the principal broker's let off and there's no further action taken. But it's only in that first 30 days. As soon as the 31st day hits, that principal broker will be given a penalty fee of $1,000, and they would have to request a formal hearing to come in and protest or ask for some sort of relief from the commission.
I had a affiliate who decided to mail in their E&O instead of going online. I think there was a $5 or $7 charge if you go online and pay your E&O, and mailed it in the 1st of November. And it was the week of Thanksgiving when she was just panicking that she still, even though she had plenty of time, but it took a considerable amount of time before she could produce her receipt to me, which is what I'm requesting. And that just would concern me if someone took that route at the end, and because if it was December 31st and she's standing there and she'd mailed it in 3 weeks before, I'm gonna send her license back.
And Rice has 10 states that renew 12/31, so they are going to have a lot of renewals come pouring in, and quite frankly, I don't think they can process them. I mean, I've talked to Cindy Rice Grissom about it. I don't think they really could process all of those if 50,000 came in on 12/31. So it definitely would behoove an individual to get it in as quickly as possible and get the certificate, and it'll be downloaded into our system, and just kind of check continually to make sure that it gets added to the system. So that you don't end up in a suspension situation.
Other comments about
No, it's definitely worth a little extra money.
Yes, it is. I mean, because I think that E&O online is kind of given priority, just because that's the way they get almost all of their E&O renewals is online. I mean, it's just easy to go in there, and then you can choose if you want some additional coverages. So I think that does make it easy.
All right, Ms. Maxwell, we have two items I think can be covered quickly in your report: budget and fingerprint fax.
The budget, I sent the budget to the commission. I don't know if anyone had any questions. As I mentioned before, the Deputy Commissioner Giannini and Bill Huddleston or Kimberly Whaley will come and talk to the commission about the budget and answer questions like they did last year. They'll either do that in January if we have time, or they'll do it in February. I talked to Bill Huddleston about it earlier last week. So if there are not any questions about that, we can just move on to the fingerprint fax real fast. And again, since the 1st of January, 1/1 of 2014, the statute was enacted that requires all initial applicants to be fingerprinted. And an initial applicant is defined by the rule as an individual who is applying initially for a license or retesting and reapplying. So anyone that's in that situation has to be fingerprinted, and it's an FBI, TBI fingerprint, and there's a specific process that has to be used in order for the correct information to be put in our database that we can see. The number of people that have been fingerprinted thus far is 3,431, and of that number, 705 have had some indication, which just means they've had some interaction with law enforcement. It doesn't necessarily mean they had a conviction. It just is some interaction. That's about 21%, and that has been consistent since the 1st of January when we began the fingerprinting. The number of reports with no indication is 2,886, and there have been 84 individuals who had no read on their prints, which means they got to go back and get a second set for free. And then if that doesn't work, they have to go to a paper print. So that's those numbers have really remained pretty consistent. Of the 21% that come back with an indication, about a third of those have no disposition listed on the FBI or TBI report that shows us what happened to the charge that we see. So those individuals, we have to ask for the court disposition paperwork so that we can determine whether or not it's something that would be a felony or a misdemeanor that involved the theft of money, services, or property that would cause the individual to have to appear before the commission. So that slows up some of the applications, as we've discussed before. I think that a lot of people now are getting a jump on that, and they're sending in their paperwork just from the court with it all and trying to get that to move along a little faster. So that works out better when people do that. And so that's fingerprints.
All right, thank you. Any questions for Ms. Maxwell related to her executive positions report?
Let me tell you one other thing. Or do we have time?
If you can keep
I can keep it in 5 minutes. Just
5
this
minutes,
wasn't.
I like about a minute.
Oh, a minute. Okay. Yeah. Well, this wasn't on the agenda, but just because a couple of the commissioners have asked me questions about it, anyone who had not paid their privilege tax that was due, the principal brokers that was due 6/1 of 2014, Revenue has had a hold put on their renewals. So anyone that asks you about that, that's what's happened, is the Revenue's had us put a hold on their renewals. Now, some people that won't affect till 2016 because they just renewed their license, but that'll be on there. We cannot lift it until the tax is paid and we receive a tax clearance letter from Revenue. And we haven't received any of those yet, although I understand some people have paid the taxes. If someone gets that by mistake, if they'll contact our office, I mean, really by mistake, they really weren't a principal broker as of 6/1/14. If they'll contact our office, we'll send the individual a copy of their computer printout sheet, and they can send that to Revenue, and that will take care of that issue. I mean, they'll still have to get a tax clearance letter, and we'll have to get that. But that'll at least take care of those problems that have come up when Revenue ran their report. So that just in case you get, because I know that some of the commissioners have had that issue come up. And so that was fast.
Does that put their license in suspension?
No, it really does not, because that's the statute doesn't authorize suspension. So it really just puts a hold on their renewal, which is why I say it won't affect some people for a little bit of time. But it's getting interest the whole time, as you know. So it might be $1,000 before. Like, they just need to go ahead and pay it, probably.
All right, any other, Mr. Bloom?
Well, just one quick comment. I think we need to think about if there's a lot of real estate companies out here do not know what you just said, that there are 10 companies or 10 states who have to renew by 12/31. And so if they accumulate all these checks and send them to Rice, and they send them the 15th day of December, and they think they're doing well, it will not be processed till January. And I do not think it's our purview to fine those people for something Rice did.
Well, I mean, Rice obviously is, I mean, Cindy, I've talked to her, they'll endeavor to get it all done. I'm just saying, if you wait till 12/31 to get online and pay, there's a chance that those won't be
understand that,
processed.
but if what I said is true, we still should not fine those people.
Well, I mean, that would be the commission's decision, and the statute, well, yeah, I think I'd have to defer to the legal department to look at the statute
I
and
thought
see
you
what.
said we didn't have the right to do that by statute.
Well, I mean, you don't have the statute says they shall be suspended. So I think it would, yeah, I think we'll have to see. I mean, I'll talk to Cindy about that. I mean, we've discussed about the fact that it does say shall, and they need to have proof of insurance. But they would also, well, if they're sending it by mail, they won't have otherwise you'd have a certificate when you paid, but by mail you won't. So I'll check with her again about that, particularly since you had that situation.
I just know some
come up.
companies do that. They would rather collect all the checks and make sure that all their agents are covered, and then they wait on the last one to get in. If it's the 15th, they're not going to be covered by the end of the year.
And as I say, in light of Commissioner Hill's person's experience, I'll talk to her. I'll talk to Cindy Rice Grissom specifically about that, just to make sure that they process those in a timely fashion.
So it's like they're a subcontractor to us, so they're going to need to take care of that, or, I mean, it's like any other vendor. If they don't do what's needed, you have to look somewhere else the next time.
I'll say something. I just got a text from Austin, and he said that Gary Cunningham died.
Did he really?
Yeah. Just want to pass that along to the rest of the commission.
All right, any other questions for Ms. Maxwell? I think it's close enough for me to say it's 11:30. We'll be back at 1:30, and we'll work until we're done. So have a good lunch. Enjoy the city. See you soon. I see the chairman has finally arrived, so we can get this thing started.
Where's he been?
He was having to do a little high finance. So before we get started on the legal report, Commissioner Bloom earlier today mentioned a rulemaking hearing, or how we're going to handle rules in January. And so I've asked counsel, Ms. Baird, for lack of a better last name at this point, in general, how do you see this going down next month as far as the rulemaking goes?
Okay, so it's my understanding that whenever we get the transcript back, which is supposed to be today, then we will work together to compile all the information from the verbal comments, the public comments, align those with the rules that they go with, so that when you guys look at it, it won't be all jumbled. It'll be in a good, tight little, and then at that point, I guess at the January meeting, if you guys have comments, then you would make them based off of what we give you.
Is it the role of the commission to address every comment that we got?
I don't think that you have to address every comment. I think that if there's something that you want to comment on, then you can, but I don't think that it's necessary to go through and comment on each one. That's my understanding.
We're just obligated to hear them.
I
John?
thought we had to respond to all of them.
Know how we'd like to do it, but I was with you on that. So, just to follow up until we get some other questions, so we'll take say there are 10 rules that we're considering, new or amended rules. We'll take a rule at a time, see if the commission has any comments following the public comment, and if we don't, or if we do, we're going to vote on each one of those rules again before it goes back up to the Secretary of State. Is that right?
Yes.
Okay.
Before it goes to the Attorney General.
Right, well, it has to go back to the Attorney General and then back through the Governor's office and then to the Secretary of State.
Okay.
They've already done a pre-review of everything, but they have to do a re-review after everything's adopted.
Did you want a copy of the actual transcript of the hearing? Is that? I mean, I don't know how, sometimes it's been really
I've just,
large.
Yeah, it's voluminous.
I've just been mulling over that, and I just thought it'd be good if maybe, I mean, we had 5 people comment, but we had 100 with their mouth, but we had 150 people comment with their feet. And I want us to take notice of that. I mean, these are issues that will greatly impact some companies, and maybe it needs to. But I also want us to give careful thought to all that. And I mean, one fella in his written comments gave us a picture of his signage, which I don't believe is in compliance. But if you just think about it, what I really care about is that the public knows who the brokerage operation is and who the agent is that works for him or her. And then I could be happy.
Well, without getting to, it's really not an agenda item at this point, other to discuss the merits of it, but I want to make sure we get the material that you want so that you can help make yourself an informed decision.
Yeah, that's fine.
That's what I want to make sure of. So if the copy of the transcript will do that.
What she's going to do, we're getting in the next few days, correct?
Well, the transcript will hopefully by today. So by the end of the week, I would say that we would start compiling all the information.
So do you want the whole transcript or the compiled?
What she's asking is, do you want a copy of the complete transcript along with what we compile?
I think I would like to see the whole transcript, just so that if there's something I have question about, maybe clarification-wise, to go back through and read it, because you're not going to compile it in its entirety, right? You're just going to kind of summarize it?
Right, we wouldn't, well, the only thing that we would really be compiling would relate to the comments, is my understanding.
Well, so, not the written comments?
Yeah, well, right. There wouldn't be really any need to go back through the entire.
We would be responding, I mean, we would be writing a little write-up, I think, about the written and oral comments, because the written ones were just.
In which rule they pertain to.
Right.
Yeah.
I think the instruction from this commission was that we ask you to go through this, each one, and then compile and make a summary of all of it. I don't want the entire thing. I want the summary of what just a synopsis. I ain't got time to read all that. I heard it before, so don't send me the complete list. But I want to see what you all think about it, and then I'm sure we will all have some difference of opinions from there.
So, are you wanting the attorneys to give an opinion on it?
I just want them to. No, I don't necessarily want their opinion. I just want them to tell us what, in a nutshell, what 4 paragraphs was in 3 sentences.
Maybe 2.
So realistically, if there are 10 rules, we got comments on 2 of them. Okay, so 8 of them may be pretty easy to handle. No comments. So we might have 2 rules that we got a lot of comments on, and many of those comments might have related to 3 sections or 4 sections of that particular rule. And in my mind, what I would like to get are a summary of those comments and the potential rule and the subsection of that rule. So This is what people said about this.
Yeah, that's the idea. That's what we're thinking we were supposed to be doing.
Meantime, it's on YouTube if you want to sit through that rulemaking hearing again. All the comments are there. You do your voice for hours on that. So, but with that said, I think whatever any individual commissioner would like to have, they ought to get. So if
Right,
you,
I agree.
and if
I would like my copy to be sent to Janet.
Does that mean I have to read it twice, Grover?
Yeah.
So who does want a full transcript of the, I mean, unless it turns out to be, we might have to reconsider, but.
you can send an electronic version,
Yeah.
can't you? Send it electronically.
So who wants a full copy?
Now,
Slept since then.
typically, since I'm 1 year old on this commission, how long does this take with 10 items?
Do what?
Nothing.
We've done the hard work on it. I mean, the commissioners are going to have one last chance to say, let's change this, let's delete this, let's add this.
Right, and some, like he said, there may not be any discussion on some of them, so
Most-
we could just breeze through those and then hit the high points
Right.
of the controversial issues.
Well, my concern is that I'm not going to be here, and I'm wondering, would it be, if it was not for hours, would it be possible for me to join in by phone?
Problem with that?
Right, I mean, we allow for, allow for telephonic communication.
Sitting down there on the beach and us up there. You will, Wendell? She's
All
up
right,
there on the beach.
I'd
If
rather
we,
be on the beach, but if I do, I don't want no phone.
So who wants the full transcript?
I guess just me.
And Gary?
Gary, no.
Does not? Okay.
All right, so Gary, have we addressed generally what you want to talk about in this issue without going into the merits of any particular rules?
That's fine.
Okay, I'll make sure we got that clear. It's not on the agenda, but I want to at least address that, because we all need to anticipate what this is going to look like a month from now. All right, at this time, Ms. Baird, we're going to start with the disciplinary action report. Is that right? Is that what you're ready to go?
Legal report?
The legal report, that's
I
what
was like, oh, I don't have the disciplinary
Legal.
report.
Now,
Yes.
So, to the audience, monthly, the Real Estate Commission gets dozens of complaints. Legal department has to present those complaints to this commission. And they have to present them to us in a fashion so that there's no way this commission or any of you people in the audience know who they're talking about. It's just a complaint. So once Ms. Baird reads the complaint into the record, she'll make a recommendation on what we should do with the complaint. And we can take her recommendation, we can reject her recommendation, we can modify her recommendation. That doesn't mean the person that the complaint was filed against is guilty of anything. It just based on the information, I don't want to liken it to a grand jury, but it's sort of like that. If it were true, then this is what we think should happen. At that point, assuming there's some disciplinary action, the law department will take it to that respondent, the person who had been complained against, and said, will you agree to this? And if you do, pay this fine, come to these classes, and we'll be done. They don't have to agree to it. And that's what you'll see tomorrow is a guy, I guess it's a guy, we don't even know, I do know it's a guy, who said, no, I won't agree to that. And so he's requested and is fully entitled to a formal hearing, which we'll have tomorrow to work out whether this commission thinks he's violated a statute or rule of the commission. So today is information we're learning for the first time. We've been given written copies. We have no idea who they're about. If staff thinks we might have some relationship, they'll tell us in advance, don't vote. They don't know for sure if we do or not, but we are hearing these for the first time, talking about them for the first time today. And Ms. Baird will read those into the record, and we'll try to make sense of them. Let's get started. And we've got a lot of them to go. We got 50-some complaints.
55.
55.
And they're lengthy.
All right, let's do it.
Okay. Item number 1, 2014007761. Oh, I forgot this part. Any consent order authorized by the commission should be signed by respondent and returned within 30 days. If said consent order is not signed and returned within the allotted time, the matter may proceed to a formal hearing. Okay.
Let's get a little closer to that microphone. I know it's going to be tough, but That's great.
Or talk louder, use your outdoor voice.
Okay. So item number 1, complainant alleges that respondent, affiliate broker, stole escrow monies in the amount of $299,648. Complainant states that respondent assisted in 2 condominium purchases for complainant's children, and their business relationship expanded from there. Complainant itemized escrow money stolen from approximately 34 transactions, including new construction loans, apartment complexes, and subdivisions. Complainant included in the complaint copies of checks cashed and copies of purchase and sale agreements, as well as an email from respondent with a promise to repay the money. An incident report for charges of fraud, false pretenses, and swindling was filed on January 22nd, 2014. Respondent submitted an answer to the complaint through an attorney denying theft of escrow monies for the 34 transactions listed, denying that copies of cash checks are evidence of theft, denying the email attached shows that respondent apologized for stealing complainant's money, denying that an incident report constitutes proof of accusations. Respondent states respondent met with the detective to explain the situation and notes that there are conflicting amounts claimed to be stolen between the incident report and the TREC complaint. Respondent states that complainant and respondent had business dealings for approximately 5 years beginning in 2009, that over that period of time there were approximately 70 transactions discussed. Respondent states that they engaged in transactions including personal loans, joint enterprise to flip real estate, financing construction, and respondent acted as affiliate broker in the closing for 2 transactions. Respondent states that a majority of the transactions were conducted as a business partnership rather than as an affiliate broker. Respondent states that complainant is aware that earnest money checks must be made out to real estate companies, and the checks included in the complaint are made out to respondent for payments of services as a member of their joint enterprise and included some capital for their projects. Respondent submitted an IRS 1099 form where this income was claimed by respondent as non-employee compensation. Respondent further states that these monies constitute business losses and no business venture is guaranteed. Respondent further admits that personal loans were received by complainant, and those checks clearly stated loan and are reflected by promissory notes. Further, respondent states that complainant received financial benefit of at least $500,000 pursuant to their joint enterprise. Respondent provided documentation for 2 real estate transactions that were closed. In both transactions, complainant is the buyer and respondent's firm is listed as selling company and respondent as independent licensee. Proper confirmation of agency status executed. Respondent was not the holder of the escrow money in this transaction. Legal counsel requested an investigation, and the investigator made contact with respondent's attorney, but respondent's attorney did not provide copies of the requested documentation. The investigator also acquired a copy of the police report filed by complainant against respondent and stated that investigation has been turned over to the District Attorney General for presentation to a grand jury. The recommendation in this matter is a litigation monitoring consent order.
Is there a motion?
Move to accept council's recommendation.
Second.
I have a motion by Commissioner Frank, seconded by Commissioner Collins, that council's recommendation be accepted. And I'll only ask you this once, but what does that mean? What does your recommendation mean, so everybody knows?
Basically means that it's kind of like a regular consent order, but in this case, it's called litigation monitoring because it's basically just a way to monitor any pending cases that are going on outside of hours, and it basically asks the parties to turn over any documentation that comes about in those cases so that we can keep track of what's going on.
With the hope that at some point this thing is litigated?
Correct.
At which point it'll come back to us?
Right. It's kind of just a way to ensure that we get all the information that we can before we make a decision.
It does come back to us.
Right.
Eventually.
It will come back to
What
us.
about a time limit on this? When you get to dealing with Attorney General, they may not pursue it for 6 months or a year?
Well, I can say that sometimes things are continued, and it does take a little longer than what you might hope, but we don't have a lot of control over that, so we're just trying to make sure we get all the information that we can before we make a decision as a commission.
Other questions?
Is swindling a charge? Or is there another word for that?
You know,
Just
that's
theft?
funny that I think it probably is just theft.
Okay.
Eve, you might know something
I don't know
more
why I
about
needed to
than
know
do.
that. I just needed to know that.
I've never actually heard of it
It's
called
kind of a southern
swindling,
word.
but yeah.
Okay.
All right, I sense we're ready to vote. If you're in favor of the motion, vote aye.
Aye.
Those opposed, no. The motion passes unanimously, and we'll move to item number 2.
Okay, item 2, 2014-007821. Trek opened a complaint against respondent, principal broker, for failure to supervise respondent in case number 2014-007761, hereinafter affiliate broker. Respondent was affiliate broker's principal broker from July 17, 2003 through July 5, 2013. Respondent states that when affiliate broker began with the firm, affiliate broker did well, but beginning in 2012, affiliate broker was slow to bring in files but eventually brought in all paperwork. Respondent states that affiliate broker continued to sell a lot of property and sold 72 properties in 2012 without any problems with earnest money or any other problems with those properties that were closed with affiliate broker and the firm. Respondent states that affiliate broker mishandled earnest money regarding one closing in early 2013, and although affiliate broker ultimately returned the earnest money before the closing, affiliate broker was reprimanded by respondent and told not to do it again. Respondent states that respondent received a call from a title company in June 2013 and found that affiliate broker once again mishandled earnest money. Although the earnest money was replaced at the closing, respondent immediately released affiliate broker. Respondent states that affiliate broker's dealings with complainant in case 2014-007761 were hidden from respondent, and previous complainant never contacted respondent to investigate any problems. Respondent states that affiliate broker told respondent of a partnership with previous complainant to buy foreclosures and fix them up, but affiliate broker never notified respondent of any homes purchased or sold, and respondent assumed the partnership fell through. Respondent states that affiliate broker hid these business dealings from the new principal broker as well. Respondent states that had respondent known of affiliate broker's dealings with previous complainant, it would have been addressed immediately like the June 2013 earnest money issue. Respondent states that respondent has been a broker since 1995 and a principal broker for the same firm since 1998 with an average of 45 agents over the last 10 years without complaints. Respondent holds regular office meetings discussing Trek rules and ethical business dealings. Respondent states affiliate broker was trained properly and hid the business dealing with previous complainant. Respondent further submitted a Trek Form 1 showing release of affiliate broker on 7/5/13. Respondent met with the investigator, and respondent denied having knowledge of any transactions between affiliate broker and previous complainant and reiterated respondent's response previously submitted to Trek. The recommendation in this matter is a litigation monitoring consent order.
Motion to approve council's recommendation.
Second.
Motion by Commissioner DeChara, seconded by Commissioner Hills, that council's recommendation be adopted, which means we're going to pay attention to this case just like it's frankly the same case as the last one,
Right.
just with the principal
And
broker.
so does this mean that we know that litigation is taking place?
Correct. As far as we know, up till this point, there is something going on that
Okay.
we just are trying to monitor.
Other questions? Let's vote. Those in favor of the motion, vote aye.
Aye.
Those opposed, no. That motion passes unanimously. Number 3.
Item 3, 2014-007841. Trek opened a complaint against respondent, principal broker, for failure to supervise respondent in case number 2014-007761. Respondent was affiliate broker's principal broker from 10/23/13 to 6/3/2014. Respondent submitted a response stating that the allegations occurred prior to affiliate broker joining respondent's firm. Respondent further states that complainant in case number 2014-007761 contacted respondent on 4/24/2014 prior to receiving the complaints from Trek. Respondent states that respondent had no knowledge of the transactions that occurred between the affiliate broker and previous complainant prior to that date, and respondent's office does not have contracts or copies of paperwork or any other documentation since affiliate broker was not under respondent's supervision at that time. Having reviewed the supporting documentation supplied by previous complainant, it appears to the Office of Legal Counsel that these matters occurred between December 2011 and August 2013. Respondent met with the investigator and acknowledged respondent's response resubmitted to Trek. The respondent restated that no transactions involving affiliate broker and previous complainant were done under respondent's supervision or through the firm. Recommendation is to dismiss.
Let's get a motion.
Move to dismiss.
I got a motion by Commissioner Frank, seconded by Commissioner Collins, that council's recommendation be adopted. Ms. Hills.
I have a question. So if we're waiting, so this is connected to the previous two, and if we're waiting for information for that, if we dismiss this and something does leave, because people's habits don't change, we will have dismissed this, right?
Correct. Well, yeah, we would dismiss it as to this particular respondent, because from what we can see, from what I understand, everything that happened prior to this person coming on board.
We have a TREC form to that effect? And that's pretty simple.
Well, the TREC records reflect when this person became the previous respondent, the affiliate's principal broker. So our records reflect what he's saying here.
And I understand, but I would think that from October 2013 to June 2014, if the allegations have any merit to them, and they must have something, I don't see someone changing their behavior when they're with just a different company for 8 months.
Right, and we base everything off of what the complainant is stating, and the complainant already terminated their relationship with the affiliate broker before the affiliate joined this principal broker's firm. If that
With that said, if something is learned in a trial, for instance, it doesn't preclude anyone
Right.
from bringing another complaint at that
And
point.
TREC could.
And TREC could as well.
Too. Okay. All right. I'm okay with it.
All right, the motion on the floor is to dismiss. Any further discussion?
This is not like when someone in court is found guilty and you can't ever bring it back, is it?
No.
So we could bring something else back.
Correct.
If something comes from it. Okay.
Okay. I'm all right with that.
Any other questions? All right, let's vote. Those in favor of the motion vote aye.
Aye.
Those opposed, no. That motion passes unanimously. Number 4. I'm sorry, is that right? Yeah, number
Yeah.
4.
4 and 5.
And 5.
Item 4.
And 6.
Yeah.
Now,
Excuse
this
Um,
me.
is the one I'm to report on. Do you want it read
No.
again?
Well, let's just,
Okay.
yeah.
All right.
Do you want me to read everything that's already been read? Just read it again? Okay. No, it's fine. Doesn't matter to me. Item 4, 2014-012-931, and item 5, 2014-02, no, 2014-012-932, and item 6, 2014-012-933. At the November 2014 meeting, these were the facts that were presented. Complainant was a potential buyer, and Respondent 1 was complainant's agent. Complainant states that an extension was filed without complainant's authorization or signature. Complainant states that Respondent 1 alleges complainant signed the contract. The complainant states that Respondent 1 was advised over the phone that complainant would not sign another extension. Complainant states that upon receiving the paperwork, a copy of the extension with a settlement date of August 15, 2013 was included, but it was the first time complainant had seen that extension. Complainant states that the settlement date on the form signed by complainant had been whited out. Complainant states that in order to receive the earnest money, complainant had to sign a contract releasing Respondent 1's firm from all liability, so complainant did not sign the form and has not received the earnest money. It appears that the contract was a cash transaction, with the seller being the Secretary of Veterans Affairs with a $500 earnest money deposit to a title company in Tennessee. There are also 2 extensions in the file that are signed by complainant on July 16, 2013 for a settlement date of July 29, 2013, with a written end date of July 30, 2013 initialed by complainant by the change date, and a second extension that is signed by complainant on July 16, 2013 for a settlement date of August 15, 2013, which does not contain initials next to the change date. There is also email correspondence provided between complainant and Respondent 1. An earnest money disbursement and mutual release of purchase and sale agreement was prepared for the earnest money to be returned to buyer, with the explanation, unable to close house in buyer's specified time frame, but it was not executed. Respondent 2 submitted a response stating that Respondent 2 is Respondent 1's principal broker for Tennessee, and Respondent 3 is Respondent 1's principal broker for the neighboring state. Respondent's offices are located in Tennessee. Respondent 3 submitted information stating that Respondent 3 is responsible for licensees of the neighboring state and was responsible for supervision of this transaction. Respondent 3 states that when the issue was brought to Respondent 3's attention, Respondent 3 recommended returning the money to complainant, that the proper paperwork was prepared, that complainant would not sign the release paperwork, and that the earnest money is still with the title company. Respondent 1 states that during a telephone conversation with complainant agreed to a final extension of August 15, 2013. Respondent 1 states that a co-worker who handles offers and extensions, who is also listed on the contract as the listing agent, made the change to the extension date, and Respondent 1 sent the form to complainant to initial by the date change. When complainant did not want to close, Respondent 1 states that Respondent 1 checked with the company that handles VA foreclosures regarding the earnest money, which initially refused to return the earnest money due to the second extension. Respondent 1 forwarded copies of the extension paperwork to complainant at complainant's request, and complainant contacted Respondent 3 stating that the second extension was not properly executed. Respondent 1 states that it was determined that a mistake was made and the extension form uploaded was not initialed by complainant regarding the change date. Respondent 1 states that release forms were sent to complainant from the coworker and the company that handles VA foreclosures, which provided for the earnest money to be returned to complainant upon signing the document. Respondent 1 states that complainant refused to sign. Respondent 1 states that the earnest money is being held at a title company in Tennessee, and it will be released upon complainant's execution of the earnest money release. Although the earnest money is still being held, it appears that the contract authorized the title company to hold the earnest money funds, and the title company is holding those funds, and the broker is relieved of responsibility per Rule 1260-02-095. The previous recommendation was to dismiss, and at that time, the commission voted to defer this matter to allow Commissioner Hills to review the file and report at the next meeting. So now the recommendation is for Commissioner Hills to discuss.
Let me tell the audience quickly, this is, the commission had enough questions about this after hearing that narrative last month that we asked, and Commissioner Hills graciously agreed to go into the file, and she's going to report to us today. However, she has knowledge that will preclude her from making a motion or voting. She's here basically at this point to tell us what she learned. Ms. Hills.
The complainants alleged that the agent amended the contract by whiting out the date from a previous amendment, which was extending the closing. And it appears clear to me that that's what was done on the date, so they just whited out the one thing. This property is in Kentucky that was sold. The broker and the agent that had the buyer both stated that the Kentucky broker was the one supervising. The listing agent and the buyer's agent, designated buyer's agent, are in the same office in Tennessee. The purchaser, there was a designated agency agreement and a confirmation that covered it. And as a designated agent in the contract, it says that if someone else in the same office, the agent will is in the same office, the agent will continue to work as buyer's advocate, which in this case was correct. In looking at the designated buyer's agreement, it says that the individual license has been assigned by the managing broker. So they used TAR forms, and of course they could use their own forms, they could use anyone's forms. They used TAR forms, they did not use Kentucky forms, and the broker listed, not by name but by address, was the Tennessee location, the Tennessee office location, not the Kentucky office location, even though both the Kentucky broker and the Kentucky agent that had the buyer, they did not list the Kentucky address.
the confirmation states that code 6213 -312 that the confirmation upholds that code, and that leads the public as to where and who they're to file a complaint against, and that's on the confirmation. So those forms were used. They could have used something else, but the buyer chose to use Tennessee forms. Anybody have any questions?
The house is in Kentucky.
House is in Kentucky.
Tennessee agent.
And they have a
Come up that
Kentucky
microphone.
license too, both
Tennessee and
and a Kentucky. But they use Tennessee forms, and in using those, it references the Tennessee codes with agency, with everything. And on the buyer's agency agreement, it references the Tennessee office. In the statement, it says that the buyer's agent and the Kentucky broker both said that the Kentucky broker was supervising it, yet it references it in the buyer's agency agreement with the Tennessee office. But there's nothing that really indicates that the Kentucky broker was doing any. In the statement from the Kentucky broker and from the Tennessee broker and from the buyer's agent, the designated buyer's agent, the only time the Kentucky broker was referenced was when we learned of the complaint. I instructed not to have communication with the complainant, and took responsibility. Said I'm responsible for supervising.
The earnest money was where?
In the title company.
In what state?
I don't think it says. I think it is Tennessee. I think it's a Tennessee. The name is Tennessee Title Company. Hold on. Well, because they use the Tennessee form, it says that's where
I can't help what the form says.
I know.
I'm a Tennessee, Kentucky broker myself. I have to maintain a Kentucky escrow account.
It was deposited in Tennessee Title Service in Tennessee.
Can I ask this question? Was the complaint filed because they can't get their earnest money back?
No, they're able to get their earnest money back if they sign a release. The complaint was that a document extending the closing date was whited out.
So we're not dealing with earnest money so much as we are that issue right there.
And it jeopardized them and
So a forgery on this contract.
And you made the statement that it was clear to you that likely happened. All right, are there other questions, or is there a motion?
And one more statement to that. The buyer's agent did not state that she did it, that the buyer's agent did it. They stated that the listing agent is the one that is the team is the one who's in charge of all extensions from the office, and I'll read you the statement. So having that listing agent be the one in charge of all the extensions made me, I don't know how you could have been a good buyer's agent. Go ahead.
So the complaint was filed against the person identified as a designated agent for the buyer?
Yes.
And it's clear to you that there was some forgery, whiting out, something like that? All right, other questions, or is there a motion?
Yes, I'd like to provide a motion that there's a violation of 62-13404, Section 2, which says to be loyal to the interest of the client, a licensee must place the interest of the client before all others in the negotiation of a transaction.
So would you like to make a recommendation as far as a civil penalty or other requirement?
yes, $1,000, and visiting us within 180 days for.
All right, the motion, as I understand it, made by Commissioner Bloom and seconded by Commissioner DeCharo, is to offer to the respondent a civil penalty of $1,000 plus attendance at a full commission hearing within the next 6 months. Ms. Breeden.
Which respondent are you referring to in this situation?
One that whited out the contract.
The designated agent.
Right,
buyer.
designated agent.
That's the affiliate, isn't it?
Yes.
Well,
Then
I'm gonna ask you, where was it, Ms. Bloom, where was the principal broker?
failure to
Not
supervise.
reviewing it,
Well,
and failure to supervise.
Let's
That's
handle one
number
licensee
two.
at a time.
Okay.
Right now, I've got a motion related to the affiliate broker. And the motion is to assess or offer a civil penalty of $1,000 plus attendance in the next 6 months at a full Tennessee Real Estate Commission meeting. Is there discussion on that motion? I hear none. Let's vote. Those in favor of the motion vote aye.
Aye.
Those opposed, no.
I abstain.
Okay, so I've got a vote of 5 ayes, 2 abstentions, and the motion passes. Now, Mr. Alexander, back to your point.
We come back and you've got a principal broker for failure to supervise. So my motion is that you fine him $1,000 or she $1,000 for failure to supervise.
Was there a complaint filed against the principal broker too?
Yeah.
Is that the Tennessee broker or the Kentucky broker?
That would be the other question. The principal brokers are both listed on here, so the one principal broker, number 5.
How do you have two principal brokers?
One's
Kentucky and
Kentucky, one's
Tennessee.
Tennessee.
Oh.
So respondent 2 was the broker's PB for Tennessee, and respondent 3 is the PB for the neighboring state, and respondent 3 stated that respondent 3 was responsible for the supervision of this transaction.
We're talking about 2. 3, what did 3 do? If it's a Kentucky broker, was he the listing agent or she
No,
the listing agent?
just the Kentucky broker. And on the buyer's designation, the buyer's agreement, for a designated buyer's agreement, when you're a designated agent, it references the broker, and on the last page where the agent signs it, it listed the Tennessee office address, not the Kentucky office address.
Was 3 a member of that firm, even though he was a Kentucky broker?
Yes.
In other words, all of them was in the same firm then.
Yes.
One of them had a Kentucky license but did not have a Tennessee license. The other 2 had Tennessee and Kentucky
I
license.
think they all had Tennessee licenses. Am I wrong?
Pardon?
You're
I
correct.
don't know if the Kentucky
They're all
broker-
licensed in Tennessee. In the headings, you can see when they were first licensed here.
Licensed as a broker in Kentucky.
Yeah.
That's the reason they brought him on board.
Well, maybe they both
That
need a
firm.
failure to
That's the
supervise.
only reason he's brought on board.
Because neither one of them were really supervising, so maybe they both should be.
One of them could be a broker, not a principal broker. You can't. Why would you can't have 2 principal brokers in the same firm?
Well, they both are principal brokers. They're just one's a Kentucky principal broker and one's a
So that's two different
Tennessee.
firms.
No, it's the same firm.
That'll be 2 different firms.
Be two different licenses then.
And what
Yeah,
I
it's two different
have, I don't know that the Kentucky broker has a Tennessee license based on what I have. I have the letter
But they're
and
saying
things.
they did.
Okay.
Are you saying that all 3 of them are Tennessee licensed?
Yes.
All right, let's work through this. So let's start with the Tennessee principal broker, Mr. Alexander. Let's talk about that broker,
Where's Mud?
which I believe is
Respondent
respondent 2.
Yes.
What are your thoughts, or is your motion related to that principal broker?
My motion is related to him if he's a principal broker of that firm.
All right, so you got a
Because
motion.
he's supposed to, if they're mixing apples and oranges when you go to crossing that line, John. You're a Kentucky broker, and you know that you're gonna have to keep your money in the state where it is if you're a Kentucky license. There's another infraction.
Well, I might argue that point, but we're not talking about that just right
Okay.
now. Your motion has to do with respondent number 2.
Oh, you're the
Principal
supervisor.
broker, Tennessee principal broker.
True.
And you offered a $1,000 civil penalty and attendance within 6 months at a full commission meeting, is that correct?
That's correct.
And who seconded that motion?
will.
Mr. Bloom seconds that motion. That's what's on the floor at this point. Is there discussion about the motion offered by Commissioner Alexander, seconded by Commissioner Bloom? All right, I hear none. Let's vote. Those in favor of the motion vote aye.
Aye.
Those opposed vote no.
I abstain.
And one abstention, Ms. Hills. Now, we've got another principal broker that's at least a Kentucky, licensed in Kentucky principal
But there's
broker.
no office over there. Is there an office in Kentucky? That firm got an office in Kentucky? Huh?
Yes, they do have an office in Kentucky. It's
And
like the firm has the same name, but they have a Tennessee office and a
I don't
Kentucky
believe you
office.
can touch
and
him. If
two
he's got a
different
Kentucky license, that's a Kentucky infraction.
He's got a Tennessee
Oh, he's licensed in
license,
Tennessee,
too.
though. He's got 2 licenses. I forget that. Yes, you
There-
can.
Yes.
Yeah.
What's your pleasure, Mr. Alexander?
He didn't sell, what did he do?
From all I read from his statement and the designated agent for the buyer,
He was the designated agent for the buyer?
he was the broker for the designated agent for the buyer because of Kentucky, even though the even though the codes are stating the responsibility is Tennessee license.
I want to make a motion that we find him also $1,000.
All right, we have a motion by Mr. Alexander that, is that respondent 3 we're talking about now, ladies?
Yes.
Okay. That respondent 3 be fined or offered a civil penalty of $1,000 and the opportunity to attend a full commission meeting within the next 6 months. I heard a second, I believe, from Commissioner Chara, which puts the motion properly on the floor. Is there discussion on that motion? All right, I hear none. Let's vote. Those in favor of the motion vote aye.
Aye.
Those opposed, no.
I abstain.
It's unanimous with one abstention by Commissioner Hills. Do you have another motion, Mr. Alexander? You think we've got them?
Violation.
What, earnest money?
Yeah.
We'll talk about that at a later time.
Okay. This
'Cause
let go.
I might be in violation myself, and I just don't want to do it in public.
I just know I have to maintain, I have to show proof to contain my license.
I have to have an escrow account in Kentucky, but I don't
Yeah.
have to put money in that account. That's all I'm saying.
Well, you don't have to, but if you better use a Kentucky lawyer, you don't need to use a Tennessee lawyer.
As long as the buyer and seller agree where they want to put it, it's okay with me. It's the way I think about it, but that's just me. All right, let's get on with this.
Sounds
Is
like
there-
y'all
are
need a
there-
lawyer.
Are there other motions related to this complaint? Are we done with this complaint? Anybody have any other comments? Thank you to everyone, especially you, Ms. Hills, for taking that on. I know it's a little bit of a challenge when you just have to dig through a file and be careful that you talk to. All right, so that puts us on numbers 7 and 8.
Okay. Item 7, 2014-013-991, and item 8, 2014-013-992. Complainants allege that respondent broker willfully neglected duties as an agent, attempted to profit from the neglect, and lied under oath to cover it up. Complainants state that respondent drafted an offer to purchase a home and attached an exclusive buyer's representation agreement to the e-sign package without notifying complainants of the agreement. Complainants state they previously declined signing a buyer's representation agreement, and complainants state that 2 judges ruled against respondent and awarded damages to complainants under the Consumer Protection Act. Complainants state that after the buyer's representation agreement was signed, respondent made no attempt to contact complainants but monitored their house hunting process on social media accounts. Complainants state that they closed on a home 4 months later with another agent, and respondent's firm filed a lawsuit to recover a commission and legal fees, contending complainants violated their exclusive buyer's representation agreement. Complainants allege that respondent never discussed the buyer's representation agreement with complainants, never confirmed the buyer's representation agreement in writing, and included the document electronically into a package of previously reviewed documents for electronic signature without informing complainants in violation of Rule 1260-02-.36. Respondent submitted a response by and through an attorney stating that respondent corresponded with complainants about homes they were interested in, and before showing the homes, respondent discussed the office policy, stating that a buyer's representation agreement must be signed before respondent could present or negotiate offers on their behalf. Respondent states complainants refused to sign an agreement stating that complainants wanted to work with respondent in one county and another agent in a neighboring county. Respondent agreed to show complainants properties that day, but advised that respondent would not continue to work with complainants after that without a buyer's representation agreement. Respondent states that after that, complainants requested to see 2 additional properties in the neighboring county and advised respondent that complainants fired the other agent. And respondent was under the impression that complainants were only working with respondent and understood the requirement of signing an exclusive buyer's representation agreement. After working with complainants over the next few weeks discussing many properties, respondent prepared an offer that complainants reviewed and approved, so respondent sent them a plethora of paperwork to sign electronically. Respondent states that all documents were viewable, including the representation agreement, and the documents could have been downloaded after signing. Respondent states the sellers of the property counter-offered. Complainants rejected the offer, and complainants told respondent that they would contact respondent to resume their search once they were settled in their rental. Respondent states that complainants inquired about 2 more homes a couple of weeks later, but a mutual friend advised respondent that complainants bought a home in their neighborhood, though respondent knew nothing of the contract. Respondent states that complainants closed on the home a few months later, and the firm sent a demand letter for payment of commission and later filed a civil lawsuit for breach of contract. Respondent states complainant filed a counterclaim for breach of fiduciary duty, negligent misrepresentation, and negligence per se for violation of TCA 6213-404. Respondent states the trial court dismissed the claims without a hearing, and the matter was appealed with counterclaims filed by complainants with an additional claim that respondent violated the Tennessee Consumer Protection Act. Respondent states that the judge initially dismissed the firm's claims and found that respondent had not violated the Consumer Protection Act, but later the judge sent an order requesting further argument on those claims. Respondent states that following the hearing, the judge found that respondent created confusion and misunderstanding with respect to respondent's authority as the complainant's agent, as well as the authority of other agents or sellers with whom the complainants dealt while negotiating the final terms of a consumer transaction. Respondent states the firm filed a motion to alter or amend the judgment, which has not been heard. Respondent states that the judge found that complainants did not read the documents they electronically signed and held that there was no meeting of the minds with regard to the buyer's representation agreement and did not enforce it upon complainants. Further, with regard to respondent engaging in fraudulent or deceptive practice, the judge stated, to do that I would have to, in fact, credit respondent with guile that I do not find myself willing to credit respondent with. There's been further court action, including a motion that has not yet been heard. Respondent further requests that TREC give an interpretation of their Rule 1260-2-.36 regarding whether or not respondent advised and or confirmed the required disclosures which could be pertinent to the pending civil action. With regard to complainant's allegations that respondent failed to obey complainant's instructions in violation of TCA 6213-4041, respondent states that the firm believes they had a valid contract, but alleges that complainants cannot simultaneously claim that the buyer's representation agreement is unenforceable and that respondent breached fiduciary duties under the Brokers Act. Recommendation is to dismiss.
Chairman,
Mr. Alexander.
I move that they be offered a litigation or the monitoring consent order.
Okay. Is there a reason to think this is going to court or is in court?
That's pending civil litigation.
Well, the judge, they already, all those quotations is what the judge determined. There is a motion still pending regarding 1262.36 that they don't want to hear until this matter is presented
I
to
think
you all.
basically what they're saying is they want an interpretation of that rule that goes along with this motion. But the judge has already ruled on everything once, but now there's another motion that's been filed. And they're asking for an interpretation of 1260-2.36.
Let's get current. We've got a motion by Commissioner Alexander that this enter into our litigation monitoring program. Is there a second to that motion? Last call. Is there a second to that motion? All right, the motion dies for lack of a second.
I'd like to make a motion that we dismiss it, as our attorneys have said, because of it's about commission, and we don't ever discuss commissions in this
Oh,
form.
we're not, that's not what,
That's So the motion.
That's my motion.
The motion on the floor is to accept council's recommendation and dismiss. Is there a second to that motion?
And I do want to clarify.
1 second. Is there final last call? Is there a second to Commissioner Collins' motion? All right, that motion dies for lack of a second. Ms. Smith.
The conversations Keeling and I had about this and why she recommends dismissal is because the judge ruled that there was no meeting of the minds, there was no contract, and the complaint was for misrepresentation. But if this respondent was not their agent and there was no contract, there was no misrepresentation.
They signed it. Did they sign it?
I did sign it. I think the issue is they're claiming that they didn't know they were signing a contract because it was lumped in with what they called a plethora of other paperwork that they had reviewed previously.
That they were supposed to read.
Correct.
And so whose responsibility is it that they didn't read it?
If they decide they didn't want the house.
Well, but it's the agent's responsibility to tell them what's in there.
Well, when you have it in writing and you send it to them, what?
It's kind of reminds me of some of the timeshare deals where the paperwork is there, but we sure would like to have heard that oral presentation. But the paperwork is there, it sounds like to me.
And it sounded like they didn't want to sign a buyer's representation the whole time. That's what this is all over, I think. And they didn't want to sign it, and so then the agent put it in with everything else, which is required in his office for their package, and the people signed it. I would think that they signed it. I mean, what's enforceable in court? It's what's written on a contract, not what's inferred.
Ms. Franks, you haven't had an opportunity to make a motion on this particular case yet. Would you like to do so?
I'd like to make a motion to dismiss.
Is there a second to Ms. Franks' motion, which sounds eerily similar to Mr. Collins'? Would you like to second that, Mr. Collins?
I would.
Okay, just checking. So at this point, there's a motion on the floor to dismiss, properly seconded, made by Ms. Franks, seconded by Commissioner Collins. Now, let's have discussion on the motion. If there's no discussion on the motion, there's been a request that this vote be taken by roll call vote. Ms. Maxwell, we're ready to vote.
So the motion is to accept legal counsel's recommendation to dismiss as to.
Oh, she didn't say that now. She said, I want to make a motion.
Motion to dismiss as to both respondents. Is that correct?
Yes.
Okay.
So a yes would be to dismiss, right?
Bloom,
Yes.
Alexander,
No.
Franks,
Yes.
McMullen, absent. Grease,
Yes.
Hills,
Recluse myself, please.
DeChara,
No.
Collins.
Yes.
4 yes and 2 noes and 1 abstention.
All right, the rules of this commission say we have to have a majority of those voting to pass a rule or a majority of commission. Is it
A majority of those voting.
Okay,
If
so-
you have a quorum, which you do.
Okay, so motion passes 4-2 and 1 abstention. All right, number 9 and 10.
Item 9, 2014014531, and item 10, 2014014532. This was previously presented at the November 2014 meeting. The facts that were presented then are as follows. Complainant hired respondent's firm. Respondent 1 is affiliate broker. Respondent 2 is principal broker to rent complainant's home. Complainant states that per the lease agreement with tenants, the tenants were to maintain the yard and gardens, but the tenants did not, and Respondent 1 discouraged complainant from taking action, stating that the yard could be repaired with security deposit funds. Complainant states that the first tenants moved out sometime in June 2013. Complainant states that Respondent 1 hired a handyman rather than professional landscaper to repair the garden, but the work was never done. Complainant states that a professional landscaper was hired by complainant, and Respondent 1 initially agreed to pay an amount toward that, but now refuses to pay. Further, complainant states that the first tenants were supposed to pay for removal of a satellite dish they installed, but tenants have not paid and complainant was charged. Complainant further states that the second tenants moved in July 2013 and Respondent 1 submitted a move-in check-in report but complainant learned from the second tenants that respondent 1 had not been to the house for inspection and check-in. Complainant states that upon visiting the home, damage to the hardwood floor was discovered from the first tenants and pulls in the carpet, but respondent 1 refused to charge the tenants. Complainant further states that the first tenants damaged 2 window seals and the first tenants did not finish the repairs, so the second tenants finished the repairs but did not receive reimbursement. Complainant 1 states that respondent 1 assisted the first tenants with the home purchase, for which respondent 1 and the firm took a commission, and complainant states complainant was not notified of this conflict of interest.
Ms. Baird, may I interrupt just for a second on this? In an effort to preserve as much time as we can. The end of this is as important as what you're reading, right?
Yes.
Could we just go to that paragraph for a second and see if commission can come to consensus without going through that much detail?
Yes. So approximately
Why don't you read what we did before, what
Okay.
our decision was, and pick it up right there.
Okay. The previous decision of the commission was for each respondent, the commission authorized a civil penalty in the amount of $1,000 for violations of TCA 6213-312B14, 6213-4041, 6213-4041 and 2, plus each respondent must attend one entire regularly scheduled meeting of the commission within 180 days of execution of the order. Approximately 1 day after the complaint was submitted to the commission at its November meeting, Office of Legal Counsel received written correspondence from complainant stating that he has made a financial agreement to settle his dispute with respondents. As a requirement of this agreement, complainant is asking that the commission dismiss his complaint. In addition to complainant's written correspondence, the Office of Legal Counsel also received written correspondence from respondent's attorney requesting that the complaint be withdrawn and that the parties have reached an amicable settlement. Respondent's attorney stated that she understands that this information was not available at the time this matter was presented to the commission and that she's requesting a reconsideration of this matter. So the new recommendation would be just to discuss. So this information literally came into our hands the day after the last meeting. Saying,
Cheaper to buy them off for $250 than it was to pay $1,000. That's simple to understand.
Well, I just want to check with commission and see if there's a desire to
Move to dismiss.
say, make a motion to
I make a
dismiss, for
motion to-
instance. I mean, there's a desire to do that by Ms. Franks. Is there a second to her motion?
Second.
All right, the motion is properly on the floor. I would like to know for the record that Commissioner Collins has had to leave the meeting for a funeral, so he won't be participating in this vote. Let's just have some discussion on this. And I want to hear from Ms. Barrett again as well.
Well, I don't know why we change our decision based upon what these attorneys have crafted. They still violated our rules and regulations.
Because you paid off after you got to file the complaint, you're still guilty.
Well, we're not calling them guilty. We're just saying that
Yes,
it
you
appears,
are.
that they might have violated a rule.
Well, we thought so last month.
I'm not arguing with it all. As a matter of fact, that's why I wanted to get to this point, because we didn't need to rehash it all the way through again if there was a similar outcome. So, Ms. Franks, your motion is on the floor at this point, and it's properly seconded. We can vote on that, and we'll see how it does, and then we'll go from there. We'll do this by voice vote. All those in favor of Ms. Franks' motion to dismiss, vote aye.
Aye.
All those opposed, vote no.
No.
All right, the chair rules that that motion fails. Is there another motion? Or is the belief of the chair that if we take no action, our previous action stands? Is there another motion? All right, I hear no other motions. I think I will at this time ask for us to take a 10-minute break, and we'll get to our next item as soon as that break is ended.
We don't have to vote that it stands. No. Okay.
All right, ladies and gentlemen, if it makes you feel any better, we're approximately 20% through the complaints we're to deal with today. All right, Keelan, if you're ready to go, numbers 11 and 12.
I'm ready. Item 11, 2014-014-701, and item 12, 2014-014-702. Complainant is a principal broker, and respondent 1 is a loan officer, and respondent 2 is the manager of the lending company. Complainant represented a buyer who was purchasing a property from buyer's father through a bankruptcy order. Complainant states that neither respondents returned any of complainant's calls after the loan was assigned, and eventually respondent 1 sent the buyer a TAR amendment to agreement form without first speaking with complainant to request changes to the terms of the agreement.
Complainant advised the buyer not to sign the TAR form and attempted to speak with Respondent 1, but ended up meeting with Respondent 2. Complainant states that Respondent 2 initially stated the loan had been denied, though an appraisal on the home had already been done, but then stated the loan should close next week. When Complainant inquired about who wrote the TAR form, Complainant states that Respondent 2 would not address the situation, but told Complainant to learn how to write a contract. Complainant advised Respondent 2 that they would be transferring to another lender. Respondent 1 states Respondent 1 has been a mortgage broker for over 10 years and has never deprived an agent of their commission. Respondent 1 denies representing oneself as an agent. Respondent 1 states that Respondent 1 was not aware that an agent was involved, stating the contract was received from the buyer's former loan originator and did not include confirmation of agency status, compensation agreement, buyer's representation agreement, etc. Respondent 1 states that the buyer mentioned Complainant was a family friend who assisted with the contract, and Respondent 1 denies that Complainant ever called the office regarding the loan. Respondent 1 states that Respondent 1 spoke to Complainant on one occasion regarding a different loan file. Respondent 1 further states that the buyer told Respondent 1 to work directly with the buyer and not Complainant. Respondent 1 states that the buyer requested the sales price to be lowered, and Respondent 1 found a sales addendum online. Respondent 1 states that upon learning Complainant was the agent involved, the buyer contacted Respondent 1, who apologized and said that the bankruptcy court required an agent to be involved, and the buyer did not realize Complainant was representing the buyer too. Respondent 1 states that the firm transferred the information to another lender at the buyer's request. Respondent 2 states that Respondent 2 is the branch manager and has been a mortgage lending professional for over 20 years. Respondent 2 disagrees with Complainant's allegations and denies representing oneself as an agent. Respondent 2 states that when the title company was contacted for exact numbers on payoffs, fees, etc., the information came back without any real estate agent commission included in closing costs, and Respondent 2 was under the impression that no agent was involved. Respondent 2 advised Respondent 1 that a sales addendum form could be found on the internet, and Respondent 1 provided it to the buyer to be executed by seller and buyer. Respondent 2 states that there was some confusion when greeting Complainant, and Respondent 2 thought it was a client until Complainant began asking questions about the buyer's file. Respondent 2 denied speaking with Complainant since there was no third-party authorization form on file. Respondent 2 requested agency confirmation forms be provided to respondents and the title company to ensure Complainant received compensation, and Respondent 2 states that Complainant became angry. Respondent 2 states that the buyer requested the loan be transferred, and respondents complied. The recommendation in this matter is a letter of warning referencing TCA 6213-301 regarding unlicensed activity. In addition, the letter of warning should reference TCA 6213-1024, which states the definition of broker. This matter does not rise to the level of unlicensed activity, and the respondent was not acting for a fee or commission.
All right, you've heard council's recommendation. Is there a motion?
I make a motion, we approve council's recommendation.
Second.
I have a motion by Commissioner DeChara, seconded by Commissioner Franks, that council's recommendation be adopted. Now discussion. Ms. Hills.
No.
Mr. Alexander. Any other discussion?
Yes.
Mr. Bloom. I knew somebody over there wanted to say something.
Well, it says this matter does not rise to the level of unlicensed activity and that respondent was not acting for a fee or commission. And I understand that, but that actual rule says, or any other valuable consideration. And what he was trying to do was get a loan origination fee. I'm pretty sure it's not stated, but he's chastising an agent and saying you didn't have the correct forms. The only reason he's trying to move this thing along is so he can get, or she can get, an origination fee, which is other valuable consideration. So I believe, I mean, I know we already have a motion, but
we can take a substitute motion easily.
Well, he's in violation. 62-13-1024.
All right. So
$1,000 and come to a meeting, 180 days.
Is this for both respondents?
1 and 2.
All right, Mr. Bloom has offered a substitute motion that, if seconded and passed, would offer a $1,000 civil penalty to both respondents 1 and 2, as well as a requirement to show up at a full meeting of the Tennessee Real Estate Commission within 6 months.
Second.
I have a second by Commissioner Hills. That motion is now the motion on the floor.
What was that rule number, Commissioner Bloom?
It's the one that's
San
cited,
Juan
6213-102, but it's in area 4 where
The
it says.
102.4 is just the definition of a broker, so the rule violation for unlicensed activity should probably be 6213-301.
Okay.
Okay. Without objection, that is the reference in the motion that Commissioner Bloom offered. Now, is there discussion or further discussion on his motion? Are you ready to vote? All right, let's vote. All those in favor of the motion vote aye.
Aye.
All those opposed, no. The motion passes unanimously. No need to consider the original motion because the substitute motion took its place. All right, next item, number 13 and 14, 15.
Hold on one second. They did say it was for both. Okay. Item 13, 2014-014-014-711. Item 14, 2014-014-712. And item 15, 2014-014-014-713. Complainant principal broker discovered that a property previously viewed with complainant's client buyer was listed back on the market as active. Complainant emailed the offer to Respondent 2, affiliate broker, and called to ensure it was received. Complainant states that Respondent 2 advised that the offer was accepted and submitted through software specializing in short sales and foreclosure, and complainant requested copies. Complainant states that complainant had not heard back from Respondent 2 in a couple of days, so complainant contacted the other listing agent, Respondent 1, who stated that Respondent 1 was unaware of any offers that had been submitted. Complainant states that Respondent 1 advised it went to either an auction or foreclosure. Complainant states that Respondent 1 told Respondent 2 to notify complainant of the foreclosure, and Respondent 1 told complainant that the offer was too low. Complainant requested that Respondent 2 call to speak with complainant regarding representing the offer to the bank, but states that neither respondent called back. Complainant states that respondents failed to furnish a copy of the contract documents that Respondent 2 advised was accepted and uploaded. Complainant also alleges that respondents failed to advise that the property was foreclosed. Respondent 1 submitted a response denying the allegations, stating that complainant called the office notifying Respondent 1 that an offer would be submitted soon. Respondent 1 submitted the offer to sellers within an hour of receiving it, stating that Respondent 1 was not sure if this was a good deal because of the pending foreclosure auction. Respondent 1 states that the seller was routinely late in returning signed documents, and Respondent 1 never received a countersigned contract from the seller. Respondent 1 states Respondent 1 called the bank, and the bank stated that the purchase price was too low and the time frame is too short. And Respondent 1 states Respondent 1 relayed the information to complainant, who would speak with the buyer. Respondent 1 states the listing was removed after the foreclosure sale. Respondent 1 states that complainant called after the foreclosure auction took place, and Respondent 1 acknowledged the offer but stated it had not been uploaded into the software program. Respondent 1 states that the sale of the property was tough and there was a lot of communication with the bank. Respondent 1 states that Respondent 1 tries the address business in a compliant and timely manner, and Respondent 1 believes complainant is stretching the truth in order to make a complaint. Respondent 1 further states that complainant screamed at Respondent 1 and called Respondent 1 incompetent, which does not reflect the business ethics of a realtor. Respondent 2 acknowledged receipt of the offer and states that it was immediately forwarded to Respondent 1. Respondent 2 states that Respondent 2 does not work in the software program and remembers complainant stating that complainant was familiar with the program. Respondent 2 states that complainant was rude when Respondent 2 advised that Respondent 1 was handling the listings and the offer would be forwarded to Respondent 1. Respondent 2 denies stating the offer was accepted or uploaded to the software program. Respondent 2 also denies receiving phone calls or voicemails regarding this listing. Respondent 2 further states that the listing was removed from MLS as soon as information was received from the bank that the property was to be auctioned. Respondent 2 further states that complainant currently has the home under contract per MLS. Respondent 3, principal broker, stated that Respondent 3 investigated the transaction upon receipt of the complaint and stated that complainant never contacted Respondent 3 to assist complainant. Respondent 3 states that Respondent 1 contacted the bank upon receipt of the offer and stated they would not accept it at that price and it was too late to stop the foreclosure auction. Respondent 3 states that there may have been a failure to communicate and states that complainant may have been hard to talk with on the phone. The recommendation is to dismiss.
All All right, you've heard council's recommendation. That is to dismiss this complaint. Is there a motion a commissioner would like to offer?
I make a motion, we approve council's recommendation.
You've heard the motion. Is there a second?
Second.
Seconded by Commissioner Franks after being initially made by Commissioner DeChara. Now, is there discussion? Ms. Hills?
Was this a team? Was this a team?
I believe they were co-listing agents. I don't recall seeing anything about teams, but that they were co-listing agents. This was with a foreclosure, and it was for a bank, so.
The only thing that struck me odd about this at all was the last line in the next to last paragraph that says, Respondent 2 further states that complainant currently has the home under contract per MLS. Can you help me with that?
That was probably when, I guess as a result of the auction sale. I can look that up.
Oh, that's okay.
I believe it was as a result, it went to auction and then, but I mean, it's not current now. It was current when respondent responded. I didn't follow up on that.
Yes, sir.
Mr. Chairman,
Yes.
I'd like to defer this till next month, and you give it to me, and I'd like to review it.
I'm not opposed to doing that, but I'd like to ask one thing. How's our time limit on this one?
It'll go over.
It'll go over.
Yeah.
It'll push us over the 180 days.
That
What
ain't
happens
my
then?
fault.
Well, then,
I'm not saying it's your fault.
so if it was co-listed, respondent 1 and respondent 2, they're both to know what everybody knows. If I have a co-listed with Gary, he's supposed to know everything I know and vice versa.
All right, so there's been a request made by Commissioner Alexander.
That's a motion.
Well, I'll just do
Okay.
it if.
Do we have a motion on the table?
We do. I just want to put this out there before we get to that point. So Commissioner Alexander, in discussing the motion, asked that he be assigned this file to research it in more depth than what we have at this moment. And we're going to have to well, look at the commission to tell me what they would like to handle first. Commissioner Alexander's request or the motion on the floor? The motion on the floor by Robert's rule takes precedence.
What
Be
happens
happy to withdraw
if we
my
don't make the
motion.
180 days?
Well, I guess it's not really, it's more on us than it is on you guys, really. If we don't make the 180 days, then it just causes the percentages that we are kind of regulated by to drop for this particular commission.
Why did it take that long to get here?
What if commission votes to defer? Is that taking action?
It's taking action, but it's not a clock stopping action for us, so it's like nothing happened, basically.
Well, so will you get your hand slapped? What does that mean? What happens?
I mean, it's it's the will of the commission. We can't, if that's what you guys want to do, we can't say no, but I just wanted to make sure we brought that to your attention.
Well, Mr. Char, did you say you?
I will withdraw my motion.
You had this motion or the second?
I had the motion.
You had the motion, I had the second.
Okay,
Now
so-
we'll withdraw too.
All right, so the motion that was on the floor is off the floor at this point. So the chair, unless there's objection from a member of commission, is going to ask that this file be assigned to Commissioner Alexander for his review and report back to us in January. Is there any objection to that? All right, let's do that then. Let's move on.
Commissioner Alexander, do you want that emailed to you or mailed to you? Mail it? Okay, I'll have to get your info at that.
Did you have, Ms. Smith, did you want to go back to a previous item?
Can we go back to the one right before what we just talked about? Hold on. I just want to make sure. It was item 11 and 12. I wanted to make sure when we made the motion and made a determination on the discipline, I can't remember if you included attendance at a commission meeting in that or you did not. Because I don't think they're licensed, so I'm not sure that we should include attendance at a meeting, perhaps just a cease and desist letter along with that. Or just cease and desist language in the consent order, I guess.
That's fine. Everyone
made the motion.
So
They're loan officers. Is what they are.
Right, so you were on the prevailing side, so you've got the right to go back and reconsider your motion if you would prefer, and it sounds like you would like to reconsider your
Yeah,
motion.
that's fine.
And tell us what you, instead of attending a meeting, a cease and desist letter, along with the fine.
That's fine.
Civil penalty, I mean.
Yeah, I'm sorry, I misspoke. It would just be cease and desist language within the consent order. It wouldn't be a separate letter. I don't know why I said that.
Okay. We can still do
doesn't
the
make
fine
sense.
though, right?
Yes.
Okay.
Everything else is the same, just minus the meeting, because that wouldn't make sense.
All right, let's just, for the record, let's vote on that. The motion being brought back up on reconsideration is that in lieu of a $1,000 civil penalty and attendance at a commission meeting, the motion is a $1,000 civil penalty, which includes a cease and desist letter. That's the motion in front of the commission at this point. You were the maker of that motion. Ms. Hills was second, as I recall. Are you also okay with that? Yes. Okay. So that's the motion in front of commission. Any discussion? All those in favor of the motion vote aye.
Aye.
Those opposed, no. That motion passes unanimously. Okay? So now we're back to
Item 16.
item 16.
Item 16, 2014-014-881. Complainant was selling a home and states that respondent affiliate broker was the buyer, agent, and placed an offer of $235,000. Complainant alleges that respondent failed to respond to complainant's agent until after the inspection report was complete and after the deadline had lapsed. Complainant alleges that respondent then submitted an offer of $190,000 and believes that respondent had no intention of following through with the $235,000 offer. Respondent stated that respondent presented an offer to seller's agent for $235,000 cash with contingencies on inspection and title. Respondent states this was initially looked into for respondent's residence and states that the inspection report stated there was a high risk of fire due to the HVAC, electrical, and plumbing being crammed underneath the property. Respondent states that the inspector told respondent the property was a teardown, and respondent began thinking of the property as a renovation. Respondent states that the inspection deadline lapsed, and instead of retracting the offer, respondent submitted an offer of $190,000 as is. Respondent states that this was respondent's second contract as a realtor and there were mistakes made, but respondent has learned from them and is continuing to expand respondent's education. Respondent apologized for not submitting a timely response. The Office of Legal Counsel followed up and obtained the transaction file. It appears that the purchase and sale agreement was accepted on May 14, 2014, and the inspection was held on May 29, 2014. The personal interest disclosure and consent was executed on June 4, 2014. An amendment to the purchase and sale agreement with an offer of $190,000 was executed on June 3, 2014, and the inspection notification was executed on June 4, 2014. Further, an earnest money release was executed on June 4, 2014. The recommendation is a letter of instruction regarding TCA 6213-4037A, which states that a licensee shall not engage in self-dealing nor act on behalf of licensee's immediate family or on behalf of any other individual, organization, or business entity in which the licensee has a personal interest without prior disclosure of the interest and the timely written consent of all parties to the transaction.
Okay, so you've heard the recommendation from council. Is there a motion?
Motion, we approve council's recommendation.
Is there a second to that motion?
I'll second it.
All right, to get the item on the floor, we have a motion and a second properly made by Commissioner DeChara and seconded by Commissioner Franks. Now, comments or questions? Mr. Bloom.
Did the sale close? He had inspection on the 4th, and the same day got his earnest money released?
I don't believe they ended up purchasing the home.
So, I've got a question for council. It seems to me that it's clear that this respondent didn't do the proper paperwork in the proper order. So why are you recommending, in my mind, leniency in this case instead of a civil penalty?
Well, I think in this particular instance, when I read over the documents, didn't think that, I guess it rose to a monetary disciplinary action. But if you think it does, then You probably know a lot more about it than I do.
Asking the question at this point, but I mean, in the past, we've occasionally seen council's recommendation that seems to, this is not a criticism at all, but seems to take into account the fact that the respondent is remorseful or says he's or she has learned from their experience. And I don't know if that's the case here or.
It did say that they apologized, but then there was also no history of disciplinary action in this matter, which is another reason why we didn't bump it up immediately. But it's certainly the will of the commission. So
This was testimony. Was it second transaction? Anyhow,
transactions is all they done. New agent.
New agent.
He was a buyer's agent. He was.
Get through this. I've got a question about the principal broker.
All right. Well, at the moment, the motion is to accept council's recommendation.
Do you have a motion?
Yes. Which is to send a letter of instruction to the respondent. Is there further discussion on the motion? All right, let's vote. Those in favor of the motion vote aye.
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 Those opposed, no. Chair rules the motion passes unanimously on a 6-0 vote. Now, Mr.
Chairman,
Alexander.
I move that a complaint be opened against the broker for supervision, improper supervision.
it has been, and it'll be number 17. It'll be the next one you hear.
You're almost like a mind reader.
You read our minds.
Good.
Or we read yours. Yeah.
All right, we're done with 16. Let's go to 17, which apparently has to do with the principal broker related to the respondent in the previous complaint.
If he's a new affiliate, I think that's sufficient.
All right, we've got that handled. Number 17.
Item 17, 2014-026-421. Trek filed a complaint against respondent for failure to supervise respondent affiliate broker in complaint 2014-014-881. Respondent has spoken with affiliate broker regarding affiliate's actions. Respondent states that affiliate broker placed an offer in a multiple offer situation and was put in backup status. Respondent states that the first contract fell through due to an inspection. Respondent states that affiliate broker's offer had an inspection period of 7 days with a resolution period of 21 days, and it appears the offer price was altered due to the result of the inspection. Respondent states that affiliate broker had no intention of trying to wear the seller down in price, but was only being cautious. Respondent is working with affiliate broker regarding negotiation and processing paperwork. Recommendation is the letter of instruction regarding TCA 6213-4037A.
Chairman.
I can get a motion on the floor, just so we have something to discuss.
I'll put that motion on the floor that we accept council's recommendation.
All right, that motion has been made. Is there a second to the motion?
I'll second it.
Seconded by Commissioner Bloom. Now, Mr. Alexander.
Make a substitute motion.
All right, sir.
That we also add a $1,000 fine to it, to the principal broker.
All right, so Mr. Alexander, is that in addition to the letter of instruction? Yes. Okay, so you want to amend the motion that's on the floor by adding a $1,000 civil penalty?
Whatever, or substitute amend it either way.
Well,
if you take a friendly amendment, that'll be great. If you don't, I'll make a substitute motion.
So I want to make sure we stay in order here. At this point, it's a substitute motion that says letter.
If Ms. DeJar will let me have a friendly amendment to it, well, that's fine. If she don't, I'm going to.
Let's assume she won't at this point. She might speak up in a minute, but at this point, I'm going to consider it a substitute motion, $1,000 civil penalty.
The broker.
To the broker in attendance, regularly scheduled.
Everybody gets to come to class.
All right, there's that substitute motion is on the floor, looking for a second.
Second.
I've got a second by Commissioner Hill, so that's now is the motion on the floor. Ms. Baird, did you?
I'm just trying to make sure that, first of all, we need to be specific on which statute we're citing. Are we talking about 4037A, or are we talking about failure to supervise?
Failure to supervise.
Okay, and then secondly, I don't know if your motion was for a letter of instruction in addition to, okay.
At this time.
Okay, great.
Okay, $1,000.
Got it.
Come to class. So I think that's what you said. All right, that motion is in front of us now. Is there discussion on Mr. Alexander's motion?
So it's the $1,000, come to the class, but no letter of instruction?
Correct. At this point, that's the chair's interpretation.
I ought to have seen him to school, but I'll let that slide.
All right, other discussion on the motion? You ready to vote? Let's do it. All in favor say aye.
Aye.
Those opposed, no. That motion passes unanimously. Numbers 18 and 19.
Item 18, 2014-014-891, and item 19, 2014-014-892. Complainant states that Respondent 1, affiliate broker, showed complainant's property and did not lock all outside doors. Complainant further states that Respondent 1 performed a final walkthrough on complainant's property and notified complainant that complainant failed to fix a ceiling settlement crack per the contract. Complainant states that this was never included in the paperwork and further alleges that Respondent 1 should have called complainant's agent instead of complainant directly. Complainant alleges that Respondent 1 was rude and threatening on the phone. Respondent submitted a reply stating that complainant's agent never notified Respondent 1 that Respondent 1 had left the door unlocked, and further states that complainant's agent advised that complainant's home was showed by 3 different agents that day, and Respondent 1 was not the last one to show the home. Respondent 1 states that complainant's agent was out of the country during the final walkthrough, and buyers called the complainant and handed the phone to Respondent 1 to speak with complainant because the buyers did not want to close on the house until the repairs were performed. Respondent 1 states that upon inquiring about settlement cracks being repaired, complainant yelled at Respondent 1. Respondent 1 states that the home closed June 6, 2014, and buyers are happy with the home. Recommendation.
Dismiss. Second.
We have a motion by Commissioner Frank, seconded by Commissioner Chara, that this complaint be dismissed. Is there discussion on the motion? Let's vote. All in favor of the motion, vote aye.
Aye.
Those opposed, no. That motion passes unanimously. 20.
Item 20, 2014-014-901. Complainant states that Respondent, affiliate broker, represented complainant in the purchase of a business and later represented complainant in the sale of the business. Complainant further states that Respondent ended up purchasing complainant's business. Complainant alleges that Respondent engaged in self-dealing, was not loyal to complainant's interests and failed to disclose dual agency, acted for more than one party in a transaction, failed to provide copies of documentation at the time of execution, and made willful misrepresentations and committed fraud. Respondent submitted a response denying all allegations. Respondent states that Respondent represented complainant in a lease purchase for a commercial property, and complainant later approached Respondent regarding the sale of a business. Respondent denies representing complainant in the sale of a business, as Respondent does not have past experience doing so. Respondent states that complainant and Respondent had a friendly discussion regarding the sales price, and Respondent thought the business was worth more than complainant was contemplating selling for. Respondent states that Respondent ended up purchasing the business at a renegotiated the purchase price because complainant began letting employees and clients go, which violated their purchase agreement. Respondent states that complainant continued to sabotage the business, and Respondent filed a lawsuit for breach of contract against complainant, which settled in May 2014. Respondent states that the settlement agreement specifically states the parties otherwise fully release one another from any obligations, claims, responsibilities, etc. that one has or may have to one another. Office of Legal Counsel followed up with attorney for Respondent for additional documentation. A lawsuit was filed by Respondent against complainant for breach of contract for an asset purchase agreement stating complainant violated certain warranties regarding the viability of the business. A counterclaim was filed against Respondent for breach of contract, breach of duty of good faith and fair dealing, intentional misrepresentation, and negligent misrepresentation stating that Respondent was agent for complainant in the lease purchase of the building, and that later Respondent agreed to act as business broker to sell the business. Subsequently, a settlement agreement was reached on May 2, 2014, and the lawsuit was dismissed. A second suit was filed by complainant against Respondent in June of 2014 for breach of settlement agreement for failure to timely perform all requirements of the agreement, specifically for return of certain property items and certain business records. This TREC complaint was filed June 10th. The subject matter of the lawsuit in this complaint is regarding an asset purchase agreement, which is not regulated by the Brokers Act. The recommendation is to dismiss.
Move to dismiss. Second.
Motion by Commissioner Frank, seconded by Commissioner Chara, that this motion, this complaint be dismissed per council's recommendation. Is there discussion? All right, then let's vote. All in favor of the motion, vote aye.
Aye.
Those opposed, no. That motion passes unanimously. Number 21.
Item 21, 2014-014-921, complainants purchased a home and Respondent was seller's agent. Complainant stated that an inspector noted that the crawl space supports needed repair or replacement, and seller was to provide repairs. Complainants alleged that complainant's agent stated that a contractor was going to do the repair, but when the inspector re-inspected the home several months later, it was noted that repairs had not been made. Complainants allege that seller stated respondent took care of the repairs. Complainants allege that respondent and one of the contractors came to complainant's house to discuss the repairs that had been made, and the inspector re-inspected the crawl space but affirmed no repairs had been done. Complainants inquired about licensure of the contractor and state that the contractor's licensing board stated the contractor is not licensed. Complainants allege that respondent reassured complainants that the contractor is licensed and works frequently for respondent. Respondent confirms that respondent represented seller in this transaction, and seller hired a contractor who completed all repairs requested except one where an air and heat vent was partially blocked by the bathtub. Respondent confirms that respondent met one of the contractors at complainant's property, and the contractor showed complainants the repairs made to the pillar support, and the contractor stated the house was safe, and respondent thought everything was okay. Complainant sent additional information stating respondent contacted the inspector and told the inspector that respondent would find somebody to fix the problem, but respondent never did so. Office of Legal Counsel followed up with respondent and received the transaction file. It appears that respondent was a listing agent and complainant's agent was an agent with respondent's firm. The binding agreement date was October 13th, 2013 and included a 12-day inspection period. The buyer inspection contingency The buyer inspection contingency removal notification was accepted on October 24th, 2013. Respondent also included a work proposal dated November 2nd, 2013 from a contracting company stating home inspection repairs at residence, and the proposal has an acceptance date of November 8th, 2013 with respondent's signature. It also appears that the buyers did their final inspection and executed a document regarding same on or about November 8th, 2013. The closing occurred on November 8th, 2013. Recommendation is to dismiss.
Motion to approve council's recommendation.
Somebody give me
Second.
a sec, thank you. So now it's on the floor. We have a motion properly made and seconded that council's recommendation be accepted in this particular case. Now, is there discussion? Questions? Ms. Hills, are you still thinking about this one? You can talk out loud and think.
So complainant alleged that the respondent assured complainants that the contractors, no, that's not the part I was looking for. So they were assured that the work was done before the closing, and they discovered it after the closing, the work had not been done.
I
Do
think
have that
there's
right in my head?
I think there's a question whether or not the work has been done, but the respondent submitted the work proposal 11/2/13, stating essentially that the repairs had been made and then they closed. So I think after they'd been in the house for several months, they called the contractor and the respondent and they talked about it. It just appeared that it was more of a contractor issue to us.
All right, so the motion is to accept council's recommendation and dismiss this complaint. Is there further discussion? Since we're ready to vote, let's do it. All in favor of the motion say aye.
Aye.
Those opposed, no. That motion passes unanimously. 22 and 23.
Item 22, 2014-015-001 and 23-2014-015-002. Complainant hired respondent 1 affiliate broker to sell complainant's condo. Complainant states the complainant requested to make at least $142,000 on the sale and that the listing agreement lasts for 3 months. Complainant states that complainant cannot see well, so complainant requested that respondent 1 read the listing agreement to complainant before complainant signed the contract. Complainant states that the listing agreement should have expired July 6, 2014, but discovered later that the listing agreement was through July 31st, 2014. Complainant also states that the listing agreement was for a sale price of $150,000 with a 5% commission to the agent. Complainant states that one offer came in for $140,000 and negotiations were made, but the deal did not go through, stating that respondent 1 was trying to convince complainant to accept an offer lower than what complainant wanted. Complainant further alleges that respondent forged complainant's signature to accept a second offer of $145,500, but alleges respondent 1 told complainant over the phone that the buyer accepted complainant's counter of $146,500. Complainant states that complainant will honor the contract with the buyers, but respondent 1 offered to give complainant respondent 1's commission. Respondent 1 submitted a response stating that respondent 1 worked with complainant at a previous employer, and complainant contacted respondent 1 to list a vacant condo which needed work done. Respondent 1 states that respondent 1 agreed to a lower commission and that the listing agreement would go through July 30th, 2014. Respondent 1 states that complainant asked respondent 1's opinion regarding maintenance and repairs that needed to be done, but complainant never followed through with repairs. Respondent 1 states that an offer came in and eventually complainant accepted an offer of $145,500 with 5% commission for both agents, and respondent 1 would give $500 of respondent 1's commission back to complainant at closing. Respondent 1 states that an inspection was done on the home, but complainant refused to replace the water heater. Respondent 1 states that respondent 1 and the buyer's agent agreed to share the cost of the installation of the water heater in order to salvage the deal. Respondent 1 states that complainant and complainant's ex-spouse visited the premises with the agents, and the ex-spouse stated that complainant would fix the water heater and sell to the buyers. Respondent 1 states that this is when complainant began accusing respondent 1 of forgery, and respondent 1 denies these allegations. Respondent 1 states that respondent 2 and the firm's broker discussed the situation, and they all attended the closing in which complainant was present and accepted the sales price of $145,500 with an additional $500 from respondent 1's commission and an extra $200 from respondent 1 to replace the water heater with the used one. Respondent 1 states that complainant made $146,200 from the sale. Respondent 1 states that complainant continues to slander respondent 1's name, and attorneys have been hired because complainant is requesting an additional $1,000 from respondent 1. Respondent 2, principal broker, submitted a response stating respondent 2 has no reason to doubt respondent 1's response, and respondent 1 has been an agent with the firm for 2 years and has had no issues or complaints. The Office of Legal Counsel followed up with respondents for additional documentation, and it appears that the HUD corroborates respondent 1's statements regarding the sale with a settlement date of June 18, 2014. It appears that the listing agreement was executed on April 3rd, 2014 for a listing price of $150,000 with 5% commission and expiration of July 30th, 2014. The purchase contract appears to have multiple counteroffers regarding purchase price, but was bound on May 16th, 2014 with a purchase price of $145,500. The recommendation is to dismiss.
Motion to approve council's recommendation.
Second.
Motion by Commissioner DeChara, seconded by Commissioner Hills, that council's recommendation be adopted and to dismiss this complaint. Is there discussion?
Yes.
Mr. Bloom.
Am I reading this right, that he gave $500 of his commission to the seller of the property?
Yes. Yeah. Mm-hmm.
That's a violation.
Or
That's
he
the
reduced the commission.
No, he said he gave an additional
Well,
fund.
I can get out the HUD to see exactly how he did it. Okay,
So the commission asked.
they may have, I mean, it's reflected on the, yeah, it says, as $3,137.50 for that agent minus, which is the 5% minus 500 for commission credit, and then, the buyer's agent received $3,637.50, which is the full 5%.
So each side got 5%?
That's 5% total.
5% total.
Okay.
I'm sorry.
The 500 was taken off of
It was
that
a credit.
It's taken
Yeah.
off of that in the HUD. So yeah, it was a
Okay.
credit. I apologize. He didn't turn around and write a
And then
check.
500, yeah.
I apologize for not making that clear.
A lot of difference.
That's once today already now.
Big difference.
All right, Mr. Bloom, any other questions? No. Okay, so the motion remains as stated by Commissioner DeChara and seconded by Commissioner Hills, that this motion, the motion is to dismiss per council's recommendation. Are you ready to vote? Yes. Let's do it. All in favor of the motion, vote aye. Aye. Those opposed, no. That motion passes unanimously. 24 and 25.
Item 24, 2014-015-051, and item 25, 2014-015-052. Complainant states that Respondent 1, affiliate broker, showed complainant a cabin, and complainant put in an offer and had a home inspection done. Complainant alleges that it was later determined that the Homeowners Association was a party in an ongoing lawsuit, so complainant requested a refund of the inspection fee, but was told by Respondent 1 that the disclosure of the lawsuit is in writing and the lawsuit would not affect the cabin purchase. Complainant states that complainant does not have said documentation and the HOA lawsuit was not disclosed. Respondents responded to the complaint, stating that complainant requested that Respondent 1 communicate with the HOA to determine the amount of money in reserves, and respondents communicated with complainant that $4,000 was earmarked for a lot line dispute with the landowner and the HOA, which in no way affected the property complainant was purchasing. Respondents state that complainant entered into a binding purchase and sale agreement, which included the proper disclosure, stating that licensees are not legal or tax experts, and it was complainant's responsibility to seek legal advice with any concerns. Complainant responded, stating that complainant requested information regarding the reserves prior to the inspection, found out about the lawsuit after the inspection, which affects every HOA member. Recommendations to dismiss.
Motion to accept council's recommendation to dismiss.
Motion by Commissioner Franks is seconded by Commissioner DeChara that this complaint be dismissed. Could you tell us the rationale for your recommendation?
Well, the HOA lawsuit isn't something that's under the Brokers Act, and that seems to be the crux of it. Any disclosures of if an HOA is in a lawsuit would have to come from the seller, not necessarily the agent themselves.
They knew.
If it's material fact.
Unless they
and
knew
it's in a
about
material
it.
fact, unless the agent knew.
I don't have documentation either way.
That's the question. Go ahead. No, let's get this out of the way now. I got a question.
What was the complainant asking for?
The return of the inspection fee, which is not something that the respondent could really do, or that we could do.
So I'm just trying to figure out what the crux of the issue is here. Is it the HOA lawsuit, or is it the inspection fee, or is it both, in your opinion?
Both, but mainly that's what the complainant wanted. Requested return of the inspection fee after finding out about the HOA lawsuit.
Thank you. Mr. Alexander? Okay. All right, the motion is to dismiss. Is there further discussion on the motion? Let's vote. All in favor say aye. Aye. Those opposed, no. And the motion passes unanimously. Number 26.
If you guys don't mind, I'm going to let Jenica take over the reading for just a little bit. Not that I'm not having fun, because I am.
Okay, just check. All right, Jenica.
Item 26, 2014-015431. A complaint was filed against respondent, who is the owner of a real estate firm, who had a principal broker who released himself on 6/24/14. Complainant states that respondent misrepresented a property that complainant rented from respondent and inflated the rental price. Complainant states that respondent filed a detainer warrant against complainant. Respondent submitted a response stating that complainant filed a civil lawsuit, and the judge ruled in respondent's firm's favor to evict complainant and ordered complainant to pay $1,690 in back rent from May and June 2014. Respondent further states that all complainant's claims arose prior to the firm's ownership and management of the property. Respondent further states that respondent did not falsely advertise the property because the firm never advertised the property, and complainant responded to a Craigslist advertisement posted by the property's previous owner. Respondent further states that the complainant had a realtor who had a fiduciary duty to provide an accurate description of the property before complainant signed a rental agreement. Respondent states that respondent had advised complainant to file a complaint against the previous owner to remedy complainant's claims. Based on the information received, it appears that complainant rented the property prior to the principal broker releasing himself on 6/24/14, and there is no evidence of unlicensed activity by respondent. The recommendation is to dismiss.
Let's get some motion on the floor.
Motion to accept council's recommendation.
Second.
Okay, a motion by Commissioner Hills has been made, seconded by Commissioner Bloom, that council's recommendation be accepted and this complaint be dismissed. Now, is there discussion? I hear no discussion. Let's vote. All in favor of the motion, vote aye.
Aye.
Those opposed, no. That motion passes unanimously. 27 and 28.
272014015771 and 2820140115. I think it should say 772 there. A complaint was filed against Respondent 2, broker, and Respondent 1, principal broker. Complainants allege that while staying at their timeshare for 2 nights, Respondent 2 brought them a gift basket and began to discuss their timeshare. Complainants allege that Respondent 2 advised that they could exchange their week for 25,100 points, which could be exchanged for 3 weeks in Hawaii. On 4/11/14, complainants executed a purchase worksheet/agreement for 25,100 conversion points for a purchase price and processing fee in the total amount of $5,894. Complainants state that they found that most weeks rented in Hawaii for more than 25,100 points. So on April 21st, 2014, they called the bank to cancel the transaction for the card and were given a confirmation number. Complainants further state that they spoke with a representative at Respondent's firm on April 21st, 2014, and requested cancellation of the transaction. Complainants further state that later they received a dispute letter from the bank. Respondent 1 submitted a response stating that the contract complainants signed to exchange their timeshare for points states all sales are final and there are no refunds. Respondent 1 states that in spite of this statement, complainants have received a full refund for their purchase. Respondent 2 submitted a response stating that Respondent 2 did not provide complainants with incorrect information. Respondent 2 states that complainants chose to take advantage of a new exchange program, but later decided to cancel their purchase and their money has been refunded. The recommendation is to dismiss.
Motion to accept council's recommendation.
A motion by Commissioner Franks, seconded by the balance of the commission that this, maybe I'm speaking out of line. Maybe I better get a second. Is there a second? Seconded by Commissioner Hills that the council's recommendation be accepted and this complaint be dismissed. Is there discussion? Hearing none, let's vote. All in favor of the motion, vote aye.
Aye.
Those opposed, no. That motion passes unanimously. Number 29.
Number 29, 201401605. Complainant listed a condo with Respondent, principal broker, and another agent. Complainant states that the agreement was that the agents would split their commission 50-50. Complainant states that the buyer was somebody that Respondent was working with, so a confirmation of agency status was executed, designating Respondent as buyer's agent and the other agent as complainant's agent. Complainant states that the HUD showed that Respondent received 75% of the commission and the other agent received 25%. Complainant believes that this was unfair to the other agent and handled improperly. Respondent submitted a response stating that Respondent managed complainant's condo for rent for 7 years and agreed to co-list the property for sale with complainant's close friend. Respondent states that the discussions regarding splitting the commission did not include splitting the buyer's side of the commission. Respondent states that the listing agreement was for a total of 6% commission with 3% split between the listing agents and the other 3% for the buyer's agent. Respondent states that the buyer approached Respondent and the other agent requested that Respondent revert to agency for the buyer, which only affected the agency representation and not the co-listing agreement. Respondent states that the other agent sent an email prior to closing to confirm that Respondent was receiving the 3% buyer's agent commission and 1.5% of the listing commission, and mentioned that the other agents would have split the entire commission 50-50. Respondent states that there was no more mention about problems with the commission until after the closing, when complainant emailed respondent asking to pay over part of the respondent's commission to the other agent. Respondent states that respondent contacted the ethics hotline for advice and regrets ending their business relationship on a misunderstanding. This matter does not appear to fall under the Brokers Act, and the Commission's authority recommendation is to dismiss.
Move to dismiss.
We've got a motion by Commissioner Alexander that this complaint be dismissed per council's recommendation.
Second.
Seconded by Commissioner DeChara. Is there discussion? Let's vote. All in favor of the motion, vote aye.
Aye.
Those opposed, no. That motion passes unanimously. 30 and 31.
30-2014-016-111 and 31-2014-016-112. Complainant states that a Facebook advertisement for a real estate team did not mention the firm name on any page or advertisement. Respondent 1, principal broker, states that pursuant to Rule 1260-02-.12, the firm name and phone number appears on the website. Respondent 2, affiliate broker, states that Respondent 2's knowledge to Respondent 2's knowledge, the website has always been in compliance with guidelines set forth by TREC. Office of Legal Counsel viewed the website in question on 11/17/2014. The homepage title includes the firm name after the team name. However, the multiple tabs, the tabs are sell, finance, your agent, blog, resources, etc., do not include the firm name. Recommendation for each respondent: authorize a consent order with a civil penalty in the amount of $500 in violation of Rule 1260-02-.12, highlighting 2B, stating that all advertising shall be under the direct supervision of the principal broker and shall list the firm name and telephone number. And 4A, the listing firm name and telephone number must conspicuously appear on each page of the website, plus attendance at one entirely regularly scheduled meeting of the Commission within 180 days of respondent's execution of the consent order. Such terms are to be settled by consent order or formal hearing.
All right, you've heard the recommendation. Is there a motion?
I've got a comment or two.
Let me put a motion on the floor.
Accept okay.
Just so we can discuss.
Okay.
I've got a motion to accept council's recommendation, seconded by Commissioner DeChara. Ms. Franks.
Okay, so the principal broker has 3 different things that are under review, correct?
Yes.
It seems like there's a pattern here of problems. I would move that the principal broker, the amount be changed to $1,000 instead of $500.
All right, there's an effort to amend the motion. Is there a second to that proposed amendment?
A second.
Okay, so now we're going to talk about the amendment for a minute, which would alter council's recommendation from a $500 civil penalty to the principal broker to a $1,000 civil penalty. That's what we're going to vote on first. Is there discussion on that amendment? All right, since there is not, let's vote on the amendment only. Those in favor, please vote aye.
Aye.
Those opposed, no. That passes unanimously. We're back to the main motion now as amended, which basically calls for a $500 civil penalty to the affiliate and a $1,000 civil penalty to the principal broker, with both required to attend a TREC meeting within the next 6 months. That's my understanding. Is everybody cool with that?
Yes.
Is there discussion? All right, let's vote on that motion as amended. All in favor say aye.
Aye.
Those opposed, no. That motion passes unanimously. Thank you, Ms. Franks. Number 32 and 33. Are you back?
I've come back. I've recovered.
Okay.
Item 32, 2014-016-141. And item 33, 2014-016-142. Complainant states that respondents have solicited and received information on complainant's timeshare, and complainant discovered that the firm does not have a timeshare registration and respondent 1 does not have a broker's license. A copy of the complaint was sent to respondent 1 to the address on file with TREC, but the letter was returned as unclaimed. A copy of the complaint was sent to respondent 2 to the address provided in the complaint, but the letter was returned as undeliverable. Office of Legal Counsel researched both respondents and was unable to receive any more information regarding their whereabouts. Better Business Bureau website states that they visited Respondent 2's address and was informed there is no such business at that address. The recommendation is to dismiss due to insufficient evidence of a violation.
Heard the recommendation. Mr. Chara decides to make a motion to accept council's recommendation, and that motion is seconded by, I'm just waiting.
Commissioner Alexander.
I'll second it.
Thank you, Ms. Franks. I appreciate your teamwork in this regard. So we have a motion and a second.
Oh, I'm not a team.
I know you're not a team. It's teamwork.
Teamwork.
All right.
Okay.
All right, the motion is in front of the commission to accept council's recommendation and dismiss. Discussion. Let's vote. All in favor of the motion, vote aye.
Aye.
Those opposed, no. That motion passes unanimously. Number 34.
Item 34, 2014-016-151. Respondent, principal broker, was complainant's property manager. Complainant alleges that respondent charged complainant for repairs to a thermostat that tenant fixed. Complainant further alleges that respondent requested that complainant replace a toilet that did not have any visible cracks, and when a complainant refused and requested that a repairman inspect the leak, respondent terminated services because complainant was being uncooperative. Respondent submitted an email from the tenant stating that tenant fixed the thermostat because it caused a $500 electric bill and the leaking toilet cost a $600 water bill. Tenant further states that respondent sent out respondent's spouse to look at the toilet, who stated the water meter was broken. Tenants further state that a plumber did not look at the toilet to determine if it needed to be replaced. Respondent replied to the response and submitted the monthly statements and repair invoices regarding the property, stating that there is no charge for a repaired thermostat. Respondent states that respondent repeatedly requested permission to send a technician to the property to evaluate the thermostat and repair, but complainant refused, stating complainant would not pay for anything that tenants broke. Respondent states that instead of submitting a work order, tenants fixed the loose wire in the thermostat. Respondent further denies requesting complainant to replace the toilet and states that a work order was submitted for approval, stating that the toilet was leaking. Respondent states the toilet had just been repaired, so respondent sent the firm's maintenance coordinator to avoid a service call from the plumber since the work order was not approved. Respondent further states that services were terminated because complainant was difficult to work with and abusive. Respondent further states that the tenants have no knowledge of documentation on file and were not present during discussions with complainant. Legal counsel examined the documents provided. There is an HVAC invoice dated 1/3/14 that states the heat relay was replaced and refrigerant was checked, but it does not appear that any work orders or invoices were submitted for thermostat repair. It appears that work orders for the leaking toilet were submitted March 8th, 2014 and June 4th, 2014. It also appears that the toilet was serviced on March 8th, 2014, which also includes a note, screw-in thermostat tightened. Recommendation is to dismiss.
Motion to accept council's recommendation to dismiss.
Second.
So we have a motion and a second. Motion by Commissioner Frank, seconded by Commissioner Chara. Did I hear you right? You said there was a screw loose in the house?
I almost got tickled when I read that too. I was like, what?
All right. Sorry.
Just reading the work order.
Inappropriate question by
Yeah.
the chair. Is there other discussion? Are you ready to vote?
Yes, sir.
Let's do it. All in favor of the motion, vote aye.
Aye.
Those opposed, no. That motion passes unanimously. Numbers 35 and 36.
Item 35, 2014-016-161, and item 36, 2014-16162. Trek opened a complaint as a result of anonymous information received that respondents were marketing a hotel in Tennessee without being licensed in the state on their website. Respondents and their principal broker sent in responses stating the real estate firm and the principal broker are licensed in Tennessee. Principal broker states that respondents are licensed in a neighboring state and respondents were working on a property in question through a co-brokerage agreement with principal broker. Principal broker states that they believe that this was the proper course of action when handling an asset in Tennessee and they seek clarification. It appears that a copy of the Tennessee listing was printed from the website on July 9th, 2014, and respondents were listed under the brokers section of the webpage. Recommendation is for each respondent consent order with a civil penalty in the amount of $500 for unlicensed activity in violation of TCA 6213-102-4A, 6213-103, and 6213-301. Said order to also include order to cease and desist all unlicensed activity.
Motion to approve council's recommendation. Second.
Motion by Commissioner Chara, seconded by Commissioner Frank, that council's recommendation be accepted. And now this, I just want to, these guys are asking for a little point of clarification, apparently. And so I think there would be no recommendation, your recommendation would be different if those advertisements were in the name of the Tennessee co-brokerage, alleged co-brokerage, is that correct?
Correct.
But because they were advertised by a brokerage firm outside of Tennessee, not licensed in Tennessee. I think that's exactly right. So if we have to give them guidance, or if they ask for it, they need to advertise Tennessee property with companies licensed in Tennessee.
And
All right.
pay a penalty.
And that.
Well, I'm talking about future. We have to revisit this. They better be advertising with the Tennessee firm. All right, you've heard the recommendation. It includes a $500 civil penalty. It does not include at this point recommendation that they attend a Tennessee Real Estate Commission meeting. It does include a cease and desist order for all unlicensed activity. If you're comfortable with that, we'll vote. Any discussion before we do? Let's vote. All in favor of the motion, vote aye.
Aye.
Those opposed, no. That motion passes unanimously. Number 37.
Item 37, 2014-016171. A complaint was filed against respondent stating that respondent was hired to obtain a tenant and received 1/2 of the first month's rent as commission. Complainant further states that respondent collected a $1,000 deposit from tenant, which was $462.50 too much. Complainants state that they agreed that respondent would send complainant the overage, but respondent has not done so. Complainant included text messages from respondent which states that respondent would mail complainant the balance of funds. Complainant also submitted a receipt for a $1,000 money order. Complainant also submitted the first page of a lease agreement which is between complainant and tenant and has a provision that tenant would deposit $1,000 which appears to be initialed by respondent and tenant. Respondent did not respond to the complaint. Recommendation is consent order for $1,000 for unlicensed activity in violation of TCA 6213-103 and 6213-301. Said order to also include order to cease and desist all unlicensed activity.
Motion to approve council's recommendation.
Second.
I have a motion by Commissioner DeChara, seconded by Commissioner Hills, that this complaint be dismissed per council's recommendation. Not dismissed, excuse me, got ahead of myself. That the respondent be offered a consent order which includes a $1,000 civil penalty.
Is that the maximum?
I think it is, yes.
Because they already have formal charges pending unlicensed activity. Well, obviously, they don't care.
I think in this case it is the maximum.
It might be 1,000 on each one of those.
Hold on one second. Let me look to
6213-3.
be sure. Just because I'm not 100%. Well, I guess. Yeah, your code, your rule says, penalty 50 to 1,000 for 6213-103B. Is that? It says the commission may assess a civil penalty for each separate violation. So. And you have a separate 50 to 1,000 for 6213-301, so.
I'd like to make a friendly amendment, or you can make the amendment.
Let's,
Just go ahead, you can be my friend. Okay. Okay, I'd like to amend that to $1,000 for each of those violations.
all right, if the second will agree to that, and I think the second was Ms. Hills.
Yes, I do.
Okay, so now the motion in front of commission is that the respondent be presented with a consent order that includes a $2,000 fine as well as a cease and desist letter to cease and desist all unlicensed activity. That's my understanding of what's in front of the commission. Is that yours, Ms. Franks?
Yes.
Yours, Ms. Hills?
Yes.
All right, is there discussion on the motion? Let's vote. All in favor of the motion, vote aye.
Aye.
Those opposed, no. That motion passes unanimously. Number 38.
Item 38, 2014-016181. Complainant was the tenant of a property and states that respondent forcibly entered the property by removing the deadbolt and broke the front door to gain entrance to the premises. Complainant states that complainant came home to discover respondent changing the locks and alleges that respondent never requested permission to enter the premises. Complainant states that respondent threatened complainant and stated respondent has a right to enter the premises to show it to prospective tenants. Complainant states that the owner of the property was out of the country at the time and left respondent in charge, identifying respondent as property manager. Complainant further states that respondent has made similar threats to other tenants. Respondent submitted a response stating that the owner of a firm hired respondent as supervising manager, and respondent assists with collecting rents and showing vacancies to prospective tenants. Respondent states that complainant rents a room from a property and owed a total of 4 months' rent. Respondent denies forcibly entering the premises and states that respondent went to collect rent and show a vacant room to a prospective tenant, but complainant would not open the door. Respondent further states that complainant changed the lock, so respondent called the police, who said that since this is respondent's property, respondent had the right to enter. Complainant submitted additional information stating that if respondent had called the police, they would have escorted respondent to ensure there would be no altercation. Complainant further denies being behind on rent and states that if true, the Uniform Residential Landlord and Tenant Act does not allow for breaking and entering. Complainant further states that these issues do not excuse the unlicensed activity. The Office of Legal Counsel performed additional research. It appears that the firm, which is unlicensed, is owned by two individuals, presumably husband and wife. It appears that the wife voluntarily surrendered her license on or about April 30th, 2014. Further, it appears that the firm owners co-own the subject property. Therefore, it appears to legal counsel that the lease and management of this property falls under the exemptions in TCA 6213-104A1, which states this chapter does not apply to an owner of real estate with respect to property owned by such person, and a resident manager for an owner who manages a residential complex where the person's duties are limited to supervision, exhibition of residential units, leasing or collection of security deposits, and rentals from the property. Recommendation is to dismiss.
Motion to accept council's recommendation to dismiss. Second.
I have a motion by Commissioner Frank, seconded by Commissioner Tachara, that this complaint be dismissed per council's recommendation. Is there discussion? All right, let's vote. Those in favor of the motion say aye.
Aye.
Those opposed, no. It's unanimous. For everyone's information, we're going to take one more complaint, take one more break, and come back and finish up the last 13 or 14. So stand by. 39.
Number 39, 2014-016-191. A complaint was filed against respondent alleging mismanagement of rental property, lost electronic records, and unpaid rents. Complainant alleged that respondent has managed his property, 2 duplexes, for over 10 years. During that time, his office had experienced a high degree of employee turnover. Electronic records have been lost. Numerous tenants have gone into collections. Tenants have been allowed to continue to occupy property when there are 6 months in arrears, and deposits have been withheld when they were not returned to the tenant who had been evicted. Complainant alleges that he asked respondent for an accounting to address questions as to where the rental proceeds have gone to no avail. Complainant indicated that an accounting going back as far as 2 to 3 years may reflect an accurate picture as to how the rental proceeds were applied to expenses and net proceeds dispersed to owner. The complaint file includes numerous emails from complainant to respondent requesting such information from respondent, but there does not appear to be responses to those emails. Respondent sent a response to the complaint stating that he has only been managing complainant's property for approximately 5 years, and that his implication that respondent was not cooperative in providing him with information is false. The delay in processing his request was due to a computer problem crash, so the records had to be hand pulled. The information requested has been forwarded to complainant. Respondent states that no tenant has been allowed to stay in a property for 6 months without payment. Respondent further stated that complainant has picked up all the information requested and is going to review it and get back with respondent. Further documentation was requested by legal counsel regarding the accounting documents requested by complainant. The information requested was not received, so we were unable to determine if the accounting was sent in a timely fashion. Therefore, our recommendation is letter of warning regarding TCA 6213-312B5.
Motion to approve council's recommendation.
Second.
I've got a motion by Commissioner DeChara, seconded by Commissioner Hills, that council's recommendation be adopted. Is there discussion?
Yeah, I mean, this person already has a $1,500 consent order for an escrow violation. I think it needs more than a letter of warning. Any discussion on that?
What do you want them to have?
Let me say,
What is the-
from my perspective, look, I think both parties agree this guy's been managing property for 5 years. The same,
5 to 10 years.
The same
Yeah.
property owners. And I can't imagine why that respondent would not have been fired if all these issues were really that prevalent. Is there something you can help us with on that?
I will tell you that the reason the recommendation is a letter of warning was because even though we requested additional documents, after one party told us that the other party had gotten the documents, it just took a little longer than necessary and he was reviewing them. We tried to uncover whether or not that was actually the case, and he did in fact receive all the documents that he had originally requested, and we didn't receive any further documentation, so we were just kind of concerned about whether or not, I guess, we would have enough evidence maybe to go more than a letter of warning because we didn't get any further information, so we really didn't feel like we could prove it either way. That's why it's a letter of warning, but I mean, I respect what you're saying too. I understand where you're coming from, so that's just the reason that it's lower than maybe you think it should be. Sometimes it's hard if you don't have something right there in front of you to go on.
But with that said, I think I interrupted you during a chain of thought.
No.
Were you ready to make a
No.
substitute motion?
No, I won't.
Okay, just checking.
Thought I would, but no, I won't.
Didn't want to talk you out of anything. Don't want anybody to talk anybody out of anything that will leave. All right, the motion on the floor, which is properly made and seconded, says to adopt council's recommendation to send a letter of warning to this affiliate or his principal, just out of curiosity. Principal broker.
Principal broker.
Principal broker, okay. Is there further discussion on the motion? Hear none, let's vote. All in favor of the motion, vote aye.
Aye.
Those opposed, no. That motion passes unanimously. Let's take about a 7 or 8 minute break. We'll try to keep this moving as quickly as we can, but I know you got to move around a little bit.
They were hungry.
He was right.
Right
here.
Some celery.
Yeah, he's right here. All right, ladies, which one has the microphone? Is it
I think I'm good.
just go as long as you can? Keep alternating back and forth, whatever it takes. 40
Okay.
and 41.
Are we ready? Sorry.
Yes.
Okay. Item 40, 2014016251, and item 41, 2014016252. Complainant hired a builder to build her home. Complainant alleges that when she closed on June 7, 2013, repairs still needed to be done, in addition to items under the 1-year builder's warranty. Complainant alleges that she contacted Respondent 1, who's the agent who sold her the house, and the builder to get all of her walk-through items taken care of to no avail. Complainant alleges that Respondent 1 was rude to her and claimed that there was nothing she could do. Complainant alleges she was informed by the realty company that those items would be added to complainant's file and complainant would be updated with appointment times. Complainant alleges she contacted the realty company numerous times to see when the repairs would be scheduled, and they were never scheduled. After being unsuccessful in getting through to the office manager, complainant alleges she contacted Respondent 1 and was informed by Respondent 1 that there was nothing she could do. Complainant is still not satisfied in that she alleges the builder has not fulfilled his contractual agreement for the 1-year builder's warranty that he signed at the close of the house. Respondent 1 sent a response to the complaint stating that he asked complainant if she had written a record of contact with the builder's office via email, to which complainant did not reply. Respondent 1 stated that she provided a completed copy of complainant's contract at complainant's request. Respondent 2, principal broker, stated he has responded to complainant's concerns in a timely fashion at every point of contact within the scope of Respondent 2's abilities. Respondent 2's company was not the listing brokerage for the home at the time complainant purchased it. The buyer's agent was not affiliated with Respondent 2's firm until well after the transaction was complete. The complaint is against the builder, and Respondent 2 has no ownership interest in the builder's company. Respondent 2 stated that it is his belief that there is a dispute between complainant and her husband as the homeowners and the builder as to what terms are covered in the builder's 1-year warranty. Respondent 2 stated he is not a lawyer and is not qualified to offer legal advice to complainant. Respondent 2 suggested complainant contact an attorney to resolve the issue with the builder. The recommendation is to dismiss.
Motion to accept council's recommendation to dismiss.
Second.
We have a motion by Commissioner Frank, seconded by Commissioner DeCharo, that this motion be dismissed per council's recommendation. Is there discussion? All right, I hear none. Let's vote. All in favor of the motion, vote aye.
Aye.
Those opposed, no. That motion passes unanimously. 42, 43, and 44.
Item 42, 2014-016-311. Item 43, 2014-016-312. And item 44, 2014-016-313. A complaint was filed by a licensed principal broker whose firm represented the seller, which was a bank. Respondent 1, principal broker, represented buyer, and Respondent 1 employs Respondent 2 as an assistant. Respondent 3 is the real estate firm. Complainant states that on May 21st, 2014, respondents decided to close on the transaction immediately, despite having executed an extension until May 30th, 2014. Complainant alleges that seller's agent attempted to contact seller's title company to offer assistance and speed closing up. The complainant alleges that Respondent 2 contacted complainant seller directly, violating the Code of Ethics. Complainant alleges this is failure to supervise on Respondent 1's part. Complainant further states that seller is very upset over Respondent's contact, and it has hindered complainant's relationship with the seller, who provides 10 to 20 listings per year. Respondent submitted a joint response stating Respondent 1 is sad that complainant felt a need to file a complaint. Respondent 1 states the transaction was set to close on April 17, 2014, and buyer was expecting a baby and had to take off work 3 times and pay extra every time the transaction did not close. Respondent 1 states the new closing date was set for May 22, 2014, but there was an error on the HUD and seller had to sign off before buyers could proceed. Respondent 1 states the complainant was unreachable by phone, so Respondent 2 contacted seller. Respondent 1 states that seller did not know they were closing on May 22, 2014, and after the phone call, the transaction began to move forward. Respondents denied doing anything unethical and state they were trying to represent the buyer the best they could. The recommendation in this matter is to dismiss.
Motion to approve council's recommendation.
Second.
I have a motion by Commissioner DeChara, seconded by Commissioner Franks, that council's recommendation be adopted and this complaint be dismissed. Is there discussion? Let's vote. All in favor of the motion, vote aye.
Aye.
Those opposed, no. That motion passes unanimously. 45 and 46.
Item 45, 2014-016-511, and item 46, 2014-016-512. Complainants were sellers of a property, and Respondent 2, affiliate broker, represented potential buyers. An offer was received on 2/28, contingent on financing and inspection, and buyers scheduled to view the home on 2/29. Complainants allege they accepted the offer and forwarded it to Respondent 2 on 2/29, but on 3/1, Respondent 2 advised that buyers backed out after viewing and inspecting the home. Complainants state that their agent requested a list of objections, but state that it was not provided within the 10-day resolution period. Complainants state that their agent then requested the earnest money, but Respondent 2 stated there was no binding contract and the earnest money was not owed to complainants. Respondent 1 submitted a response stating Respondent 1 has never seen the contract nor the earnest money as it was not submitted to the office. Respondent 2 told Respondent 1 that there was never a binding agreement date, so Respondent 2 never received the earnest money deposit and at the time canceled the contract. Respondent 2 submitted a response stating that potential buyers felt safe making an offer before seeing the property because it was listed as above average condition, so an offer was submitted 2/28. Respondent 2 states that complainant's agent neglected to point out many flaws in the property and misrepresented the property. Respondent 2 states that when complainant's agent requested a list of objections, Respondent 2 felt that it was not appropriate to use the contract amendment TAR form because the contract did not include a binding agreement date. Respondent 2 states that earnest money was not collected because there was no binding agreement date. Limited documentation was received. It appears the offer was received by complainants late on 2/28, and their electronic signatures were made the afternoon of 3/1/14. The binding agreement date was not filled in. The contract is a TAR form, and states that earnest money will be collected one day after the binding agreement date. An earnest money disbursement and mutual release of purchase and sale agreement was submitted to respondents on 3/25, requesting that potential buyers forfeit the earnest money. The recommendation is to dismiss.
Where's the earnest money?
It was never collected.
Okay. Still did the disbursement.
Why don't you give us a motion and we'll talk about it?
Well, I don't know what motion.
It don't, you can vote against your own motion. That's when it's
I'll
all
give a
over.
motion
Okay,
for it.
I'll make a motion to dismiss it.
All right, there's a motion by Commissioner.
And second.
I'm going to say Commissioner Hills made that motion, and you
Okay, I'll
seconded it.
second it.
The motion is to accept council's recommendation and dismiss. To get it on the floor for discussion, I appreciate the cooperation you two ladies show. Now, is there discussion?
Where's the earnest money?
Ms. Hills?
No
ahead,
earnest money was
There's-
collected.
Well, they have a disbursement then.
I know. That was
And
my
there was
question.
never a binding, it was never
Correct.
signed binding. Okay.
Is it a state law, or is it just a TAR form that has that there has to be a binding day on a contract?
Delivery. And,
Have a beginning date and an
and
ending
end
date.
date.
But not binding contract date.
That,
It
that
has
would
to have
show
it has to have a
delivery.
closing date.
But that shows delivery. That shows
One
delivery
of my
to the other side.
questions is that,
Or
respondent, or that the complainants, said that they didn't want the house on March
The
1st.
complainants were sellers. Complainants were selling the property.
Okay, wait a minute. The buyers withdrew their contract on 3/1, but that's also the same date that the sellers signed the contract.
Right, so
So, but we don't know time-wise if the buyers withdrew their offer before the sellers signed it or not.
Right, so they submitted an offer on the 28th, saw the property on the 29th, withdrew their offer at some point in between, and then around the same time on the 1st, so 2 days after they saw the property.
No, it's
or-
February.
Oh, it is February.
28th.
Never mind. So the next day, they received an acceptance. So the seller signed off accepting their offer, but didn't fill in the binding agreement date. And around the same, that's why there's limited documentation. I'm not sure which came first.
But
There is correspondence in the file between the agents saying that they're not interested in the property.
Selling agent.
The buyer's agent, which is the respondent to the affiliate broker, contacted the seller's agent and stated they were not
if the seller's
interested.
agent then signed it if the seller signed it electronically accepting it, that would have a timestamp.
We could check the timestamps and the timestamps on the emails if you want.
Council's position, there was never a contract.
It's council's position that without the binding agreement date, there was, well, it's,
Delivery.
the problem is with the earnest money. The sellers want the earnest money. The contract that the contract that we have states that the earnest money will be collected one day after the binding agreement date. There was no binding agreement date filled in that same contract.
But that could be an agent not doing their part. That's why the
And that's
time,
why
I
it's up
think,
to
is
you.
real important on when the buyer withdrew the offer and when
Because the
seller
agent's not a
signed it.
party to the contract in the first place, and if you have a meeting of the minds and they've signed it off, whether you write in a blank that this was and use the terms, binding date or not, it's a binding contract.
Was the contract, did I understand you, the contract was subject to an inspection?
Yes.
Yeah.
Yes.
There's the
Contingent on
key to-
financing and
There's the
inspection.
key
They're
to
gonna say
it.
that.
It'll make it, the binding, in my mind, the binding agreement date is irrelevant.
Right.
You've got, it. But if the inspection if it wasn't subject to an inspection, and the seller signed that contract, and he can prove he signed it before they withdrew it, it's a binding contract, in my opinion.
The buyer's inspection and resolution is 10 days after the binding agreement date inspection period.
Had 10 days to inspect it after the binding agreement. So it's, and if he inspected it and it wasn't acceptable, then he had a out if they gave the reasons for why.
Well, here's how it sounds to me. The seller wants the earnest money. He's looking to the buyer for the earnest money. The buyer doesn't have the earnest money.
Right.
I don't know how.
There was no earnest money collected.
Correct.
So they can't disperse any earnest money.
So I'm not sure that there's any recourse.
I got you, John, yeah.
For the agent or for this.
And there's nothing that
well,
said
the
about
contract
his
said
agent.
that the earnest money would be collected 1 day after the signing of the contract.
Right.
Right.
Now, you're saying the binding day, but I'm saying that the day that the contract got signed by both parties is a binding contract.
Yes.
The acceptance of the contract, it is electronic, so it is time stamped by sellers 3/1 at 1:59 p.m.
Contract was written that same day.
Oh, the contract was written on the 28th.
Let me see if I can find the emails between the.
Where the buyer withdrew their offer.
Whether,
Right.
my point, I think, is whether the buyer withdrew their offer or not, if the buyer won't turn over earnest money to the agent, then there's nothing the agent can do.
No consideration, so there's no contract.
Oh, yes, there is.
There may be a contract, but it's
Okay.
still, I don't know if the
You
agent.
don't have to have
This
earnest
might
money
answer it.
to have a binding contract.
The respondent sent an email on March 2nd at 11:38 to the seller's agent, so complainant's agent, stating, after showing the property to buyers and them having an agent to perform initial home inspections, they have decided to withdraw from the contract based on sections pertaining to the home inspections. I will forward the necessary TAR form if necessary with a list of objections.
Oh, the inspection's what they're using
There you
to
have
have
it.
the contract.
All right, we've got a motion to accept council's recommendation and dismiss this complaint. Is there additional discussion? All right, there's a call for the question. Without objection, let's vote. All in favor of the motion, vote aye.
Aye.
Those opposed, no. That motion passes unanimously. 47 and 48.
Item 47, 2014016521, and item 48, 2014016931. Two complaints were filed against respondent by a husband and wife who are sellers who are divorcing. Complainant 1 states that their home was viewed and the potential buyers gave excellent feedback. Complainant 1 requested that respondent follow up, and respondent told them that the potential buyers did not want vinyl siding, but complainant 1 states that their home does not have vinyl siding and alleged that respondent showed negligence and misrepresentation, costing complainants the sale of their home. Complainant 1 requested to drop the price of the home and alleged that respondent failed to get permission from complainant 2. Complainant 1 further states there is a violation in the listing of familial status. Complainant 1 alleges that respondent did not show reasonable skill and care, misrepresented the property, and lacked overall communication between the parties. Complainant 1 provided text messages regarding the miscommunication of vinyl siding, where respondent states that buyer's agent called it vinyl, and respondent called back and left a message explaining that the siding is hardy board. Respondent also states in the text that respondent checked the MLS and it states that the siding is fiber cement because hardy board is not an option. It appears that the MLS says fiber cement vinyl. Complainant 2 states that respondent failed to notify complainant 2 or get consent when lowering the price on their home. Complainant 2 further states that respondent ignored repeated requests of being notified of any showings taking place and feedback. Complainant 2 further states that respondent lost a deal regarding the vinyl siding. Complainant 2 states by listing the home as the family home, it discourages non-family buyers from even looking at the home. Respondent submitted a response stating that the buyer's agent requested information on the siding, and respondent admits that respondent was not sure how to answer the pros of fiber cement siding. Respondent states that the buyer's agent gave feedback that the buyers did not want an all-vinyl home, and respondent regrets not immediately correcting the agent. Respondent believes that this misunderstanding did not cost complainants the sale, but that their property is on a big slope with a complicated driveway. Respondent states that the complainants were married when the property was listed but began divorce proceedings, causing complications in communication. Respondent states that when complainant 1 requested a price reduction, respondent reduced the price and later spoke with the complainant 2, who okayed the price reduction. As far as the familial status, respondent states that an assistant listed that it was a family home in a good neighborhood. The buyer's agent sent in a letter stating that buyers did not want a house with all siding but brick. Buyer's agent states that respondent did not misrepresent siding as vinyl, and MLS was listed that siding was fiber cement and trim is accurately listed as vinyl. Buyer's agent states that buyers found a home they liked better with a bigger yard. Recommendation is to dismiss.
Motion to approve council's recommendation.
Second.
We have a motion by Commissioner DeChara, seconded by Commissioner Franks, that this complaint be dismissed per council's recommendation. Discussion. Let's vote. All in favor of the motion, vote aye.
Aye.
Those opposed, no. That motion passes unanimously. 49, 50, 51, and 52. Long one, unfortunately, but we get 4 out of the way.
We do get
Jenica.
4 out of them. 49-2014-016-871, 50-2014-016-872, 51-2014-016-873.
Are those 20 or 50? Are you saying 50?
I think she's saying the item number
Bring the
4950
number
and then the
case
number of
number.
the.
Okay, I'm sorry. I'm sorry.
Sorry. We're going backwards.
I
We're
thought
now on number
this was the
20
right
again.
number on the record. Okay, sorry.
Oh.
Gotcha.
51-201.
Not appropriate for council to be laughing at commission. I just want to-
I'm not counting.
I'm just like, we're going backwards now.
Just ignore commission.
Okay,
It's
she's
been
had
a
a
long
delay.
day.
I think I left off on 51-201-4016873. 52, complaint number 2014-016-874. A complaint was filed by a seller against buyer's agents and seller's agents. Respondent 1 is principal broker for Respondent 2, affiliate broker, who were seller's agents. Respondent 4 is principal broker for Respondent 3, broker, who were buyer's agents. Complainant entered into a binding contract with potential seller who required multiple items to be repaired as a result of a home inspection. Complainant expressed concern with Respondent 2, who assured that if buyer walks away after repairs were complete, the buyer would be in breach of contract. Complainant wanted to use complainant's father, a contractor, to complete masonry repairs, and complainant alleges that Respondent 2 said that a third-party vendor needed to perform the work. Complainant wanted to walk away from the contract at that point, but alleges that Respondent 2 told complainant that that would be breach of contract. Complainant states that after repairs were made, the buyer walked away, and states that Respondent 2 should have collected more than $500 in earnest money to protect complainant's interests. Complainant also alleges that complainant has not received the earnest money and states that Respondent 1 said the matter was turned over to an attorney. With regard to buyer's agents, complainant states that there was a shed on the property that was not included in the sale, and complainant did not have enough time to disassemble it by closing date, so complainant sold it. Complainant states that a few days before closing, Respondent 4 told complainant that the shed was part of the contract, stating that it was bolted to the concrete foundation. Complainant states that Respondent 4 requested that the complainant return the money to the buyers of the shed, but complainant was not willing to do so since a bill of sale had already been signed. Complainant states that Respondent 2 contacted complainant expressing concern that the deal may not go through because of the shed, and told complainant that Respondent 4 made a mistake by not including it in the contract. Complainant states that Respondent 4 contacted the buyers of the shed and stated Respondent 4 would buy back the shed out of Respondent 4's commission, but complainant alleges that Respondent 4 has not paid the buyers of the shed. Complainant also states that the home buyer had 24 hours prior to closing to do a walkthrough, and states that the buyer did so without permission or without agents present, stating that they found a small amount of water under the crawl space after record-setting rain, and Respondent 4 failed to secure a clear flood certificate prior to closing, which delayed the closing that never occurred.
Respondent 2, complainant's seller's agent, responded stating that Respondent 2 advised complainant that the seller ran the risk of buyer walking away from the contract if repairs weren't done to buyer specifications that were listed in the buyer's inspection contingency removal notification. Respondent 2 also states that contingency form stated that the repairs were to be handled by a licensed and bonded contractor, and complainant's father was not licensed at the time of the transaction. Respondent 2 denies assuring complainant that buyer would not walk away and stated that anything can happen in a transaction, but Respondent 2 worked hard to ensure that everything went smoothly so it would close. Respondent states that after the transaction fell through, Respondent 2 advised complainant to speak with Respondent 1 about the earnest money. Respondent 2 confirms that Respondent 2 told complainant not to sell the shed to anybody else until a home buyer had the opportunity to purchase it. Respondent 2 states that Respondent 2 worked hard to sell complainant's home and did so ethically. Respondent 1 submitted a response stating that the firm hates to see the transaction fail to reach the closing table. Respondent 1 understands that complainant's frustrations and need for assurances, but states that they are promises that Respondents 1 and 2 could not give. Respondent 1 states that Respondents 1 and 2 gave complainant options, but the transaction was complainant's decision. Respondent 1 states that Respondent 1 spoke with complainant several times and may not have always given complainant the answer complainant wanted to hear, but gave the best answer with Respondent 1's knowledge and experience. Respondent 1 states that the buyer chose not to proceed after the final inspection, although respondents were in the process of answering buyer's questions, and buyers requested the return of their earnest money. Respondent 1 states that complainant did not agree to the request, and he wanted the option to sue buyer for breach of contract. Respondent 1 states that the earnest money was submitted to respondent's attorney for an interpleader within 21 days as required by the rule. Respondent 4 submitted a response stating that the contract was bound on October 8, 2013, stating there were 5 executed amendments to agreement, which included a 6th that the buyers did not execute. Respondent 4 states that all amendments were to extend the buyer's inspection and resolution due to non-performance of complainant. Respondent 4 states that Respondent 2 called on November 29th, stating that complainant wanted to sell the shed and buyer was given the first right of refusal. Respondent 4 states that the buyer was out of town and would be back the following Monday, but complainant sold it before then. Respondent 4 states that Respondent 4 went to the property to inspect the shed and learned that it was not permanently anchored to the concrete pad, and complainant offered the contact information for the buyers of the shed. Respondent 4 contacted the buyers of the shed and stated that the home buyer is interested in purchasing the shed but wanted to wait to see if the deal went through, and states that the buyers of the shed were contacted once the deal fell through. Respondent 4 observed that the shed has been removed from the property. Respondent 4 states that during the final week of closing, the lender notified the buyer that the home was determined to be in a floodplain and the lender needed to obtain new flood certificates, but the surveyor could not survey the property until after the closing was to occur. Respondent 4 and the buyer performed the final walkthrough and discovered that running water and standing water were prevalent in the crawl space with the constant light rain. Respondent 4 states that the earnest money disbursement and mutual release of purchase and sale agreement form was immediately executed and forwarded to Respondent 2, and the earnest money was forwarded to an attorney for an interpleader. Respondent 4 states that the survey was performed and another inspection was completed to inspect the water problem, and the buyer was not happy with the result. Respondent 3 submitted a response stating Respondent 3 was not the broker and another licensee was the broker at all times relevant to the transaction. Respondent 3 reviewed the transaction and states that Respondent 4 acted in good faith through the transaction, diligently representing the interest of the buyer while keeping all parties' interests in mind to ensure the spirit of the agreement was carried out. It appears to legal counsel that all contracts and documentation are in order and the transaction fell through due to standing water. There seems to be a question of whether or not this is a cosmetic problem, hence the earnest money interpleader. The Office of the Legal Counsel followed up regarding the interpleader action, and it appears that it was filed on March 19, 2014, and a judgment was reached on April 24, 2014, awarding the earnest money to complainant. The recommendation is to dismiss.
Motion to accept council's recommendation to dismiss.
Motion by Commissioner Frank, second by Commissioner Hills. This complaint be dismissed per council's recommendation. Is there discussion? Let's vote. All in favor of the motion, vote aye.
Aye.
Those opposed, no. it's unanimous. Just as a, personally, ladies, if I had to write that, what you just read, I would kill myself.
Well, imagine writing 55.
Do you guys do
Imagine reading 200 pages and then writing it.
All over a shed.
I'm telling you, ladies and gentlemen, these ladies have to compile mountains of information into a narrative that should make sense and not identify anything, and it would drive me freaking crazy, I'll just tell you. It's a great job. Congratulations. Let's keep going. What's next?
Well, we need to vote on that.
Did we not vote on it?
We did.
We did.
I thought we did. Are we, we've got another one, or are we done?
We're done.
Did you? We have the
We
supplement.
have supplement. Do you guys have that?
Supplement.
There are only 3 on the supplement.
Where is the
Do
supplement?
you have the supplement?
It should have been loaded as
let's see.
well. If not, I can go print some.
Or we can just read
We just read them.
Received that. I mean, it was,
Yeah,
it was emailed to you. I mean, like.
It
so
was.
It's not loaded.
Right.
Okay.
It might not, but it,
Sorry. We tried to add more for us to make copies, or
Oh, well, let's listen and see. Can you show me how long you're about to read is?
It's 3 pages,
Oh,
4,
God.
3.5.
one of them was a matter that was in litigation monitoring.
One of them
And
is
that's
a
the longest
represent. One's a represent. So the facts from the previous commission meeting are on here. So if
Let's,
you
let's,
want
let's get
And the other
started.
two are
If we can't
timeshare.
take it, we'll let you know, okay?
Okay, if the others are not very long though.
They are.
Let's start. Let's take. I'd like
Here,
to.
John.
You
Use
have,
mine.
where'd you get it? You printed
Send it to them.
I get my material.
One of our more conscientious members on this
Just more
commission is Diane
studious.
Hills from near the Virginia border, apparently.
Yep.
All right, let's go with number 53.
Before I read, would you like for me to read the whole thing again, even the previous from the?
Would you move to the microphone? Tell us generally what it's about and what we did and why we're back looking at it.
Okay, it's item 53, 2013-013-011, which was previously presented at the October 2013 meeting, which I was not at. So basically, I'll just try to jump through and try to figure out. The previous recommendation was for a consent order for litigation monitoring because it stated in October there's active litigation between complainant, the property owner, respondent, and respondent's auction firm.
I'm going to interrupt you.
Okay.
In the printed copy, after this went to recommendation which council adopted was to a consent order for litigation monitoring. Subsequent to that, and this is why it's back, the respondent's attorney provided additional information that an agreed order of compromise and dismissal was filed in Chancery Court on October 28, 2014. The settlement agreement between the parties is confidential and was not provided to legal counsel. So, with that background, your recommendation is to dismiss this, and tell me why we should dismiss it.
Well, since the settlement agreement between the parties wasn't provided to council, we don't have any additional evidence to go forward from the litigation monitoring order. Nothing showed up to us that said, hey, there's a violation. So at this point, if you don't get anything there's no point in monitoring the litigation any further because it's over. And there was nothing presented to us that showed a violation of any of TREG's laws and rules. So at this point, it only makes sense to dismiss.
That's what I'm looking for. Is there a motion?
I make a motion, we accept council's recommendation to dismiss.
I have a motion by Commissioner Chara, seconded, and I'm sorry for interrupting you, Commissioner Franks, to dismiss.
The way we roll.
It's fine.
Don't take it personally.
Thank me for bringing the
It's been a
copies
long
here.
day. We're
I understand.
54.
We're almost there. 54, 2014015951. Complainant state respondent will not release complainants from their timeshare contract and the salespeople misrepresented complainants.
Motion to dismiss.
Second.
I have a motion, and I will explain this to the audience in a second. We have a motion from Commissioner Chara to dismiss. Mr. Chara, and a second by Commissioner Franks. And we really have no authority at all on timeshare. And so as soon as Mr. Chara heard the word timeshare, she said, let's dismiss this thing. Frankly, we've not seen this complaint. We've not even had a chance to read it. And so I'm going to ask the commission, except for Ms. Hills. of
You
course.
have seen it.
We got it.
You got it?
I sent it by email.
It came by email to y'all.
Okay, let's vote.
Some of us read those things.
Can I clarify?
Would you please?
You do have authority over timeshare. It's very limited. The rules aren't nearly as extensive, and a lot of the times the contracts say something else from what the complainant alleges. Their contracts are very
We know all about
detailed.
timeshares. Move on.
So, just to the audience, there is authority here, but
We've got authority.
we review the contracts for you.
But frankly, every timeshare complaint we've ever heard, the paperwork is impeccable. It's just the paperwork contradicts what the complainant thought they heard from the timeshare salesman, which is just he said, she said kind of stuff.
Call for the question.
Thank you, Mr. Alexander. The question has been called for. Let's vote. All in favor of the motion, vote aye.
Aye.
Those no. Chair abstains. The vote is 5 ayes, no noes, and 1 abstention. I haven't read
Plus
it.
he hadn't read it. He didn't do his homework. Okay.
Maybe I was doing other more important things than reading about timeshare stuff. You know, you just never, ever know. Maybe I'm, no, one more, number 55.
Oh, we're on to the last item. Item 55, 2014-016-011. Complainant states that complainant interviewed with respondent and was offered a position, but due to scheduling conflicts, complainant's start date was
Make
put
a
on.
motion to dismiss this one,
You can make any motion you'd like to, anytime you'd like to.
please. I would like to make that motion.
Second.
I have a motion by Commissioner Char, seconded by Commissioner Franks to what?
Dismiss.
To dismiss per council's recommendation. All right, is there a discussion?
Is it a timeshare thing?
Yes.
Okay.
All right, I don't hear any other discussion. Let's vote. Those in favor of the motion vote aye.
Aye.
Those opposed, no. Chair recuses himself, abstains. The vote is 5 ayes, no noes, and 1 abstention. I think, ladies and gentlemen, I want to tell you one thing. Don't forget to sign out. Don't sign out yet, but whatever you do, don't forget to sign out, or you get to do this over again another day. And the second thing I want to tell you is we start back tomorrow promptly at 9 o'clock. The judge expects us to be in our seats at 9 o'clock, and we expect you all to be here as well. Anything else from any member of commission? All right, this session is on hold until tomorrow morning at 9 o'clock. We'll see you then. All right, ladies and gentlemen, we're ready to begin. At this time, I'll turn the proceedings over to Judge Wilson. He'll give us guidance as we go through the morning, and we'll conduct the proceedings. Judge Wilson.
Okay. Good morning, everybody. I'm Rob Wilson, been assigned by the Secretary of State to preside over the hearing of this matter. In matters like this, the Commission sits as their own jury.
Judge, I hate to interrupt you, but would you move that microphone right there so we can?
Thank you. Okay.
Thank you.
Alrighty. Good morning. I'm Rob Wilson, assigned by the Secretary of State to preside over the hearing of this matter. As the gatekeeper of evidence, this is a hearing before the Tennessee Real Estate Commission, which sits as their own jury in matters such as this. We're here this morning in the matter of Thomas Williams. It's docket number 12.18-124-814A, and the matter was set for this morning, 9 o'clock. Just for the record, I did just speak with Mr. Williams' attorney, Mr. Weissman, and Mr. Weissman did inform me that they were aware of the hearing and I had chosen not to attend. Let's see. The date is December 4th, 2014. Again, this is a hearing conducted by the Tennessee Real Estate Commission to consider the matter of Thomas Williams. Okay. Let's have the board members just one time introduce themselves for the record, if we could start at the left.
My name is Marcia Franks.
Janet DeChara.
John Grease.
Diane Hills.
Wendell Alexander.
Okay, those are the board members, and Mr. Chairperson, does this constitute a quorum?
Does, Your Honor.
Okay, we have a quorum of the board. Members of the board are reminded that during the hearing, you'll have an opportunity to question each witness under oath. There will be questions from just one lawyer, and then and that's it. With the opening statements, again, are optional, and closing statements. The Sunshine Law requires that all board discussions be in public and before all parties. Please don't draw any conclusions until all the proof has been submitted. One other question, does anyone have any prior knowledge of this matter with Mr. Williams that would prohibit them from making a fair decision right now? Okay, there are no disclosures for any communications from the board. I believe that's it. Let's go ahead and list the technical record. The technical record in this matter is a February 20th, 2014 notice of charges. There are several orders of, one agreed order of continuance. There is a witness list from the state, attorney for the state. And a separate continuance, which was granted before from Mr. Weissman on behalf of the client. And a scheduling order scheduling the hearing for this morning, this location. We'll go ahead and mark that as the technical record in this matter. Let's get our witnesses sworn in. That's everybody that's going to testify in this matter. If you can raise your right hand and answer in the affirmative, do you solemnly swear or affirm that the testimony you're about to give will be the truth?
Yes, I did.
Okay, witnesses are sworn in. If any other witnesses join that aren't here now, we'll swear them as we go along. Rule will not apply, and did you want to distribute anything to board members before?
Yes, Your Honor, I'd like to distribute the notice of hearing and charges to the board members.
Okay, we'll do that. This is State's Counsel Robin Ryan, and she'll be representing the state on this matter. As you know, Mr. Weissman is not present, although I did just speak with him. It matters because we're certain that there was proof of service, but do you want to submit anything?
Your Honor, I actually would like to put on the record the history so that we do have a clear finding of default if possible.
Okay, let's go ahead and after those are distributed, we'll go through and we'll have a summary of the history, what has transpired so far. The state has indicated that they would like to make a motion for a default judgment. And what evidence do you have?
Thank you, Your Honor. This matter was filed on February 23rd of this year. I think it's the 23rd. It could be the 28th or the 20th. I can't read my copy. It was filed in February. It was signed for and served on Mr. Thomas Williams' address at 254 Winbrook Drive, Suite 110 in Memphis, Tennessee, signed for by someone at that office of 225 of 14. That is the address on record for Mr. Williams. Mr. Williams did have an attorney who filed a motion for continuance and notice of hearing, and that was filed in April, as the hearing date was originally set for April. That motion was granted and it was continued to a September date. The judge was September 11th. The judge was not available, so the attorney and I entered an agreed order to continue it on September 11th to this date. I would ask the court to find that this is sufficient proof to show that the party was served. Let me put this in as well. Not only that, I've had communication with Mr. Williams' attorney via email, and at the request of Mr. Williams' attorney, I presented to this board yesterday a motion on his part, or request on his part, to appear only via telephone, which was discussed by the board and then determined to be denied. Based on all of this evidence, I ask that we be granted a default judgment and be allowed to proceed in this manner.
Thank you. I find that Thomas Williams has received adequate service of notice on this hearing, as well as his attorney, pursuant to Rule 1360-4-1-.15 of the Secretary of State's Rules of Procedure. The board or commission may now decide whether to grant or deny the state's motion to default, taking into account what Ms. Ryan just related.
Is there a motion from any member of the board?
I make a motion to go forward with this default hearing.
I'll second.
Is that a proper motion, Your Honor?
Yes.
Okay, that's the motion on the floor. Ladies and gentlemen, is there discussion on the motion? All right, let's vote. Those in favor of that motion vote aye.
Aye.
Those opposed, no. That motion passes unanimously.
Okay, the commission has decided to go forward with this default proceeding and put absence on the record in Mr. Williams' absence. That being said, I believe that brings us to our hearing.
Thank you, Your Honor. I would like to make a brief opening statement. This matter here today involves an escrow account. Specifically, proof will show that this respondent, Thomas Williams, had an escrow account that was not funded correctly. This was found as a result of an audit in April of 2013. When it was discovered, there should have been $5,000 in the escrow account, but instead the balance was $1,416.57, a shortage of $3,583.43. As a result of that audit, the present complaint was opened, and Mr. Williams responded, admitting that the shortage occurred when Mr. Williams had issues. Proof will show that in that response in May of 2013, Mr. Williams promised to have the account fully funded again by June the 4th. Mr. Williams stated in a subsequent letter of 9/3 that he was not able to clear up this issue, and that as of that letter date, the account was, quote, shorter than in the original reply. Proof will show that Mr. Williams at that point included a bank statement that showed a balance of $0 in that subsequent letter. Follow-up information showed that in October, the account was replenished in the amount of $3,000, and that respondent expected to furnish the additional $2,000 by later that same week. Proof will show that finally, in November of 2013, the account was fully funded. The issue in this matter is improper and poor handling of monies not owed to Mr. Williams in violation of 6213-312-5 and violation of 6213-4036 for untimely accounting for trust fund deposits. We assert that this is a pretty serious matter, and that, as far as I know, Mr. Williams has no legally acceptable reason for failing to follow the legal responsibilities assigned to him as a Tennessee real estate licensee. I will tell this board further that Mr. Williams has had a license for a number of years, and that you will hear from his complaint history that he does not have any real prior complaints, although there were 2 complaints in 1995, but other than that, his record is clear, and that my understanding he is 74 years old. And I think you should take those things in consideration, but I would suggest again that this is still a serious matter, and I'm asking that you find accordingly. Thank you.
Okay, do you want to go ahead and call your first witness?
I do. I call Eve Maxwell.
She disappeared.
This is better.
State your full name
Eve M. Maxwell.
and your position with the state of Tennessee.
I'm the Executive Director of the Tennessee Real Estate Commission.
And as the executive director, are you familiar with both the license file and the complaint files of Mr. Thomas Williams?
Yes, I am.
When was he first licensed?
Mr. Thomas Williams holds license number 54040. He was first licensed as an affiliate broker on 7/24 of 1969. He was licensed as a broker on 8/13 of 1974. He became the principal broker of his firm which is T. Williams Realty number 55736. And he became the principal broker of that firm, on 6/17 of 1997.
Is that firm currently licensed, as far as you know?
Yes, that firm is currently licensed. It has a license that will expire on 10/12 of 2016.
Does Mr. Williams have affiliates working for him in this firm?
He has, according to the TREC records, he has one affiliate working for him, and that's the only individual who's working for him.
And you are then also familiar with this present complaint file against Mr. Williams?
Yes, I am.
When was it opened?
The complaint was opened on 4/13 of 2013.
And the reason it was opened?
It was opened, one of our auditors, field auditors, had gone to his firm to do a field audit and went and looked at the escrow account and found that there was a shortage in the escrow account, which Mr. Williams recognized was a shortage. As a matter of fact, I believe it said that to the auditor when he came in. And so he came back and brought the results of his audit, and we opened a complaint because of the shortage in the escrow account.
Let me ask you about the process for auditing licensees in the state. Is there a rule or a law or something that gives you power and permission to audit licensees?
Yes, there is. There's a section of 6213-312 which gives the commission the authority to go in. It's 312D, and it states the director of the Division of Regulatory Boards or the director's duly authorized representatives may at all reasonable hours examine and copy such books, accounts, documents, or records as are relevant to a determination of whether a licensee has properly maintained and dispersed funds from escrow or trustee accounts required hereunder. And then it goes on to talk about what happens if you refuse.
So this was a common practice then for auditors to go to the licensees' offices in the state and audit their accounts?
Yes, it was. It was. We tried to audit every firm every 2 years, and so the auditors regularly went around and did that.
Who was the auditor in this matter?
The auditor in this matter was Johnny Kidd, who has since retired from the state, but he was the person who was doing the Memphis area at that time.
And are audits now also something that the TREC is still doing for licensees?
Yes, we do continue to do audits. We now have a mail-out audit that we send to principal brokers. They fill it out, and it contains all their financial information, their reconciliations, and we have an auditor on staff who then reviews all those, and if there's a problem or a question about those, he contacts the firm. We feel like that's a very important part of protecting the public and making sure that the brokers and the firms comply with the statutes and the rules of the Tennessee Real Estate Commission.
Was the audit that was provided by Mr. Kidd a part of this complaint file?
Yes, it was.
May I approach the witness, Your Honor?
Yes, that appears to be a copy of the audit, which I have.
Thank you. Your Honor, may I pass a copy of the audit?
Yes.
What is the date on this audit, Ms. Maxwell?
The date on the audit is, was signed on 4/12 of 2013 by both Mr. Kidd as the auditor and Mr. Thomas Williams as the principal broker. As I say, they both signed it on 4/12 of 2013.
Would you look at page 3 of the audit? And the bottom of that page, could you read what Mr. Kidd found?
It says balance per bank statement 2/28/2013, $1,419.57, should be $5,000. Escrow account is $3,583.43 short.
Did Mr. Williams, again, did he sign this audit?
He did sign this audit.
If the court please, I'd like to have the audit admitted as exhibit number 1.
Go ahead and mark the audit that's been distributed as exhibit number 1.
As a result of this audit, you said earlier that a complaint was then opened?
Yes, it was.
And was a copy of the complaint sent to the respondent?
Yes, a copy of the complaint was sent to the respondent.
Was there a response filed by him?
There was not a response filed in the time frame allotted by the statute, which is 10 days from the date of receipt. But we did ultimately receive a response. It was dated, it was a letter, and it was dated 5/10 of 2013. It was transmitted to the legal department on 5/22/2013. So I believe that it was received by TREC on 5/22/2013.
And that was included then prior to it being presented before this commission?
That was included prior to that, yes, it was.
Can you find that letter for me?
Yes.
Can you please read that letter into the record?
Yes, it's from T. Williams Realty Company, and it's Ray Trek docket 201300825. And it's addressed to Mr. House, who was our former complaint coordinator. Dear Mr. House, this sworn statement is a response to Trek docket 201300825, which involves an escrow shortage. This matter occurred when I encountered some very urgent obligations that I normally have been able to control. There was some future income that I had worked very hard for and was sure it would be available to me in a timely manner. However, after I used funds from the escrow account, that income which I expecting did not materialize. My actions was a clear violation. However, there was never any greed involved, nor was there any type of personal gain, because what funds I used was strictly for some installment payments. The account will be fully funded on or before June the 4th of 2013, at which time I will be able to furnish proof of same. At this time, I would like to express my regrets for my actions and ask that any compassion and leniency that you can provide me in this matter will be greatly appreciated. Sincerely, Thomas Williams.
Your Honor, if I might pass a copy of that to the commissioners and have that entered as my next exhibit?
Yes, we'll go ahead and mark the letter from Mr. Williams as exhibit 2. And what is the date of the letter?
The letter dated May the 10th, 2013.
Okay, May 10th, 2013 letter from Mr. Williams.
Maxwell, did Mr. Williams respond further to the commission or the legal department concerning this matter?
He did. It appears on September the 3rd of 2013. The complaint file shows that there was a letter addressed to Julie Kropp, who was a Trek attorney at the time, and it concerned Trek docket number 2013-00825. That letter says, Dear Ms. Kropp, in reference to the escrow shortage and our conversation earlier today, I will explain it this way. When the auditor came April the 12th of 2013, I explained to him about the shortage, which is shorter now than what it was.
I'm sorry, what letter are you reading?
September the 3rd.
Okay. Before you read that letter, is there a letter prior to that dated September the 1st?
Yes.
Thank you. Could you read that one first?
Yes.
Thank you.
That likewise is addressed to Ms. Kropp. Trek docket 2013-00825. Dear, and it's from T. Williams Realty Company. Dear Ms. Kropp, in reference to the real estate sales contract, November 20th, 2012, that contract is still open and active. I will give you the various delays in the order in which they occurred. However, I'm unable to give you a timeline on each occurrence. The original contract was an all-cash contract. That was number one. 2, within approximately 2 weeks, the buyer decided that he wanted to get commercial loan through First Tennessee Bank. He did apply to bank. During processing of the loan, the bank wanted certain EPA documents from the seller, and the seller complied, but the bank said that this information did not meet the bank standard and that they needed more EPA testing, and this went on for several months. 3, the buyer decided that he wanted the seller to accept a down payment and he would execute a promissory note for the balance of the sales price, and the seller agreed. 4, in the process of moving toward a closing with title search and everything, the closing attorney discovered a large lien on the property. However, the buyer said that he had been to court on the matter and his attorney said it was settled and he did not owe anything. The seller took several months trying to get this lien cleared, but his attorney did not try to help him. The closing attorney, the buyer, and the seller decided on a way to close it without the lien being cleared. 5, during most of this time, the seller's wife had some type of illness, but later became very ill and was in and out of the ICU unit. She is currently in rehab. Presently, there is no closing date set. However, the buyer and the seller is in agreement on everything and say the sale will close. Sincerely, Thomas Williams.
Is there an additional letter attached to that?
There is.
And who is it addressed to?
It's addressed to the Board of Commissioners from Thomas Williams.
Can you read that?
Yes, that's dated September the 1st, 2013 as well, from T. Williams Realty Company. Dear Commissioners, I entered into the real estate business in 1969. I've witnessed thousands of salespeople who got out of the business years ago. I've elected to stick it out because I truly love the business and it can be rewarding. I've managed to survive numerous downturns since I've been in the business, including 3 or 4 major recessions and interest rates as high as 18%. I consider myself to be a strong and stable person. I have been married for 50 years, lived in the same home for 45 years, and the same phone number for 45 years. Is this to say that everything has been perfect? Of course not. People have struggles in life, but you have to be strong enough to hopefully overcome them. During my approximately 42 years in the real estate business, my E&O insurance have not been required to pay anything on my behalf. Does this mean that a rule violation should be overlooked? No, it do not. A violation is a violation. What I'm asking at this time is that any leniency that you can provide me in this matter would be more than appreciated. Sincerely, Thomas Williams.
If the court please, I'd like to have that entered it by next exhibit and give it to commission.
Okay, we'll mark, and is that a collective of both letters?
Yeah, it's part of one document that was sent to us at the same time, yes.
Okay, we'll mark that as exhibit number 3. And I'll add 2 letters from Mr. Williams, September 1st.
Was there a subsequent letter sent to Ms. Kropp?
There was a subsequent letter sent September the 3rd of 2013 to Ms. Crop, Ray Trek docket 2013-00825 from T. Williams Realty Company. Would you like me to read it?
Please.
Dear Ms. Crop, in reference to the escrow shortage in our conversation earlier, today I will explain it this way. When the auditor came April the 12th of 2013, I explained to him about the shortage, which is shorter now than what it was at the time of the audit. Those funds for the Barron Avenue contract has always been as far as the shortage, the funds in question, as I said in my original reply. There is no consultation for me in this matter. If there was, I suppose it would be the fact that not any of the funds was spent for personal gains, instead just all for financial life-saving matters. I find myself in this situation, and so far have not been able to clear it up, yet realizing it could happen any day now. This is a completely true statement in this matter, and if I could reverse everything, I would, but of course that opportunity is not available. Sincerely, Thomas Williams.
Did he attach anything to that letter?
He did. He attached his, I guess it's a banking, from his bank, it appears to be a statement with some banking transactions on it, and it shows that his opening balance in this particular statement was $246.57. This is the T. Williams Realty Company business checking account, and that it goes on the funds available. The closing balance is initially $246.57. The last statement was 8/31/2013. And then when you look at the transactions that have taken place, there was then a check withdrawal for $246.57, which was the amount of the balance at the time, which left an available balance of $0 in the account.
And the date then?
The date of this is all transactions 8/5/2013 to 8/31/2013.
Subsequent to that, did his attorney also provide information?
There's a bank statement from his attorney dated November, let's see, November the 1st or 2013.
And could you read the letter from the attorney into the record that covers that bank statement?
Yes, this is a fax that came to Julie Crop, and it's from Larry Weissman, Weissman, Ray Thomas Williams, the complaint number 2013-008251.
Excuse me, did I enter that last letter as an exhibit, Your Honor?
Let's go ahead and mark that
Please,
as
I'm sorry.
State's Exhibit number 4. That's okay. And the date of that letter was?
September the 3rd.
Okay, September 3rd letter from Mr. Williams as well.
Apologize. Thank you. Go ahead and read this one, please.
Yes, the fax cover sheet is dated 11/4/2013, and this is the cover message. Ms. Crop, accompanied is a copy of Mr. Williams' bank statement that shows that he $5,036.57 on deposit in his real estate escrow account at Renaissance Bank. The branch is located at 5240 Poplar Avenue in Memphis. They can be reached at 901-684-0670. I cannot read the signature of the teller that provided Mr. Williams with the statement, but she is teller number 311. If there's anything else you need at this time, please get back to me. Larry A. Weissman, attorney at law.
And accompanying that is a copy of the statement, is that correct?
Yes, and the statement has got a November 1 of 2013 stamp on it, and likewise does have, I can't read the initials of the teller either. It shows a ledger balance of $3,011.57, and then the closing balance is shown as $5,036.57.
And that is in November of 2013, is that correct?
That is correct. That's what it showed after there was apparently a deposit on that day of $2,025, which was added to the $3,011.57 to get that $5,000 total.
Looking back at all the documents, the transaction in question, do you know the date of that transaction when the money should have been in the bank?
When the
You might find that in the audit.
yes.
Yeah, okay.
The audit, which was done by Mr. Kidd, shows that there was a contract for sale of real estate, which Mr. Kidd had gotten a copy of while he was doing the audit and attached to the audit paperwork. And that contract has an 11/20 of 2012 date, and it says that received of Abdu Mohammed Al-Jami the sum of $5,000 as earnest money. And as I say, the contract appears to be dated 11/20 of 2012.
Before we go any further, Your Honor, I'd like to enter that last letter from Mr. Weisman on behalf of his client as the next exhibit.
Okay, and that will be exhibit number 5, and that's a fax from Larry Weissman, 11/4/13, with a bank statement. Thank you.
And let me go on.
Ms. Maxwell, do you have something to add?
Well, yes, I just was going to add that along with that contract, the Johnny Kidd, the auditor, also got a copy of the deposit slip from that $5,000 where it was placed in the T. Williams Realty Company escrow account. Appears to have the date of 11/20 of 2012 on it as well.
What laws govern escrow account handling?
There are several that actually govern escrow accounts. 6213-321 requires the establishment of an escrow account. 6213-323 says you either have to have that or a waiver. In Mr. Williams' case, he actually did have an escrow account pursuant to the statute. The rule 1260-02-.09 speaks of the deposit of the earnest money and the accountability for the earnest money. It says brokers are 1260-02-.09(3) says brokers are responsible at all times for deposits and earnest money accepted by them or their affiliate brokers in accordance with the terms of the contract. And number 4 goes on to say, when a contract authorizes a broker to place funds in an escrow or trustee account, the broker shall clearly specify in the contract the terms and conditions for disbursement, the name and the address of the person who will hold such funds. And then it goes, that particular section goes on to discuss several other provisions as it relates to disbursement of those funds.
How about in 312?
Yes, I was just getting to 312. 6213-312 B5 specifically says, I'll read the first part. The commission shall have the power to refuse a license for cause or to suspend or revoke a license where it has been obtained by false representation or by fraudulent act or conduct, or where a licensee in performing or attempting to perform any of the acts mentioned herein is found guilty of, number 5, failing within a reasonable time to account for or remit any monies coming into the licensee's possession which belong to others.
Did you also already read 6213-403?
Yes, 403
6.
Involves the agency relationship and the duty owed to the parties. And this particular section, 6213-403, states a licensee who provides real estate services in a real estate transaction shall owe all parties to such transaction the following duties, in addition to those other duties specified in this chapter or rule. And number 6 says, timely account for trust fund deposits and all other property received from any party to the transaction.
Thank you. And there are rules specifically involving trust fund monies?
Yes, there are.
Okay. Are there rules or procedures that say when you can use someone else's money in an escrow account?
You can never use another person's money in the escrow account. It never belongs to the broker. It belongs to the third party for whom it's being held in trust.
The money held by Mr. Williams in his escrow account never belonged to him.
No, it did not. It belonged to a third party.
Can you tell me again how long he's been licensed?
He was first licensed as an affiliate broker in 1969, so that's approximately 45 and a half years.
And do you happen to know his age?
I believe that he's approximately 74 years old.
And in that whole history, do you show a variety of complaints or problems with Mr. Williams?
He's had a couple of complaints that dealt with earnest money issues through the years. They were, let's see, there was 1/1/23 of 1996. At that time, his license was downgraded from a broker to an affiliate broker, and he was placed on probation for almost a year, and he was reinstated to a broker status on 2/1 of 1997 once he completed a 30-hour office broker management course. And then he received a letter of reprimand on 4/17 of 95 for a delay in return of earnest money. And then he had a couple of E&O complaints for failure to renew his E&O insurance in a timely fashion.
What year were those?
We had one in 01, and then he had one in 11. But those were just, the 01 was, they were both just civil penalties. And then he had another complaint about earnest money, but it was dismissed, and that was in 2002.
So from 1969 to the present, those are the only complaints against him?
They
And the
are.
only issues- And nothing really serious since 1995, is that my understanding?
That would be correct, yes.
Okay. And he doesn't show any other discipline? How about for any of his associates? Or you know of any discipline for any of his associates?
No, I do not.
Thank you. I have nothing further at this time.
Thank you. Questions from board members?
Ms. Franks?
Ms. Maxwell, was this was it a surprise visit, the audit?
Normally, Mr. Kidd, actually, all the auditors made appointments before they arrived at the office so that the individuals would know that they were coming. And there's, a matter of fact, an email that apparently that Johnny Kidd wrote to me, and he indicates that Mr. Williams met him and told him there was a problem with the escrow account.
And did that closing ever take place? Do you know?
The last information we have is the information that was in that letter of November the 1st or the 3rd, where he said it was still open and ongoing.
So we don't know then if that $5,000 was ever funded to the buyers then?
No, the last information that I have is the information that shows that he had put the money in himself, but whether it was ever paid out or not and this contract came to fruition, I don't know the answer to that question.
And did he have a separate escrow account separate from his operations account?
When that $5,000 was initially deposited on 11/20 of 2012, it did go into an escrow account. Those bank balances that were from the fax, the November 1 and 4th, the fax, those apparently were in a business, I believe it said T. Williams business account on those. So that would not have been an escrow account.
That's all.
That says like the one where the balance went to 0, that says T. Williams business, Realty Company business checking. And the other ones likewise say T. Williams Realty Company business checking.
Ms. Hills?
Ms. Maxwell, but, and in looking at the exhibits, and it showed the escrow account. However, am I looking at this correctly, that still all the account numbers remain the same?
Are you starting with the 2012, or is that what you're?
So all the ones that I've been presented are still the same account number. They have a different sort of title as business account, but as it started from the very beginning, it has showed escrow account, and they're still all the same account numbers, correct?
That appears to be correct,
Okay.
yes. Yes, that appears to be correct.
Ms. Maxwell, how do you know how old he is? Is it in everyone's file, or how do you know?
It is in, it's not in everyone's file, but we're now required to get it from everyone, so we've actually sent a letter to those people whose files it's not in, but it does happen to be in his file.
Just out of curiosity, who requires the Real Estate Commission to have that information?
The administration requires that we have the birth dates.
Not pertinent to this case, I presume, but I just was curious about that.
It is asked on the, on the PSI, on the testing information, and it's,
But if someone didn't fill it in, could they still take the test?
well, we're required to get it now, along with your social security number. Huh? And your fingerprints, correct.
Thank you. Any other questions, Ms. Maxwell? I think we're through, Your Honor.
Okay. Any further proof?
Done. Thank you.
Okay. Anything in closing?
I do.
Okay.
We all know the how serious nature of escrow accounts, and it is very serious. And I think you need to consider that when you're making your decision today. You know me, and you know that my initial reaction to everybody is take their license. The things that I think that also should be considered this particular matter, though, are the length of time, the age. I honestly do not know if Mr. Williams had a problem and that's why he's not here. I don't know. And the fact that he did recognize and acknowledge his problem from the beginning, but he took a year to get it back in balance. And you need to consider that factor as well. I'm asking today that you suspend his license, issue him a civil penalty in an appropriate amount, and that license would be then require him to go to education, and he could get his license back upon the payment of the civil penalty. That is what the state is seeking this morning. Thank you. I propose findings of fact.
Okay. That is all of the proof in this matter. I'll have a very short board charge for you because not a lot came up that was challenged or was any other questions. Is everybody okay with me to go forward with that, or does anybody need a break?
Could we take a
Absolutely.
5-7 minute break for the
Absolutely.
audience and board members? Remember, we don't discuss it up here.
Absolutely, yes.
We'll take a
Okay.
7-minute break.
Reel 'em in.
Hate to interrupt you.
Yeah, today, everybody's gotta be butts in the seats.
Sure.
That's okay. Okay. Have we distributed the
Proposed
findings of fact?
Not yet.
No.
Okay.
Robin?
Let's go ahead and distribute the proposed findings, and I'll go ahead and do a short board charge while we're doing that. The commission has now heard all of the proof in the matter of Thomas Williams. You can now conduct open deliberations and make your findings of fact and reach conclusions of law based on those findings of fact. Let's see. You are the exclusive judges of facts in this case. You are the exclusive judges of the law and your rules, specifically your statutes and regulations and their application to this case. The state has charged the respondent with certain violations of your statutes and rules. For each of these charges, you can reach a determination of guilt or innocence, and in your findings of fact, give the underlying facts that support that decision. Please make your findings of fact based solely on the evidence that was presented at this hearing. There is a charge about the difference between direct and circumstantial evidence, but I don't believe we even need to go into that. The evidence in this case consisted of testimony and documentation. Okay. The law does not require you to accept all the evidence that has been admitted, even though it is all legally competent. In determining what evidence you accept, you must make your own evaluation of testimony given by the witness and determine the degree of weight you choose to give that testimony. Last charge that's applicable is, although you may consider only the evidence presented during the hearing in making this decision, this does not mean you are required to set aside your own business knowledge of real estate and things like that. The experience that you bring to this procedure is also appropriate in making your decision. Before you consider any disciplinary action, first determine whether the state has met its burden of proving the charges by a preponderance of the evidence, which is just the more than 50%. If the scales go just a little bit this way, then the state has made their proof. If the scales are even, then they haven't, because it has to be a preponderance. Once you reach your findings of fact and conclusions, your policy statement is a reason which explains why your particular disciplinary action you choose, if any, is correct, given the wide realm of cases you hear and the various options under the law that you have. If there are no questions, I'll now turn this hearing over to our chairman to preside over the deliberations, after which you will make your findings of fact, reach conclusions of law, and give your policy statement for your decision. Okay.
Thank you, Your Honor. We will look forward to your guidance as we work through this. For instance, the notice of hearing and charges listed 3 different counts. Do the findings of fact have to be particular to those counts, or can they just be findings of fact based on the testimony we've heard today?
I believe they do not have to be particular to the counts, but it looks like they are, though. Isn't that correct? I think if you look at the findings, I think it does cover each of the statutes that the state has mentioned in their notice of charges. On the notice of charges, the state has listed, well, 6 statutes. Well, I'm sorry, 6 segments of similar statutes and then 2 of specific rules. Okay? Does that answer the question?
If you find our findings of fact are out of order, would you let us know?
Absolutely.
Okay,
yes,
thank
yes.
you. Just I want to make sure we stay in line. Mr. Chara?
Mr. Chairman,
Ms. Franks, I'm sorry.
May I ask, can all the findings of facts be done in one motion, or do we need to individually do them?
Never seen them all done in one motion.
Okay.
I believe they go through them individually.
There may be additional findings of fact as well. All right, Mr. Chara.
Mr. Chair, I would like to make a motion that we find the following findings of facts. Number 1, respondent was at all times pertinent hereto a licensee with the Tennessee Real Estate Commission license number 54040.
Second.
You so moved, right?
I so moved.
Okay, we have a motion by Commissioner DeChara, seconded by Commissioner Franks regarding that proposed finding of fact. Is there discussion? Hearing none, let's vote. Those in favor of the motion vote aye.
Aye.
Opposed, no. That motion passes.
I move that number 2, respondent was the principal broker of T. Williams Realty Company, a licensed real estate firm. I so move.
Second.
Motion by Commissioner DeChara, seconded by Commissioner Franks. Is there discussion on the motion? Hearing none, let's vote. Those in favor of the motion vote aye.
Aye.
Those opposed, no. That finding of fact is adopted.
I move that on April 12, 2013, former state auditor Johnny Kidd completed an audit of respondent's firm. I so move.
Second.
We have a motion by Commissioner DeChara, seconded by Commissioner Franks. You've heard the motion. Is there discussion? Let's vote. Those in favor of the motion vote aye.
Aye.
Those opposed, no. The motion passes unanimously.
I move that in this audit, Mr. Kidd observed and noted that the firm's escrow account indicated it should have an earnest money deposit of $5,000. I so move.
Second.
Motion by Commissioner DeChara, seconded by Commissioner Franks, that that particular finding of fact be adopted. Is there discussion? Hearing none, let's vote. Those in favor of the motion vote aye.
Aye.
Those opposed, no. That motion passes unanimously.
I move that the escrow account only had an actual balance of $1,416.57 as of the last bank statement, therefore indicating a shortage of $3,583.43. I so move.
Second.
Motion by Commissioner DeChara, seconded by Commissioner Franks, is to adopt that particular finding of fact that she just read into the record. Is there discussion? Let's vote. Those in favor of the motion vote aye.
Aye.
Those opposed, no. That motion passes unanimously.
I move that based on the audit, this complaint was opened against respondent as the principal broker in charge of the escrow account. I so move.
Second.
Motion by Commissioner DeChara, seconded by Commissioner Franks, that that particular finding of fact be adopted by this commission. Is there discussion? Let's vote. Those in favor of the motion vote aye.
Aye.
Those opposed, no. That motion passes unanimously.
I move that respondent admitted that the escrow shortage stating it was due to respondent using the monies in the account for urgent obligations. Respondent further stated he believed that future income would cover that shortage, but this did not occur. I so move.
Second.
You've heard the motion. Is there discussion? Mr. Chara, it seemed to me that there was testimony that at some point that account was replenished, so I might take issue with.
We're going to address that in the further findings of fact.
Well, that particular finding of fact would say that it did not occur when in fact it did occur at some point. I'm just.
Says not. Oh. But
It's an open discussion period
Ain't
right
got
here,
there
so.
yet.
If
Money got put back
At a later date.
at a later
It
date.
ju-
You know, two
Would-
different checks came in.
All right, so how about we change it to the income would cover that shortage?
Stop
but-
there.
Well, but this did not occur when he indicated it would. Because he was 4 months later than what he said he would do that.
Personally, I would be happy if there was a period after the word shortage that said he believed the future income would cover that shortage. I think that is a finding of fact. I don't know particularly when that was covered. I don't know when the money was replenished.
In November. Okay.
Well, don't okay it if you don't like what I'm talking about. Just go ahead and tell me. But we do need to get this finding of fact into the record in some form.
I think the chairman's correct in that there should be a period there.
Is that all right? Would you like to amend your motion to that? That the finding of fact. that
The
you're-
finding of fact would be respondent admitted that the escrow shortage stating it was due to respondent using the monies in the account for urgent obligations. Respondent further states he believed that future income would cover that shortage.
So moved.
Just as a change-up, I'm going to allow Mr. Alexander to make that particular motion that you just read in. That particular finding of fact is a motion made by Commissioner Alexander, seconded by Commissioner Hills. All right, now we're ready to vote, or is there further discussion on this particular finding of fact?
Call for the question.
All right, the question has been called for. Let's vote. Those in favor of the motion vote aye.
Aye.
Those opposed, no. That motion passes. Thank you. Mr. Chara.
I move that respondent stated the account would be fully funded by June 4th, 2013. So moved.
Second.
All right, you've heard the motion. Is there discussion on that particular motion? Let's vote. Those in favor of the motion vote aye.
Aye.
Those opposed, no. That motion passes.
I move that in a supplement response of respondent dated September 3rd, 2013, respondent stated that the escrow account shortage was shorter now than it was at the time of the audit. This additional response included a bank document indicating the escrow account had a zero balance. So moved.
Second.
Motion by Commissioner DeChara, seconded by Commissioner Franks. You've heard the proposed finding of fact. Is there discussion? Let's vote. Those in favor of the motion vote aye.
Aye.
Those opposed, no. That motion passes unanimously.
I move that respondent replenish this account by depositing $3,000 on October 25th, 2013, and had a balance of $5,036.57 as of November 1st, 2013. I so move.
Second.
You've heard the motion made by Commissioner DeChara, seconded by Commissioner Franks. Is there discussion on that proposed finding of fact? All right, let's vote. Those in favor of the motion say aye.
Aye.
Those opposed, no. The motion passes unanimously. Do you have additional findings of fact?
I do not.
Does any other commissioner have additional findings of fact? All right, at this point then I will rule that that portion of our discussion regarding findings of facts has closed, and now we will get to the conclusions of law portion of our deliberations. And I'll yield to Mr. Chara if you would like to continue as.
I move that we find the following conclusions of law. Respondents' acts and conducts as described in the foregoing findings of fact constitute a violation of Tennessee Code Annotated 62-13-312B-5, wherein it states in pertinent parts as follows. B, the Commission shall have the power to refuse a license for cause or to suspend or revoke a license where it has been obtained by false representation or by fraudulent acts or conduct, or where a licensee in performing or attempting to perform any of the acts mentioned herein is found guilty of. Number 5, failing within a reasonable time to account for or to remit any monies coming into the licensee's possession that belong to others. I so move.
Second.
All right, Mr. Chara has made a motion regarding the conclusion of law that she has just read into the record. Ms. Franks has seconded that. Is there discussion amongst the commissioner members before we vote? I sense there is not. Let's vote. Those in favor of the motion vote aye.
Aye.
Those opposed, no. The motion passes unanimously. Mr. Chara.
I move that respondents' acts and conduct as outlined in the above allegations of fact are a violation of Tennessee Code Annotated 62-13-312B-14, which states, B, the Commission shall have the power to refuse a license for cause or to suspend or revoke a license where it has been obtained by false representation or by fraudulent act or conduct, or where a licensee in performing or attempting to perform any of the acts mentioned herein is found guilty of. Number 14, violating any provision of this chapter, any rule duly promulgated and adopted under this chapter, or the terms of any lawful order entered by the Commission. I so move.
Second.
Ms. DeChara has made a motion that conclusion of law be accepted by the Commission. Ms. Franks has seconded. Is there discussion? All right, let's vote. Those in favor of Mr. Chara's motion, please vote aye.
Aye.
Those opposed, no. That motion passes unanimously. Mr. Chara.
I move that respondents' acts and conduct as described in the above allegation of fact constitute a violation of Tennessee Code Annotated 62-13-403, which states a licensee who provides real estate services in a real estate transaction shall owe all parties to the transaction the following duties except as provided by 62-13-405, in addition to other duties specifically set forth in this chapter or the rules of the Commission. Number 6, timely account for trust fund deposits and all other property received from any party to the transaction. I so move.
Second.
All right, you've heard Mr. Chara's motion that conclusion of law be adopted by the Commission. Ms. Franks has properly seconded. Is there discussion? Let's vote. Those in favor of the motion, vote aye.
Aye.
Those opposed, no. That motion passes unanimously.
I move that each of the above violation constitute grounds for the assessment of investigatory and hearing costs pursuant to Tennessee Code Annotated 56-1-311 and Tennessee Compilation Rules and Regulations.
Close enough.
0780-5-11-.01. I so move.
Second.
Motion by Commissioner DeChara regarding the fourth conclusion of law, seconded by Ms. Franks. Discussion. Let's vote. Those in favor of the motion, vote aye.
Aye.
Those opposed, no. That motion passes unanimously. Ms. DeChara, any other conclusions of law you'd like to reference this morning?
I do not have any other conclusions of law.
Do other members of the commission have additional conclusions of law?
No.
All right, at this time, and Your Honor, you may direct us on this, the penalty phase, is that the right terminology for what we're about to do next?
Yes, the assessment of a civil penalty.
That's what I meant.
For the conclusions that, that you found for the violations that you find. And you can discuss that openly as well.
Okay, so we're going to, amongst us, determine what penalties to assess at this point, and the floor is open to a motion from any member of commission at this point.
I'd like to know what the range is in that penalty.
$1,000, $250 to $1,000.
If the court, may I address that? It is up to $1,000 per day of occurrence.
Mr. Chair,
Mr. Alexander.
I have no motion. I certainly have I guess we need a motion, though, before we discuss it. Is that what?
Well,
we're
that's
looking
how I'd like to operate, but in this particular case, if you'd like to talk about how you see this case first, I'll let that happen at this point.
Well, I see this case as being, by the evidence that's been given us today, that this is kind of a habitual thing for this, for Mr. Williams. He, record has indicated that he has had discrepancies in his escrow account before. If you look at his checking account, you see that he apparently is not very active in the business. There's not much funds coming or going. I think he was honest in telling you what he was doing. That the letters that he has sent to the commission indicated that he didn't have the money. He replenished the money. He's been suspended before. His license have been downgraded. There's no question that the golden rule is you don't mess with the escrow account. That's my.
Thank you for your comments. And you're welcome to add more as we go through this. Anyone else like to just talk out loud about what you're thinking at this point?
Well, the fact that he could not appear today because of financial burden that it would cause, which I believe was the statement that he made, would kind of indicate to me that the civil penalty is not going to be paid regardless of what kind of penalty we put on him. I don't think that should eliminate him paying it by any means, but I think whatever we make a motion to do, that his license probably should be suspended until that civil penalty is paid.
And I'd like to say that he obviously has an attorney because the judge spoke with the attorney this morning. We know that attorney's fees are very expensive. So I'm not convinced that it's a hardship as far as the money for him. I'd like to make a motion.
Thank you. You're welcome to.
I'd like to make a motion that we give a civil penalty of $1,000 for each of the 4 violations, making it a total of $4,000. And I make a motion that we suspend his license until this penalty is paid. And the court cost.
I'll second that motion.
Okay, let me state the motion and see, ladies, if I have this correctly. Ms. Franks' motion is to assess a civil penalty of $1,000 for each of the 4 counts listed in the notice of hearing and charges. Is that right? There are only 3 charges in there.
Well, I made them according to the conclusions of law.
And the fourth one is basically the conclusion that you can assess the penalty and the investigatory
Okay, so that
cost.
would be
it's actually 3.
That would be. I'm in my motion then to the 3 violations with a total of $3,000.
So let me continue to state this motion as I understand it. Ms. Frank's motion is to assess a civil penalty of $3,000, $1,000 for each of 3 counts, suspend this licensee's license until that civil penalty is paid, and assess all court costs and hearing costs.
Your Honor, if I could just for the moment, the conclusions of law do have 3 violations, but one of the violations is relating back to number 2, and their civil penalties are for up to $1,000 for a violation of number 14. There is no separate money for a violation of 403, that it would be included as a violation of number 2 and number 14.
Us at all. Do you understand what Ms.
So there's just 2 violations.
Well, because what you're saying is 3 is
Under
like
their-
included.
Right, under
in
the
2.
law, Real Estate Commission laws, anything not listed in 312 can be a violation under number 14. Anything listed not in there, for instance, another section of the code or rule, would be included in 14, subdivision 14 of 312. And that is $1,000. Both of those are $1,000 per occurrence or per day of the occurrence.
So we could issue a penalty of more than the $2,000 based on the amount of time he went without the escrow account being funded.
Correct, because it's per
day of the violation. That's correct.
Okay, so I would like to re-amend my motion and go back to the original motion of $4,000 for the violations.
Okay, is there a second to the motion as stated now?
I think you can.
So let's see, is there a second?
If you can do it per day.
Well, I think you have to determine.
Chair rules, there's no second, so let's get that off the table just for a minute.
Okay.
Now we'll get to discussion. If please, the chair, just for 1 second, would you specifically reference the 2 charges that we can find by number, so I know
Can I do that, Your
Yes,
Honor?
absolutely.
Number 1 is a violation of 312B5. That's the 1 charge. Number 2 is a violation of B14. And the acts included in B14 are those enumerated in number 3 in the conclusion of law.
Thank you very much.
And if the court please, it is up to $1,000 per day of violation, and it would seem to me that if you are charging more than $1,000, you would have to make the determination for how many days you are charging.
Ms. Hills.
And that's my question. Thank you very much. So in calculating the days, I would start for me to calculate the days, Judge Wilson, I would start from the date of the audit to the date it was made whole?
If you were going to calculate it by days and you enumerated the days, you could do it that way. Not sure anyone was suggesting that, though. Although it's whatever you want to do.
I really feel it should be stiff, but I'm not for going $1,000 for every day because, I mean, that's not collectible probably anyhow. Huh?
You can do $5 a day. I mean, you
You
can
could.
determine any.
And that's why I said 4,000 total. You can divide that extra 2,000 by however many days it was.
Perhaps if it would be appropriate that I read into the record the penalty phase for these violations, the minimum and the maximum. For each violation of B5, it is a minimum of $300 to a maximum of $1,000. For violations of B14, it's a minimum of $50 to a maximum of $1,000. Each day of a continued violation may constitute a separate violation. That is, you can charge for per day. And if the court please, let me read the rest. This is the rule, let me read it in it. This is your rule, 1260-02-32. Each day, that was number 3, each day is a continued violation. And number 4, in determining the amount of civil penalty, the commission may consider such factors as the following: whether the amount imposed would be a substantial economic detriment to the violation, the circumstances leading to the violation, the severity of the violation and the risk of harm to the public, the economic benefits gained by the violator as a result of noncompliance, and finally, the interest of the public.
Thank you, Ms. Ryan. At this point, there's no motion in front of this commission, and Chair is happy to entertain a motion at this point. I don't think we ever got a second to that motion.
We did have an original motion with the second.
Well, I didn't mean to let a second motion come in on top of it then. Do you want to, since the chair's rule and the floor is open at this point, do you want to restate any motion or make a motion at your?
I'm trying to figure what's the best way to state it. $200 days.
Well, I know, but you could.
Okay, okay. I'd like to make a motion that on the 1312B5, is it 62 before that? Yeah. That we assess a penalty of $1,000. As to 62-13-312B14, I would like to make a penalty there of $1,000. And on the 02, what was the 02-32 that she just said?
It has to be, those are the only two.
Right, I believe that was the part about considering the substantial detriment, the severity, the risk of harm to the public, and the result of.
And with the daily number.
Either one of those two, perhaps, depending on your motion.
Okay, and I find that we give a civil penalty of $100 a day for 200 days in violation.
Which particular?
Done the math.
On B14.
That's $20,000.
That's 20,000.
What's the minimum?
Correct me if I'm wrong, the
trying
per
to get
day
$2,000.
is not mandatory. You can give one penalty. It doesn't have to be per day.
Yeah, if the penalty is in excess of $1,000, they would have to find another day's violation.
That's what I'm trying to get at.
So on the B5 for 1,000, you're within the range of 300 to 1,000, and on B14, 50 to 1,000. So you're within the range on 1,000 for each.
And then for the daily additional,
It would.
You wouldn't have to do a daily, correct?
That's
at that point.
May I address if your purpose is to attempt to have more than $1,000, you don't have to do all the days either. Am I correct, Your Honor? They could just say, for 3 days we're going to give 3,000, or for 1 day we're going to give 1,000.
okay. So for 2 days, $1,000 each, making the penalty, the civil penalty, a total of $4,000 plus court cost.
That's 5 now.
What?
You got 2 and 3. It's 5. 3. Because you got 1,000 on two. You already your motion that you started to making that we haven't completed is you're going to find him 2,000 for or 1,000 on each count, and then if you add 3 days, $1,000 a day for 3 days. 3 and 2 is 5.
2 days.
Yeah, let me see if I can state the
2
motion.
days.
Let's see if
for 1,000 each.
All right, so the motion by Commissioner Franks that I'll entertain a second in a moment, I think reads like this. Her motion related to 62-13-312B5 is a $1,000 civil penalty. Her motion related to 62-13-312B14 is a $1,000 civil penalty times 2 days. In addition, she's also moving that all court costs and hearing costs be assessed against the respondent, and finally, that his license be suspended until these costs are paid.
Second that motion.
Is
And
that
that
your
would be a
motion?
total of $3,000
That'd be
plus court
three.
costs.
Is that your motion, Ms. Franks? Did I get it correctly?
3,000 will be my total.
All right, I have a second by Commissioner Alexander to that motion. Now, discussion on the motion. Is everyone clear on the motion that gets a vote?
Sorry.
All right.
Call for the question.
Let's vote. Is there any objection to the call? I don't hear one. Let's vote. All in favor of the motion, vote aye.
Aye.
Those opposed, no. That motion passes unanimously. At this point, Your Honor, we're to the policy statement phase of this hearing. And frankly, we have a member absent who typically helps us with this policy statement. And I understand, I recall from his previous eloquent policy statements that it had to do with what's in the best interest of the citizens of the state of Tennessee.
That's correct. In other times that we've done this, we've had to protect the safety and welfare and the best interest of citizens of the state of Tennessee. Can be a policy reason. Would you suggest anything else?
And that perhaps we want to consider the responsibility of a licensee in their role as a licensee and handling money, and therefore that is their responsibility as well to govern other licensees so that they handle money correctly for protection of the public.
Take the motion that we just passed over again.
Yes, sir. The one during the penalty phase, the motion that passed called for a $1,000 fine for violation of 6213-312B5 and a $2,000 fine, $1,000 a day for 2 days for violation of 6213-312B14, payment of all court costs and processing costs, and a suspension of the licensee's license until these civil penalties and costs have been paid in full. That's what we've had.
What I thought, but I want to be sure that it's in the record about the suspension too.
Yeah, that's there. So, does anyone up here on this commission like to take a run at a policy statement? I'm sure it could be less wordy than what I just heard an attorney say, so I just wanted to check.
Thank you.
Well, we'll take a stab at this and see what we come up with. Our policy statement would be that this decision has been made based on the safety and best interest of the public, and that it is the responsibility of the licensee to handle money correctly when it belongs to someone else. Will that work?
That works for me.
We need more?
The role of the commission is to
The role of the commission
To uphold the
these.
statutes and rules of the.
role of the commission is to uphold these findings.
Those standards, at
These
least.
standards.
Yeah.
Second.
Okay, I have a policy statement that's been read into the record and properly seconded by
the
Commissioner
laws, and
Franks.
the laws,
Statutes.
statutes and
Laws.
rules, right?
And rules. We're all realtors, not lawyers. Our lawyers stayed home today.
Okay, is there discussion on the policies?
Robin, can you read that back to us?
I'd rather have the
Oh,
court. I'd rather
she
have
can.
I'd rather have the court.
There we go.
report.
Somebody needs to
She
read
will.
it back to us to make sure we got it all in there.
Okay, it is the decision of the commission to uphold the safety and best interest of the public, and it is the responsibility of a licensee to handle money correctly when it is handled by or when it belongs to somebody else, and it is the role of the commission to uphold the statute and rules.
That's the motion in front of the commission. Is there discussion on the motion? All right, let's vote. Those in favor of that motion, vote aye.
Aye.
Those opposed, no. The motion passes unanimously. Your Honor, I think we've completed our charge here. I'll turn it back to you at this point.
Thank you, and I would just like to say that completes the hearing of Mr. Williams. I'd like to thank every board member for your time and service to the state of Tennessee, and the attorneys and the witnesses and everybody else involved with this hearing today. If there's nothing further, we're adjourned.
Now, the court's adjourned, not us just yet, okay? So, thank you.
Are you
Your
going to
Honor.
discuss other business as well with?
Just very briefly. but
Okay.
You guys are Free to go, and we appreciate your sense of humor. Sometimes we have judges
Thank
who
you,
don't have the
Judge.
same sense of humor.
Thank you. Thank you very much.
It's kind of like the blind leading the blind over here this morning.
I'd like to tell all the licensees in the audience that you make sure you sign out. We don't want you coming back. I hope you found this session yesterday and today interesting and helpful, and that you can carry some messages back to your office that this commission tries to take their charge, our charge, seriously. We'd appreciate that. Let's see. So let me start. Wendell, do you have anything you'd like to just say as we close this session up?
Well, I would again ask you to have Commissioner Bloom in your thoughts. Also, those of you that are here, you heard us discussing maybe, and you heard in this complaint about Mr. House. Mr. House was a loyal, dedicated employee for the state for how many years, Eve, you remember?
He worked for the state for 20 some odd years, like 25 years or something.
This morning that we've lost him, we'd ask you to keep him in your thoughts. Yesterday, we lost a former commissioner of this body, Gary Cunningham, who was a very dedicated commissioner that I had the pleasure of serving with for several years. And everybody have a nice Christmas and a happy holiday. Thank you.
Ms. Hills?
The only thing I would remind everyone is to be sure you get your E&O insurance taken care of before the end of the year.
Ms. Franks?
I would like to thank everybody who came, and hopefully you've learned from this what's important to the commission and really how important your job is, as you are the ones who are representing the public, and that you take your job very seriously. We don't want anybody to end up here again, but we appreciate every one of you, and we are honored to serve the state of Tennessee in this capacity. Like to thank Eve Maxwell for the amount of work she does on behalf of the state, and also to keep these families that are close to us in your prayers. And I'd like to wish you a Merry Christmas also.
Mr. Chara?
Well, I'd like to thank all the staff for the hard work that you do, because sometimes you may feel underappreciated, but we do appreciate it. And Kimberly, thank you so much for making us feel special. Y'all should see our little room back here, what she did for us. She goes out of her way to make it very festive for us and comfortable, and we appreciate that. Thank you, Judge, for being here today. And I hope everyone has a very Merry Christmas, and come back and visit us for 8 hours of continuing education, but don't come back to visit us because you have a penalty.
Thank you, Mr. Chara. Just a special note of thanks to Jenica Smith and Keeling Baird in the back for their work yesterday on that legal report. I'm telling you, I thought about it again last night, and the bad news is I complimented them privately yesterday, and they told me there are a whole bunch more of those coming our way, and I'm going, golly. If you need mental help anywhere along the way, make sure there's state help somewhere around that can help you. Finally, if you're heading, what do you drive, Diane? What kind of car is it?
Right, I'm in a Toyota today.
What kind of Toyota?
Avalon.
If you see a Toyota, if you're going east and you see a Toyota Avalon coming up on you in a hurry, get the heck out of the way. She can get to Johnson City faster than most small jets, as I understand it. So please get out of the way.
It's only if I have a tailwind.
All right, friends, thanks for coming. I hope you have a great holiday, and please be safe going home. Sign out.
Don't forget to sign out.